ಕೋಟಲ್ ನಂಬರ್ 25 ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
Lords, petitioner wants to withdraw the petition, my lords. Office has raised objection regarding maintainability of the petition.
Yes.
Let it be listed tomorrow, my lords, please. My lords, one more petition. Matter pertaining to PC Act, my lords, petitioner has been in custody for the past 1 month.
File the memo, will be listed.
Kindly have it tomorrow, my lords, please.
On memo date declared on 14th, but not listed, can they have?
Madam,
tomorrow?
ಅದೊಂದು ನಾಳೆ
File it,
ಇಷ್ಟ
file it.
Tomorrow.
Be listed. Yes, it will be listed, sir.
Any adjournment? List 1, page 1, serial number 1 to 5.
Yaru. Serial number 3. Yes. Yes, for that. Why the petitioner is not interested? In January, the petition was filed. Till date, you are seeking time. I'll dismiss this leisurely. You can file a separate petition. I'll dismiss this. Counsel for the petitioner prays for time. The petition was filed on 25/1/2024. Till date, the petitioner is not ready to address the argument. I do not find any reason to adjourn the matter, however, to offer final opportunity. Finally, as a last chance. Next.
Serial number 2, my lord.
Two also same, awaiting report,
Notice served.
served,
Served, my lord. Only 2 days or 3 days?
two nulli, learned HCCP submission. The notice to respondent number 2 is already served. Submission is placed on record. Counsel for the petitioner prays for time. Next.
Page 2, serial number 6 to 13. Page 3, serial number 14 to 24.
Note 15.
Serial number 15, yes, prays for time. Next.
Serial number 23. 14, I withdraw the, madam.
20,
14, I withdraw the petition. This is infectious.
14.
Yes.
Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Memo is accepted, petition dismissed as withdrawn. Next.
Serial number 23, my lord.
23, prays for time. Prays for time. Next.
My lord, serial number 18, my lord. Kindly
18.
2 weeks time, my lord.
Prays for time. Next.
Page
Much
4,
obliged.
serial number 25 to 33.
My lord, serial number 30, my lords.
30,
Please, my lords, I pray for a week's time, my lord.
prays for time. Next.
Page 5, serial number 34 to 42.
Serial number 33. Only maybe password.
Serial number? Yes, next.
Page 6, serial number 43 and 44.
Yes.
My lord, list number 2, serial number 13.
Comply with the.
Week's time.
That will be given. Next.
List 1, serial number 1, Gautam M.
Served. Counsel, learned HCCP submits the notice to respondent number 2 is already served. Petition is placed on record. Yes.
Kindly pass on.
I have filed wakalat for respondent number 2.
Respondent number 2. He is ready. Pass over.
Serial number 2 and
Submission is placed on record. Adadmele so and so. Submits that he has filed wakalat for respondent number 2. Office to show his name in the cause list. Yes, pass over. Next.
serial number 2 and 3 adjourned. 4, Natrajuti.
Yes.
The offences alleged 307, my lord. Sole accused, and he was arrested on 21/3/2021, my lord.
When?
21/3/2021, my lord.
21.
Please, my lord.
Is this the first petition?
No, my lord, earlier it was filed, my lord, it was dismissed for non-prosecution.
Okay. On merits, no.
Please, my
Yes.
lord. Ashim may kindly see. It's the allegation of
Okay,
the,
even the evidence has begun.
my lord, only 2 witnesses are examined, my lord.
Now, how many witnesses are there?
Totally, my lord,
Totally, my lord.
Only 11
11
witnesses.
witnesses, 11 witnesses, sir.
Huh.
Please.
How many are examined?
Totally 3 are examined, my lord. Out of 3, my lord, 2, my lord, not supported the prosecution.
Who are they?
My lord, PW1 and PW2, my lord.
Who are they? Who are
CW3 and CW4.
CW 3 and 4?
Please, my lord.
They are the
CW
Mansar witnesses.
Please, my lord. CW3 is, my lord, who translated the complaint, my lord.
Hmm.
And 4, my lord, who is the merger, my lord.
Injured is CW 1?
Please, my lord.
No, CW 2.
Both are injured, my lord. 1 and 2 both.
They are yet to be examined.
Lord, the since from 2020.
Maybe, sir, you insist already the trial has begun.
Please, my lord.
The injured are yet to be examined
Almost, my lord, he is.
simply
my lord,
because the Mansar witnesses have turned
Lordship, may
hostile.
kindly see the doctor with examination for a moment. For a moment, my lord.
Not 7.
I request you, Lordship, to, my lord, see the examination, cross-examination of the doctor.
Come to the wound certificate.
Please.
7 injuries are
Please, my lord.
sustained,
Please,
and the other one sustained 5 injuries,
please, my lord.
grievous in nature.
Please, my lord.
Hmm.
Lordship, may kindly see, my lord, page number 43 for a moment. I request your Lordship to see.
43.
Please, cross-examination.
Ah.
Lordship, may kindly see. May I read, my lord?
Yes, why you are drawing
Lord.
my attention?
My lord, it is not, my lord, 307.
Hmm.
In fact, my lord, both are, my lord, voluntary, my lord, visit the
is
hospital.
scene number 30 ಅಂತ ಹೋಗ್ಬಿಟ್ರೆ ಸುಮ್ನೆ ಅದು
Voluntary, my lord,
date
they are admitted to the hospital.
Huh.
None of the, my lord, or the complainant or somebody else, my lord, have taken them.
Is it the requirement?
They were, my lord, capable.
Should sustain injury.
They were, my lord, capable, my lord, of, my lord, visiting the hospital. That itself is shows that, my lord, injuries, my lord, not to the extent, my lord,
That cannot be the
causing the
conclusion.
death, my lord.
That may be your defense,
Please.
but that cannot be the conclusion that could be arrived at. No.
And yes, my lord, already spent, my lord, 3 years,
Tagol.
my lord, one sound submission, my lord.
Yes, I understood your point, but injured are not yet examined.
My lord.
No.
They are not turned up, my lord. They are not attending the court, my lord, since from 2002, my lord, to 22.
You
My lord,
take up
2.5
the
years, my
matter.
lord.
HCGP, please, you direct your counterpart before the trial.
And your lordship may kindly see for a moment, my lord, CW 2 and 3 examination, your lordship.
Sir, I have seen everything.
Please.
I'm not inclined to grant any relief.
My lord, almost, my lord, 2.5 years, my lord, over.
So for the petitioner submission, the petitioner, being the sole accused, is seeking grant of bail. He was apprehended on 21/3/2021, and since then he is in judicial custody. CW. It is stated that the petitioner has assaulted CW 1 and 2 with an intention to cause her death. The wound certificate discloses that both have sustained multiple stab and incised wounds, which are grievous in nature. The prosecution has already examined 3 witnesses, even though it is stated that 2 of them have turned hostile, they are the Mansar witnesses. CW 1 and 2 are the injured eyewitnesses, yet to be examined. Considering the nature and seriousness of the offense, I am of the opinion that the petitioner is not entitled for any relief at this stage. Accordingly, I answer the point. Yes, dismissed.
One submission.
Hmm.
I may agree, my lord, liberty may be granted to more application after examination of CW 1 and 2.
At this stage, learned counsel for the petitioner prays for reserving liberty to file similar petition after examination of the material witnesses.
Serial number 5, Bhadravati Siddeshwara.
Liberty reserved as prayed for, if he is advised to do so. But before the trial court. Yes.
Offense is 302-201, my lord. He was arrested on 11/7/2021, my lord.
When?
11/7/2021, my lord. There was a first petition,
7/21.
21, my lord. Initially,
Only accused?
so 2 accused, my lord. He is A1, my lord. A2 demised in jail, my lord, while she was in judicial custody. My lord, initially petition was filed and detailed order was passed, my lord, dismissing the petition with the observation that, my lord, that I need to be given, I has given a liberty to approach this court if a FSL report is filed and or else as soon for completion of trial as soon as possible, my lord.
Kodi.
Till today, FSL report has not yet been filed, my lord. Only 5 witnesses
Charge
have
sheet
been,
is filed.
charge sheet has filed, my lord.
What is the stage before the trial court?
My lord, witnesses have been examined, my lord.
SC
Five
number?
witness- My lord, SC number 195 of 2021, my lord.
195 of 2021.
Yes, my lord.
What is the stage?
My lord, trial is going on, my lord.
How many witnesses are?
Five witnesses have been examined, my lord.
PWs 1 to 5.
Yes, my lord.
In all, how many witnesses?
My lord, 33 witnesses, my lord.
How much?
33, my lord, 33.
33.
No FSL report has been, my lord, this is
For
circumstantial.
the prosecution, let them secure it. ಏನಿದೆ? What is the liberty grant?
Yes, my lord, at last para, my lord.
This is the petitioner da?
Yes, my lord, same petitioners, my lord.
ಹಾಗಾದ್ರೆ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಲ್ಲ. ಹ? ನೋಡಿ,
At the time also, charge sheet was filed, my lord.
This petition is to be placed before the same coordinate bench.
Yes, my lord, but
I will order, it will be
Please,
placed before.
a date may be given, my lord, at least.
Sorry, one counsel, learned counsel to the petitioner submission. The petitioner had filed a criminal petition under Karnataka. And the same was came to be dismissed today, order dated so and so. Office is directed to list the petition before the same coordinate appropriate bench. Yes,
Within a week, my lord, at least.
yes, that will be done, sir. Immediately it will be listed.
Obliging.
Serial number 6, Sri Parameshwarappa.
Yes.
Yes. Who is the petitioner?
The
Accused
petition
number-
is accused number 1, madam.
In all, how many accused?
4 accused.
What about 2 to 4?
2 to 4 are already on bail. 2 and 3 are the parents of accused number 1. 4 is the marriage negotiator.
He is the husband?
The accused number 1, whose engagement, marriage engagement was solemnized with the victim. The alleged offences are under section 4617 of POCSO and 376(2) of Indian Penal Code.
Age of the victim?
At the time of offence, she was 16 years, 2 months.
You fully supported 164.
164, page number
Yes, fully supported. She has
supported, but
stated in
during the
detail.
class examination, she specifically admitted that.
164 I am saying. She is examined already.
She is examined also before.
PWs,
PW1.
only one witness is examined.
No, out of 28 witnesses, 14 have been examined,
PWs 1 to 14,
1 to 14,
out of 28 witnesses.
out of 20.
Huh.
Even during-
Victim has supported.
Supported the case of prosecution, but my lord, the entire incident she was telling that she admitted during the cross-examination, the presence of her brothers in the house.
Maybe, sir, appreciation of evidence after the evidence is the job of the trial court, not this court.
My lord,
I am not deciding the matter. I am not either convicting or acquitting. Appreciation of evidence is the prerogative of the trial court.
from the last date of
I cannot say it is the omission, it is the improvement. No,
the last
that
date
is
of
not the job of this court.
my lord, one subject, the last date of the incident on 20th/7/2021. There is 72 days of delay in lodging the complaint. Only when the accused allegedly refused to marry her.
Hmm.
And as per the case of the complaint,
Maybe you have not sought for quashing.
approached the,
All these grounds could be raised there. 482, not before this court. That too, when the victim is already examined, she supported the case. No,
as per,
before the trial.
but as per the version of the CW1.
Maybe I am not considering any of that thing. That is not the job. I will be exceeding my limits if I do that.
He's in
Law
custody,
does not permit it.
but he's in custody for nearly 3
Maybe
years.
you insist the court to expedite the trial. That is the court to convince. Prima facie, the witnesses have supported the case. And the allegations are very serious. No. Nobody.
From the allegations itself, my lord, it shows that only when he refused to marry her,
So that cannot be
complaint lodged
concluded,
after.
sir. I cannot give any such finding. I am not supposed to give. Trial has already begun. It is the privilege given to the trial court. If I give such conclusion, what remains with the trial court? Is it not?
Yes, sir.
Then
We don't want one.
petitioner accused number 1 is before this court.
I may be permitted to withdraw the
Withdrawing it,
withdrawing it and the direction to conclude the trial.
we
There
need
list.
our markup. So I will direct the PPS. Withdrawing,
Yes, sir.
counsel for the petitioner after addressing the argument at length. Permission to withdraw the petition
2-3 months.
and request for issuance of that to the trial court. To conclude the trial expeditiously. Permission is placed on record, petition dismissed as withdrawn. The trial court is directed to expedite the matter. And to dispose of the same at the earliest. At the earliest, yes.
Serial number 7, Nanjagunda Gowda MR.
My lord, the direction given for concluding. the-
Expeditious.
Yes.
We have issued NOC to petition number 4, my lord. Unfortunately, I have not taken a signature on him receiving the entire case file.
Argue the matter.
May I
Argue
request, my
the
lord, it's a week's time, my lord, since the entire brief is with him, my lord.
Huh?
Since the entire case file is with him. He has already,
With whom?
with the petitioners. Because he has come on 5th of May and he has taken the entire case file along with NOC.
Then file a memo.
Please, my lord. I
Pass
shall file a
over.
memo, please.
Serial number 8, VB Sidramaya, N
Yes,
Somshekar.
my lord. Lord, I have filed a memo for withdrawal, my lord.
Eight. Counsel for the petitioner filed a memo seeking permission to withdraw the petition.
Somshekar M.
With liberty to approach the sessions court. Since the charge sheet is already filed, memo is accepted, petition dismissed as withdrawn with liberty.
Great.
8.1, Somshekar. 8.2. Non Non-compliance ಇದೆ 8.1. 8.1 ನಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. Counsel for the petitioner is absent, no representation, office objections. Since criminal petition 3144 of 2024 is already disposed of, the same is dealing with from the present case. 8.2 ನಲ್ಲಿ counsel for the petitioner is absent, call with the so and so. ಮೊದಲೇ ಆಗಿದ್ರೆ ಮತ್ತೆ ಬೇಡ. Yes, 9.
Serial number 9, Yogesh G.
My lord, I am appealing for the petitioner, my lord.
Yes,
1 week time will be granted, my lord, to produce the entire charge sheet, my lord.
counsel for the petitioner prays for time. Next.
Serial number 10, Sharath H. Gogi.
Petitioner. The petitioner is accused number 13.
1-3.
1-3.
In all, how many accused?
15 accused.
Offense?
Offense under section 506, 504, 120B, 149, 419, 420, 468, 471, 464. There is absolutely no allegation against this accused. Your Honor, could page number 18, complaint.
Page number?
18, para number 4 of the complaint.
Come to page 14.
Please. Page 14.
Yes,
The complaint is at ink page number 16.
sir, 14 gist
Yep.
is there.
Please, please,
read
madam.
that.
Please. ದಿನಾಂಕ 11/1/24 ಸಂಜೆ 4 ಗಂಟೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿ ತೆರೇಸಾ ಬಾಬು ಅವರು ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನೀಡಿದ ದೂರಿನ ಸಾರಾಂಶ ಏನೆಂದರೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬಿದರಳ್ಳಿ ಹೋಬಳಿ ಹಿಂಡರಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 56/4ರಲ್ಲಿ 2 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನು 2001 ಇಸ್ವಿಯಲ್ಲಿ ಬೆಂಗಳೂರು ನಗರ ವಾಸಿ ಶ್ರೀಮತಿ ಶೀಲಾರವರ ಕಡೆಯಿಂದ ಬೆಂಗಳೂರು ಮಹಾಧರ್ಮ ಕ್ಷೇತ್ರ ಅಪರಾಧಿ ಐ ಚಿನ್ನಪ್ಪ ಖರೀದಿ ಮಾಡಿದ್ದು ಐ ಚಿನ್ನಪ್ಪರವರು ದಿನಾಂಕ 13/12/22ರಲ್ಲಿ ಚಿನ್ನಪ್ಪ ಅವರು ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. ಐ ಚಿನ್ನಪ್ಪ ಮೃತಪಟ್ಟ ನಂತರ ಬೆಂಗಳೂರು ಮಹಾಧರ್ಮ ಕ್ಷೇತ್ರದ ಆರ್ಚ್ ಬಿಷಪ್ ಬೆಂಗಳೂರವರಾದ ಡಾಕ್ಟರ್ ಪೀಟರ್ ಮುಚಾಡೋ ಅವರು ನನ್ನ ಹೆಸರಿಗೆ ಜಮೀನು ನೋಡಿಕೊಳ್ಳಲು ಹಾಗೂ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಿವಿಲ್ ಕೇಸು ದಾಖಲು ಮಾಡಲು ಕ್ರಿಮಿನಲ್ ಕೇಸು ದಾಖಲಿಸಲು ಜಿಪಿಎ ನೀಡಿರುತ್ತಾರೆ. ಚಿನ್ನಪ್ಪರವರು ಬದುಕಿರುವಾಗ OS ನಂಬರ್ 788/20ರಲ್ಲಿ ಸಗಾಯಿ ಮೇರಿ ವಿರುದ್ಧ ಸಿವಿಲ್ ದಾವೆ ಹೂಡಿದ್ದು ಸದರಿ ದಾವೆಯಲ್ಲಿ ಯಾರು ಮಾರಾಟ ಮಾಡಬಾರದೆಂದು ದಿನಾಂಕ 5/11/22ರಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ತಡೆಯಾಜ್ಞೆ ಮಾಡಿದ್ದು, ಇದಾದ ನಂತರ ಅವರು ಮೃತಪಟ್ಟಿರುವುದರಿಂದ ಸದರಿ ಕೇಸನ್ನು ವಾಪಸ್ ತೆಗೆದುಕೊಂಡು OS 667/23ರಲ್ಲಿ ನಾನು ಸಿವಿಲ್ ಕೇಸು ಹೂಡಿದ್ದು ಸದರಿ ದಾವೆಯಲ್ಲೂ ಕೂಡ ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಯಾರಿಗೆ ಮಾರಾಟ ಮಾಡಬಾರದೆಂದು ತಾತ್ಕಾಲಿಕ ತಡೆಯಾಜ್ಞೆ ನೀಡಿದ್ದು ಸದರಿ ತಡೆಯಾಜ್ಞೆ ಮುಂದುವರೆದಿರುತ್ತದೆ. ಸಗಾಯ್ ಮೇರಿ, ಸಗಾಯ್ ರಾಜ್, ಅಂಟೋಮಲ್ ರಾಜ್, ಗ್ರೇಸಿ, ಜೋನ್ಸಿ, ಸ್ನೇಹಲ್, ಲೋಕೇಶ್, ಬಾಬು ಇನ್ನಿತರರು ಅವಲಹಳ್ಳಿ ಪೊಲೀಸ್ ಠಾಣೆ ನಂಬರ್ 463/22 ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಗಳಾಗಿರುತ್ತಾರೆ. ಇವರ ಜೊತೆಗೆ ಹರಿಪ್ರಸಾದ್, ಸಂದೀಪ್ ಕುಮಾರ್, ವೆಂಕಟೇಶ್, ಹೇಮಣ್ಣ ಮತ್ತು ಬಿದರಹಳ್ಳಿ ಹಿರಿಯ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕಚೇರಿ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಶ್ರೀಮತಿ ಲಲಿತಾ ಅಮೃತೇಶ್ ಮತ್ತು ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ತಹಶೀಲ್ದಾರ್ ಶ್ರೀ ಮಹೇಶ್ ಇವರುಗಳೆಲ್ಲ ಒಳಸಂಚು ರೂಪಿಸಿಕೊಂಡು ದಾಖಲಾತಿಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ನನಗೆ ಮೋಸ ವಂಚನೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಮೇಲ್ಕಂಡ ಪ್ರಸಾದ್, ಸಂದೀಪ್ ಕುಮಾರ್, ವೆಂಕಟೇಶ್, ಹೇಮಣ್ಣ ಅವರ ಹೆಸರಿಗೆ ದಿನಾಂಕ 17/10/23ರಲ್ಲಿ ಲೋಕೇಶ್ ಮತ್ತು ಬಾಬುಜಿ ರವರು KR ಪುರಂ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಕಚೇರಿಯಲ್ಲಿ ಕ್ರಯ ಪತ್ರ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಜಮೀನಿನಲ್ಲಿ ಯಾರು ಯಾವುದೇ ಕೆಲಸ ಜಮೀನು ಮಾರಾಟ ಮಾಡಬಾರದೆಂದು ತಡೆಯಾಜ್ಞೆ ಇರುವುದರಿಂದ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಮತ್ತು ತಾಲೂಕ್ ತಹಶೀಲ್ದಾರ್ ಅವರಿಗೆ ಮೇಲ್ಕಂಡ ಜಮೀನು ಬೇರೆ ಯಾರಿಗೂ ರಿಜಿಸ್ಟರ್ ಮತ್ತು ಇತರೆ ದಾಖಲಾತಿಯನ್ನು ಬದಲಾವಣೆ ಮಾಡಬಾರದೆಂದು ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಪ್ರತಿ ಲಗತ್ತಿಸಿದರೂ ದೂರು ಅರ್ಜಿ ನೀಡಿರುತ್ತೇನೆ. ಆದರೂ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಮತ್ತು ತಾಲೂಕ್ ತಹಶೀಲ್ದಾರ್ ಅವರಿಂದ ಲಾಭ ಪಡೆಯುವ ಉದ್ದೇಶದಿಂದ ಕ್ರಯ ಪತ್ರ ಮತ್ತು ಪಾಣಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿರುತ್ತಾರೆ. ನಾನು ಕೊಟ್ಟಿರುವ ದೂರು ಅರ್ಜಿ ಮತ್ತು ನ್ಯಾಯಾಲಯದ ಆದೇಶ ರೆವಿನ್ಯೂ ದಾಖಲಾತಿಗಳಲ್ಲಿ ಕಾಣಿಸಿಕೊಳ್ಳುತ್ತದೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳು ಮೇಲ್ಕಂಡ ಜಮೀನಿನ ಈ ಹಿಂದೆ ಪಾಣಿಯಲ್ಲಿ ಐ ಚಿನ್ನಪ್ಪ ಎಂಬುವರ ಹೆಸರಲ್ಲಿ ಇದ್ದ ಜಮೀನು ದಾಖಲಾತಿಗಳನ್ನು ಬದಲಾಯಿಸಿ ಜಮೀನಿನ ನಕಲಿ ದಾಖಲಾತಿಯನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಹಾಗೂ ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ಜಮೀನು ಅವರ ವಶಕ್ಕೆ ಪಡೆಯಲು ಈ ಪ್ರಯತ್ನ ಮಾಡಿರುತ್ತಾರೆ ಮತ್ತು ಈಗಾಗಲೇ ಅವಲಹಳ್ಳಿ ಪೊಲೀಸ್ ಠಾಣೆ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 463/22 ಮತ್ತು 145/23 ಪ್ರಕರಣಗಳಲ್ಲಿ ಆರೋಪಿಗಳಾಗಿದ್ದರು. ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಡೆದಿರುವ ಜಾಮೀನು ಆದೇಶವನ್ನು ಪಾಲನೆ ಮಾಡದೆ ಪದೇ ಪದೇ ನಕಲಿ ದಾಖಲೆಯನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ನನಗೆ ಮೋಸ ವಂಚನೆ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಪದೇ ಪದೇ ದಾಖಲಾತಿಗಳನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡು ಬೇರೆ ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡುತ್ತಿರುತ್ತಾರೆ ಹಾಗೂ ನನಗೆ ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳು ಮತ್ತು ಅವರ ಸಹಚರರು ಸೇರಿಕೊಂಡು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ನೀಡದೆ ನಿಮ್ಮನ್ನು ಪ್ರಾಣ ಸಹಿತ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ನನಗೆ ಮತ್ತು ನನ್ನ ಜಮೀನಿನಲ್ಲಿ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವ ಸೆಕ್ಯೂರಿಟಿಗಳಿಗೆ ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುವ ಅವಾಚ್ಯ ಶಬ್ದ ಬೈದು ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ಕೋರುತ್ತೇನೆಂದು ನೀಡಿ ದೂರು ಪಡೆದ ಪ್ರಕರಣ ದಾಖಲಾತಿ. In this, the accused number 13 name is not forth.
But he is named in the FIR.
Accused name is there in the FIR, but in the content of the complaint, there is no name forthcoming. Neither he is the party to the alleged document, nor he is the witness to the alleged documents.
Yes.
And,
You are working as?
please,
You are working as?
I am an,
Huh.
I'm
Are you
an-
a government servant or?
no, no, Mila. I'm
Then
a
what is
private,
the role?
doing business,
Hmm?
business,
What business?
real estate business.
Real estate?
Yes.
Date of complaint?
Date of offense, the alleged, there is no specific date of offense, but the date they refer to of the alleged sale deed is of 17/10/2023.
Date?
17/10/23. But they don't refer it as a date of offense, but that is the document which they claim that it has been executed.
Yes, what is?
Allegation in the complaint itself, page number 18, kindly see. Para 4, the last upper down, para
Hmm.
18 minutes, about 10 lines after document, the accused number 7-30,
Hmm.
7-13.
Yes.
This 13 means the present petitioner. 7-13, already they are the accused in crime number 463/2022 and 145/2023 and 131/2023. They are hand in glove with the other accused 1-6 and jointly committed criminal conspiracy to share the booty and helped in concocting, fabricating such document in respect of suit schedule property. Moreover, my lord, it is my lord anticipatory bail,
Hmm.
my lord, seeking my lord, they are from the date
What
of
about other accused?
other accused.
No, I'm not aware of it. Accused number 13 was not a party in the accused in crime number 463. He was accused in crime number 145. He was enlarged on the bail by the Sessions Court.
Hmm.
Earlier.
What about 131?
Milord, he is not accused in that.
Yes.
To my knowledge.
This allegation, the complaint, my lord, the anticipatory
No,
bail.
you
This
have to
refers to the
verify.
allegation with respect to the other crime
Not
number.
an accused in 463.
I have produced
And
the
he
FIR
is
copy.
not aware about 131.
I have produced the ink page number 34, crime number 463.
Subsequently, might have, my lord, he had added, my lord, FIR has been produced, my lord.
What is the progress made? Who are the accused who are apprehended? What is the information the IO has collected? Whether he can be granted anticipatory bail?
Only
ಇದು ಏನು ಹೇಳ್ದೆ ಸುಮ್ಮನೆ ಇದ್ ಮಾಡಿದ್ರಿ ಏನು what is?
custodial investigation.
Huh?
Only after custodial investigation it has been.
See, January, the complaint was filed.
Yes,
There is no progress in the investigation.
here, my lord.
Then there must be some semblance.
Stringent condition.
Get the information and tell me.
Please.
Pass over.
Highly obliged.
Serial number 11, Sagar Bibi.
Lots for petition, lots. Seek 1 week time to file charge sheet, lots.
Counsel for the petitioner prays for time. Yes, next.
Date may.
Serial number 12, Sandeep K.
Petitioner, my lord. Petition under 438 of CRPC in anticipatory bail. The petitioners are accused number 2 and 3.
In all, how many accused?
3 accused, my lord.
About one?
Not aware.
ಏನು ಗೊತ್ತಿರೋದಿಲ್ಲ ಮತ್ತೇನು?
Offenses under section 465, 466, 468, 417, 419, 420, 434, my lord. The allegation against these accused are that they are the bona fide purchasers, my lord. The accused number 1, being the GPA holder of one Kullaya, has sold and 14 guntas of land in survey number 609 of Kesara village, Mysore, in favor of these accused persons, my lord. And these
The GPA holder of
one Kullaya.
Kullai. On the basis of GPA deed, he sold it in favor of?
Accused number 2 and 3. These accused, my lord, after getting the sale deed, they applied for change of kata.
Hmm.
And the Tahsildar has rejected their application, and upon that, they filed a revenue appeal and produced the documents which were given to the accused number 2 and 3 by accused number 1 at the time of sale, my lord.
Hmm.
And the assistant commissioner, upon verification of the at least genealogical tree of late Kullaya, he found that to be a fabricated document.
Hmm.
And he filed a complaint before the complaint police, my lord. But these accused, my lord, they are the bona fide purchasers and they do not have any notice of defect, my lord. And they have paid a valuable consideration to the
No,
land.
this is not a case for 438. Sir. Yes, what do you say?
Lord. All the accused, my lord, involved in cases, my lord. Moreover, my lord, this 438 petition, my lord, the custodial investigation was very much necessary, my lord.
Yes,
My lord, there is no allegation against these petitioners in the
all are conspiracy.
my lord,
All
there is no,
have conspired together. You are hand in glove, concocted documents. No,
but there is no specific allegation against these petitioners.
not the body that. The assistant commissioner is the complainant.
Please,
Look at the seriousness of the offense. It is not some Kullaya or his legal representative. Assistant commissioner has filed the complaint.
please, my lord.
So what?
But the alleged documents has not been created by these petitioners, my
That
lord.
is for the investigating officer. Let him investigate. Petitioners being accused number 2 and 3 are seeking grant of anticipatory bail on the apprehension of being arrested. The assistant commissioner. Mysore. Lodge the first information against accused number 1, 2, 3 for the opposite offences. They stated that accused number 1 concocted and fabricated a document styled as a general power of attorney. Deed said to have been executed by one Sri Kullaya, who is the owner of the landed property. He in turn sold it in favor in the name of these petitioners under a registered sale deed. When they applied for a change of kata, the informant came to know that the GPA deed is a fabricated document, and on the basis of the same, the accused have managed to get the sale deed in their names. The allegations against the present petitioners, allegations against the accused are very serious in nature. Contention of the learned counsel for the petitioner that the petitioners are the innocent bona fide purchasers cannot be accepted at this stage, as it is as the investigation is still at the initial stage. Therefore, I am of the opinion that petitioners are not entitled. Looking at the nature and seriousness of the offense, I am of the opinion that the petitioners are not entitled for grant of anticipatory bail. Yes, rejected.
Number 13, Jayana GR.
Appearing for petition. My lord, kindly pass. My lord, kindly have 2:30 minutes. 2:30. Afternoon.
Why? Continuously you are seeking time.
No, I am asking last time only. Before that, government advocate took the time.
Counsel for the petitioner prays for time. Okay. Next.
14 disposed, 15 serial number 16, Mohammed Pasha.
ಏಕೆ
File ನಮ್ಮ colleague applies.
ಫೈಲ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ನೀವು ಇಲ್ಲಿದ್ದು ಏನ್ ಮಾಡೋರು?
So he is supposed to appear.
ಪಾಸ್ ಓವರ್.
Serial number 17, Anuradha Aras.
Appear for the petitioner, please. This is an offense under section 302. The petition is 302, Swami.
302. Petitioner is
Petitioner is the mother, the deceased is the son, please, Your Lordship. Mother is 24 years, the son was 2.5 years. It is a case of the prosecution that she has given Lakshman Rekha to the child and she also consumed it and the child expired, she survived. That is the case of the prosecution, please, Your Lordship. But the actual fact is that there is no eyewitness, please, Your Lordship. There is no
is the
eyewitness.
complainant.
Husband, please, Your Lordship. Husband also is not a witness, please, Your Lordship. I would take your honors to, I would take your Lordship to the complaint typed copy at page 17, please, Your Lordship. From para 2 onwards, please. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ವ್ಯವಸಾಯ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡಿರುತ್ತೇನೆ. ಈಗ 4 ವರ್ಷದ ಹಿಂದೆ ಟಿ ಮಣಿಯಂಬಾಳ್ ವಾಸಿ ದೇವರಾಜು ಎಂಬುವರ ಮೊದಲನೇ ಮಗಳಾದ ಪೂರ್ಣಿಮಾ ಎಂಬಾಕೆಯನ್ನು ಮದುವೆಯಾಗಿದ್ದು ನನಗೆ 2.5 ವರ್ಷದ ದೀಕ್ಷಿತ್ ಗೌಡ ಎಂಬ ಗಂಡು ಮಗು ಇರುತ್ತದೆ. ನಾನು ನನ್ನ ತಾಯಿ ವರಮಹಾಲಕ್ಷ್ಮಮ್ಮ ಹಾಗೂ ನನ್ನ ಅಣ್ಣ ಪ್ರೇಮ್ ಕುಮಾರ್, ಅತ್ತಿಗೆ ಚೈತ್ರ ಹಾಗೂ ಇವರ ಮಕ್ಕಳಾದ ಚಿರಂತ್ ಗೌಡ ಹಾಗೂ ಇನ್ನೂ ಹೆಸರಿಡದ ಗಂಡು ಮಕ್ಕಳಿದ್ದು ನಾವೆಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಗೋದೂರು ಗೇಟಿ ಬಳಿ ಇರುವ ಒಂದು ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಇತ್ತೀಚೆಗೆ ನಮ್ಮ ಅತ್ತಿಗೆ ಬಾಣಂತನಕ್ಕೆ ಬಿಡದಿ ಚುಂಚಗ ಗ್ರಾಮಕ್ಕೆ ತವರು ಮನೆಗೆ ಬಾಣಂತನಕ್ಕೆ ಹೋಗಿದ್ದು ಸರಿಯಷ್ಟೇ. ಈಗ 4 ತಿಂಗಳಿಂದ ನನ್ನ ಹೆಂಡತಿ ಪೂರ್ಣಿಮಾರವರು ನನಗೆ ಬೇರೆ ಮನೆ ಮಾಡು ಅಂತ ಹೇಳುತ್ತಿದ್ದಳು. ನಾನು ನಮ್ಮ ಅತ್ತಿಗೆ ಬಾಣಂತನ ಮುಗಿಸಿಕೊಂಡ ಬಂದ ಮೇಲೆ ಬೇರೆ ಮನೆ ಮಾಡಿಕೊಂಡು ಹೋಗೋಣ ಅಂತ ಹೇಳಿದ್ದೆ ಹಾಗೂ ಸಮಾಧಾನ ಪಡಿಸಿದ್ದೆನು. ಇತ್ತೀಚಿನ ದಿನಗಳಲ್ಲಿ ನನ್ನ ಹೆಂಡತಿ ಬೇರೆ ಮನೆ ಮಾಡು ಅಂತ ತುಂಬಾ ಹಠ ಮಾಡುತ್ತಿದ್ದು ನಿನಗೆ ಸಮಸ್ಯೆ ಇದ್ದರೆ ಹೇಳು ಅಂತ ಕೇಳಿದರೂ ಏನೂ ಇಲ್ಲ ಅಂತ ಸುಮ್ಮನಿದ್ದಳು. ಆದ ಕಾರಣ ಪೂರ್ಣಿಮಾರವರನ್ನು ತಂದೆ ತಾಯಿ ದೇವರಾಜು ಹಾಗೂ ನಾಗರತ್ನ ಈಗ 20 ದಿನಗಳ ಹಿಂದೆ ಕರೆಸಿ ಮಾತಾಡಿಸಿ ನನ್ನ ಹೆಂಡತಿ ಅವರಿಂದ ತಿಳುವಳಿಕೆ ಹೇಳಿಸಿ ನನ್ನ ಅತ್ತಿಗೆ ಚೈತ್ರ ಬಂದ ಮೇಲೆ ಬೇರೆ ಹೋಗೋಣ ಅಂತ ನನ್ನ ಅತ್ತೆ ಮಾವನ ಮುಂದೆ ಹೇಳಿದ್ದು. ನಂತರ ನನ್ನ ಹೆಂಡತಿ ಮಗುವನ್ನು ಅವರು 1 ವಾರದ ಮಟ್ಟಿಗೆ ಮಣಿಯಂಬಾಳು ಗ್ರಾಮಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು ನಂತರ ಈಗ 1 ವಾರದ ಹಿಂದೆ ವಾಪಸ್ ಅವರೇ ನನ್ನ ಹೆಂಡತಿ ಮತ್ತು ಮಗುವನ್ನು ಕರೆದುಕೊಂಡು ನಮ್ಮ ಮನೆಗೆ ಬಿಟ್ಟು ಹೋದರು. ಆಗಿಂದ ಚೆನ್ನಾಗಿದ್ದಳು. ದಿನಾಂಕ 23/1/2024 ಬೆಳಗ್ಗೆ ಸುಮಾರು 8 ಗಂಟೆ ಸಮಯದಲ್ಲೂ ನಾನು ಮನೆಯಲ್ಲಿ ಇಲ್ಲದ ಸಮಯ ನೋಡಿಕೊಂಡು ಲಕ್ಷ್ಮಣ್ ರೇಖೆಯನ್ನು ಸೇವನೆ ಮಾಡಿ ನನ್ನ ಮಗುವಿಗೂ ಸಹ ಕುಡಿಸಿರುತ್ತಾಳೆ. ನಾನು 9 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮನೆಗೆ ಬಂದು ನೋಡಿದಾಗ ಮನೆಗೆ ಒಳಗಡೆ ಚಿಲಕ ಹಾಕಿಕೊಂಡಿದ್ದಳು. ನಾನು ಎಷ್ಟೇ ಕರೆದರೂ ಬಾಗಿಲು ತೆರೆಯದ ಕಾರಣ ನಂತರ ನಾನು ಕಿಟಕಿಯಲ್ಲಿ ನೋಡಿದಾಗ ನನ್ನ ಮಗುವಿನ ಬಾಯಿಂದ ನೊರೆ ಬರುವುದು ಕಂಡು ಗಾಬರಿಯಾಗಿ ನಾನೇ ಹಾರೆಯಿಂದ ಬಾಗಿಲು ಒಡೆದು ಒಳಗೆ ಹೋಗಿ ನೋಡಿದಾಗ ಇಬ್ಬರು ಅಸ್ವಸ್ಥರಾಗಿದ್ದರು. ನಂತರ ಯಾವುದೋ ಆಟೋ ಒಂದರಲ್ಲಿ ದಾರಿಗೆ ಅಡ್ಡ ಹಾಕಿ he took her to the hospital. ನನ್ನ ಹೆಂಡತಿ ಪೂರ್ಣಿಮಾ ಹಾಗೂ ನನ್ನ ಮಗ ದೀಕ್ಷಿತ್ ಗೌಡರನ್ನು ಕರೆದುಕೊಂಡು ಡಾಕ್ಟರ್ ಚಂದ್ರಮ್ಮ ದಯಾನಂದ್ ಸಾಗರ್ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆಗೆ ಬೆಳಗ್ಗೆ 10:20 ಗಂಟೆಗೆ ವೈದ್ಯರ ಬಳಿ ಹೋಗಿ ತಪಾಸಣೆ ಮಾಡಿದಾಗ ಮಗು ಮೃತಪಟ್ಟಿರುವುದು ವೈದ್ಯರು ತಿಳಿಸಿರುತ್ತಾರೆ. ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಅಲ್ಲೇ ಚಿಕಿತ್ಸೆಗೆ ಒಳರೋಗಿಯಾಗಿ ದಾಖಲು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ನನ್ನ ಮಗನಾದ ದೀಕ್ಷಿತ್ ಗೌಡ ಲಕ್ಷ್ಮಣ್ ರೇಖೆ ಕುಡಿಸಿ ನನ್ನ ಮಗನ ಸಾವಿಗೆ ಕಾರಣ ಆದ ನನ್ನ ಹೆಂಡತಿ. This is the complaint. The actual fact is that at morning 8 o'clock, since she was busy, she had put the child on the floor and put around him the Lakshman Rekhe. By mistake, she had left the Lakshman Rekhe there. When she came back and saw, the child had already consumed half of the Lakshman Rekhe and it was unconscious. It was already, the child has epilepsy, please, Your Lordship. There are documents to show that the child had epilepsy. And when she came and saw the child was unconscious, she assumed that the child is dead and she also consumed the Lakshman Rekhe, please, Your Lordship. This is but whatever said and done, the husband also has not witnessed.
No mother will do that. Mother will take the child and seek assistance from others.
My lords, by then the child was already unconscious, please, Your Lordship. She assumed that the child is dead, please, Your Lordship. She had no reason to kill the child, please, Your Lordship.
She should have alerted the others. No.
She had no reasons, please, Your Lordship. And in fact, she also had a little bit of
Charge sheet is filed.
No, please, your lordship.
This is
She-
438.
ಹೌದ್ ಸ್ವಾಮಿ.
No,
ಅಲ್ಲ, my humble submission before the court is,
nothing.
she is
When
under
you
psychiatric.
discharged from the hospital?
Pardon, please, your lordship.
When you discharged from the hospital?
She has continuously under psychiatric treatment, please, your lordship.
Yes, still not discharged.
She is discharged but
When?
under the psychiatric treatment,
When?
please, your lordship. She was discharged on, she was discharged from the hospital and again, it is at page number 33, please, your lordship.
When she was discharged?
Yes, please, your lordship. Twenty-seven one, please, your lordship. Allah. Twenty-nine one 2024, please, your lordship.
No,
But she was taken over by the psychiatric department, please.
You appear before the investigating officer.
My
Not the
lord, she
case.
is not in a condition to even give any statements or anything. She is still under treatment, please,
This
your
is for
lordship.
the investigating officer to consider. But very serious allegations are made. It is not a case for 438. 439. I
My
can
lord, she is
consider.
just 24 years. If she will cooperate. Tomorrow itself, she will surrender before the IU,
Has
please,
to.
your lordship.
The offense under 302
Yes, please,
is
your lordship.
removed.
I do agree. I'm not saying it's a simple offense and it is her own child, please, your lordship.
Yes, that is the concern of the board. Third. No, not.
She has
that.
got some psychiatric disorder also, please,
Let
your
her take
lordship.
treatment.
She is under treatment, please, your lordship.
Petitioner. Being the sole accused is seeking grant of anticipatory bail on the apprehension of being arrested. The husband of the petitioner lodged the first information, alleging commission of the offence punishable under section 302 of IPC. It is alleged that the petitioner was insisting for arranging separate house, and when her demands were not met, pesticide to her child aged 2.5 years. And she also consumed the same. As a result of which, the child aged 2.5 years died. And she was discharged after taking treatment in the hospital. The contention of the learned counsel for the petitioner that petitioner has not committed any offense, but she was innocent, etc., could not be accepted at this stage, given the seriousness of the offense alleged. Hence, I am of the opinion that the petitioner is not entitled. Dismissed.
Serial number 8, adjourn 19, Sunil Kumar Patel.
I've been instructed that charge sheet has been filed, my lord. Be given 1 week time to place the
Place
charge.
button. Next.
Serial number 20, Naveen HM.
For petitioner.
Four 39, my lord.
Yes, how many accused are there?
3 accused, my lord.
What about 1 and 2?
Accused number 1, judicial custody, my lord. Accused number 2 already is bail. Session court, my lord. Accused number 3 is also judicial custody, my lord.
When arrested?
Iriut Police Station, 24/1/2024, my lord.
What are the offense?
Offenses 326A, 34 and 109, my lord.
Who is the complainant?
Arun Kumar. Arun Kumar.
He is the injured?
Yes, my lord. Already discharged, my lord.
Date of incident?
16/1/2024, 16/1, my lord.
Date of discharge?
Investigation is completed, my lord. Investigation is completed, charge sheet
No,
also.
he is not yet discharged. Injured. Yes, what is it?
No, yes, my lord. Suffered, my lord. Previous injury, my lord, it's a acid attack, my lord. And there are 4 injuries, my lord. Lord, case against unknown persons, my lord. Therefore, my lord, TI period also conducted, my lord. Where, my lord, he has identified this petitioner also.
TIP.
TI period also conducted, my lord, he has identified. Therefore, my lord, there is a prima facie case, my lord.
So this petitioner is one of the assailant.
Yes, my lord, yes.
Swami, case ಅಲ್ಲಿ ಪಿಟಿಷನರ್ ಆಸಿಡ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಪಿಟಿಷನರ್ ಬೈಕ್ ಅಲ್ಲಿ ಕೂತಿದ್ದ ಅಂತ ಅಲಿಗೇಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ಆಲ್ರೆಡಿ ಸೆಷನ್ ಕೋರ್ಟ್ ಬೇಲ್ ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ.
Allegation ಎಲ್ಲಿದೆ?
326A 109/34 my lord.
No, where it is alleged that you are only abusing them. Where is the allegation? According to the learned HCGP, the injured identified him as one of the assailant.
ಐಡೆಂಟಿಫಿಕೇಶನ್ ಪೀರಿಯಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಐಡೆಂಟಿಫಿಕೇಶನ್ ಪೀರಿಯಡ್ ಅಕ್ಯೂಸ್ ಕೂಡ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 76 my lord. 76 ಅಲ್ಲಿ 80 ಪೇಜ್ ನಂಬರ್ my lord. ಲಾಸ್ಟ್ 11 ಕಾಲಮ್ ಪ್ರಕರಣ ಸಾಕ್ಷಿದಾರರ ಇವರು ಮೇಲ್ಕಂಡ 14 ಜನ ಆರೋಪಿಗಳ ಪೈಕಿ ಪೇಜ್ ನಂಬರ್ 80 my lord, 80. ಇವರು ಮೇಲ್ಕಂಡ 14 ಜನ ಆರೋಪಿಗಳ ಪೈಕಿ ಯಾವುದೇ ಆರೋಪಿಗಳನ್ನು ಗುರುತು ಹಚ್ಚಿರುವುದಿಲ್ಲ. One my lord. Another one, page number 87 my lord.
No, this pertains to which accused?
87 my lord. Another one page. ಇವರು ಮೇಲ್ಕಂಡ 14 ಜನ ಆರೋಪಿಗಳ ಪೈಕಿ ಆರೋಪಿಗಳನ್ನು ಗುರುತು ಹಚ್ಚಿರುವುದು.
No, there are 3 accused.
Yes my lord.
What is name of accused number 1?
Accused number Prajwal my lord. Prajwal.
Oh, who is accused number 2?
Accused number 2 Nitin Kumar my lord. Nitin Kumar already bail 16/3/2024 ಸ್ವಾಮಿ. Honorable Session Court already bail ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ. My petitioner name is Girish my lord. Accused number 3.
Yes, where is the document? Identified by whom?
Injirappa complaint.
That is the injured.
Complainant.
Complainant is not the injured.
Then father, injured father, my lord, Anjanappa,
Anjanappa.
father.
Was also with him.
Yes, my lord. Yes.
No, madam.
Yes, my lord.
Whether complainant was with the injured. Complainant is Arun Kumar.
Yes, my lord.
Even,
The injured himself.
even CW 11 and 12 are the eyewitnesses. CW 11 and 12 also.
Charge sheet is already filed.
Charge
Yes,
sheet
my
is
lord, yes, my lord.
CW one is the injured.
injured.
Yes.
CW
11 and 12 are the eyewitnesses.
11 and 12. What is
11 and 12, my test period accurate produced matter Swami, out the Swami now.
CW 11? Who is CW 11?
Sridhara,
CW
11 Raghavendra, 12 Sridhara, my lord.
12 is Sridhar.
Yes, my lord. Test period
Who is
report.
this Anjanappa? Sakshi avunu ashte.
Anjanappa is, my lord. He is the father of the, my lord, the injured, my lord, victim.
Whether he is an eyewitness,
No, my lord, no, my lord.
He is, my lord, circumstantial.
then how can he identify? Hmm? Yes. This is the identification by whom? ತಗೊಳ್ಳಿ.
The case is Swami, accused number 2, Swami, acid accident allegations is Swami, accused number 3.
No, there
Yes,
is some
Vaikal.
document that Girish, that is the petitioner, was identified.
Yes.
But identified by whom?
Pass over, my lord.
Proceed.
Serial number 21, Hari Prasad L.
Appearing for petition. Petitioner is the sole accused. Petitioner is the sole accused.
Sole. When he was
Offense is
arrested?
302.
302.
302. The
When he was
petitioner got
arrested?
arrested on 2/1/2024.
Charge sheet is filed?
Lord, the time of the reporting alleged offense is at about 3 AM in the early morning.
Yes.
Lord, kindly page number 36, madam.
Charge sheet is already filed.
Charge sheet filed. Page number 36.
Who is the complainant?
Complainant is the mother of the deceased. Varalakshmi. She suspect the petitioner. Lord, page number.
There are
11.
eyewitnesses.
Lord, the IO has shown the three witnesses as eyewitnesses, but they are not the eyewitness. Lord, kindly turn to page number 36, madam. 36, kindly.
No, first let me understand what is the allegation. How she died,
Lord, by stabbing injury on chest,
where,
on the chest.
now whether deceased is related to you.
No, my lord, he is telling that he is my friend. My lord, page number 11, my lord, the complaint, first information. Last 5 pages, the complainant is the mother of the deceased. My lord, ಯಾರೋ ದುರುದ್ದೇಶದಿಂದ ಹರಿತವಾದ ಆಯುಧದಿಂದ ನನ್ನ
That
ಮಗನ
is at the first instance. Now investigation completed and. charge sheet
investigation
is filed
complete, charge sheet is
Against you.
against
You are the sole accused.
I am the sole.
What is the case made out by the prosecution?
My lord, case made out by the prosecution, my lord, page number 36.
Hmm.
My lord, second para. ನಂತರ ದಿನಾಂಕ 31/12/2023 ಮಧ್ಯರಾತ್ರಿ ಸುಮಾರು 12:30 ಗಂಟೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ನಗರ ಹನುಮಂತನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಶ್ರೀನಿವಾಸ ನಗರ 80 ಅಡಿ ರಸ್ತೆ.
No, what is the object, intention, first para?
My lord, intention. ಸಾಕ್ಷಿ ಶ್ರೀಮತಿ ವರಲಕ್ಷ್ಮಿ ರವರು ಮೃತ ವಿಜಯ್ ಎಂ ವಿಜಿ 21 ವರ್ಷ ಎಂಬ ಒಬ್ಬನೇ ಮಗನಿರುತ್ತಾನೆ. ಹೀಗೆ ಸುಮಾರು 5-6 ವರ್ಷದ ಹಿಂದೆ ಮೃತ ವಿಜಯ್ ಮತ್ತು ಎಂ ಮತ್ತು ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯ ಅಂಕಣ 12ರಲ್ಲಿ ನಮೂದಿಸಿದ ಆರೋಪಿ ರಮೇಶ್ ಅಲಿಯಾಸ್ ವಿಷ್ಣುರವರು ಸ್ನೇಹಿತರಾಗಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ ಇಬ್ಬರು ಒಟ್ಟಿಗೆ ಸಿಗರೆಟ್ ಸೇದುವುದು, ಗಾಂಜಾ ಮತ್ತು ಎಣ್ಣೆ ಹೊಡೆಯುತ್ತಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ ಚಿಕ್ಕ ವಿಚಾರಗಳಿಗೆ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಆರೋಪಿಯೊಂದಿಗೆ ಆಗಾಗ ಜಗಳ ಮಾಡುತ್ತಿದ್ದನು. ಇದರೊಂದಿಗೆ ಆರೋಪಿಯು ಮೃತನೊಂದಿಗೆ ಮಾತನಾಡುವುದನ್ನು ಬಿಟ್ಟಿದ್ದನು. ನಂತರದ ದಿನಗಳಲ್ಲಿ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಆರೋಪಿಯನ್ನು ನೋಡಿದಾಗಲೆಲ್ಲ ಗುರಾಯಿಸುವುದು, ಬೇರೆ ಹುಡುಗರನ್ನು ಕರೆದುಕೊಂಡು ಬೈಕ್ನಲ್ಲಿ ಬಂದು ರೇಗಿಸುವುದು ಹಾಗೂ ಬೇಕಂತಲೇ ಗುರಾಯಿಸಿ ಜಗಳ ಮಾಡುತ್ತಿದ್ದನು. ಘಟನೆ ನಡೆಯುವ ಸುಮಾರು 20 ದಿನಗಳ ಹಿಂದೆ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಏರಿಯಾದ ಕೆಲವು ಹುಡುಗರ ಬಳಿ ಆರೋಪಿಗೆ ಹೊಡೆಯುವುದಾಗಿ ಹೇಳಿಕೊಂಡು ಓಡಾಡುತ್ತಿದ್ದನು. ಇದರಿಂದ ಆರೋಪಿಯು ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿಯು ತನಗೆ ಹೊಡೆಯುವ ಮುಂಚೆ ತಾನೇ ಆತನಿಗೆ ಹೊಡೆಯೋಣವೆಂದು ತೀರ್ಮಾನಿಸಿಕೊಂಡು ಕಡಲೆಕಾಯಿ ಪುರಸೆಯಲ್ಲಿ ಒಂದು ಚಾಕುವನ್ನು ಖರೀದಿ ತನ್ನ ಬಳಿ ಇಟ್ಟುಕೊಂಡಿದ್ದನು. ದಿನಾಂಕ 31/12/2023 ಮಧ್ಯರಾತ್ರಿ ಸುಮಾರು 12:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಬೆಂಗಳೂರು ನಗರ ಹನುಮಂತನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಶ್ರೀನಿವಾಸ ನಗರ 80 ಅಡಿ ರಸ್ತೆ ಶ್ರೀನಿವಾಸ ನಗರ ಬಸ್ ಸ್ಟಾಪ್ ಎದುರು ನಂಬರ್ 7A ಗಣಪತಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಮುಂಭಾಗದ ರಸ್ತೆಯಲ್ಲಿ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿದಾರರಾದ ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ್, ಸಾಕ್ಷಿ 3 ಚಂದ್ರಶೇಖರ್ ಅಲಿಯಾಸ್ ಚೋಟು ಮತ್ತು ಸಾಕ್ಷಿ 4 ಗೌತಮ್ ಅಲಿಯಾಸ್ ತೂತೂರ್ ಅವರು ನ್ಯೂ ಇಯರ್ ಪಾರ್ಟಿ ಮುಗಿಸಿಕೊಂಡು ಮನೆಗೆ ಹೋಗಲು ಬರುತ್ತಿದ್ದು, ಅದೇ ರಸ್ತೆಯಲ್ಲಿ ಬರುತ್ತಿದ್ದ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಎಂಬುವನು ಸಾಕ್ಷಿ 2, 3 ಮತ್ತು ಸಾಕ್ಷಿ 4 ರವರನ್ನು ನೋಡಿ ಮಾತನಾಡಲು ಬಂದು ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ್ ಅಲಿಯಾಸ್ ಸೀನಾರ್ ಅವರೊಂದಿಗೆ ಮಾತನಾಡುತ್ತಿರುವಾಗೆ ಆರೋಪಿಯು ಠಾಣಾ ಮಾಲುಪಟ್ಟಿ ಸಂಖ್ಯೆ 2/2024 ಕ್ರಮ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ನಮೂದಿಸಿಕೊಂಡಿರುವ ಪ್ಯಾಸೆಂಜರ್ ಆಟೋ ರಿಕ್ಷಾ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸರಲ್ಲಿ ಬಂದು ಆಟೋದಿಂದ ಚಾಕುವಿನ ಸಮೇತ ಕೆಳಗೆ ಇಳಿದು ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿರವರಿಗೆ ಯಾಕೋ ನೀನು ತಿಕ್ಕಾಗಂಚಿನ ಮರ್ಯಾದೆ ಕೊಟ್ಟರೆ ನೀನು ಏನು ದೊಡ್ಡ ಇದ್ದಾಡದಂಗೆ ಆಡ್ತೀಯ ಎಂದು ಠಾಣಾ ಮಾಲುಪಟ್ಟಿ ಸಂಖ್ಯೆ 2/24 ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ನಮೂದಿಸಿಕೊಂಡಿರುವ ಚಾಕುವಿನಿಂದ ಹೊಡೆಯಲು ಬಿಸಿದ್ದು, ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಏಟಿನಿಂದ ತಪ್ಪಿಸಿಕೊಂಡಿದ್ದು, ಅಷ್ಟರಲ್ಲಿ ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ್ ಅಲಿಯಾಸ್ ಸೀನಾನು ಆರೋಪಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಸ್ವಲ್ಪ ದೂರ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು, ಆದರೆ ಆರೋಪಿಯು ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ್ ಅಲಿಯಾಸ್ ಸೀನಾ ತಪ್ಪಿಸಿಕೊಂಡು ಓಡಿ ಬಂದು ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಬಲಭಾಗದ ಎದೆಗೆ ಚಾಕುವಿನಿಂದ ಚುಚ್ಚಿ ಕೊಲೆ ಮಾಡಿರುತ್ತಾನೆ. ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ರವರ ಮಗನಾದ ಮೃತ ವಿಜಯ್ ಎಂ ಅಲಿಯಾಸ್ ವಿಜಿ 21 ವರ್ಷರವರನ್ನು ಹಳೆ ದ್ವೇಷದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕೊಲೆ ಮಾಡಬೇಕೆಂದು ತೀರ್ಮಾನಿಸಿಕೊಂಡು ದಿನಾಂಕ 31/12/2023 ಮಧ್ಯರಾತ್ರಿ 12:30 ಗಂಟೆಯಿಂದ 12:45 ಗಂಟೆಯಲ್ಲಿ ಸಮಯದಲ್ಲಿ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಯ ಬಲಭಾಗದ ಎದೆಗೆ ಚಾಕುವಿನಿಂದ ಚುಚ್ಚಿ ಕೊಲೆ ಮಾಡಿರುವುದು ತನಿಖಾ ಸಮಯದಲ್ಲಿ ಲಭ್ಯವಾದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ದೃಢಪಟ್ಟಿತ್ತು.
Yes.
Lord, I'm furnishing the remand application.
Why?
Lord, during the course of investigation, my lord, the IO went to the spot. He drawn Pancharama and he found one Ganapati complex, my lord. There a CCTV is found, my lord. That was written in.
There are eyewitnesses, sir.
My lord, adu ಹೇಳ್ತೀನಿ.
What is to be done with the CCTV camera?
I will make my submission.
ಏನಿದೆ ಓದ್ ಹೇಳಿ, I
Yes,
will
ma'am.
accept your submissions.
My lord, during the course of investigation, my lord, the IO went to the spot.
Hmm.
My lord, there he found out one CCTV camera. my lord. ನಂತರ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದಲ್ಲಿ ಅಳವಡಿಸಿದ ಸಿಸಿ ಕ್ಯಾಮೆರಾವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿರುತ್ತೆ ಹಾಗೂ ಘಟನೆ ನಡೆದ ಸಮಯದಲ್ಲಿ ಚಂದ್ರಶೇಖರ್ ಅಲಿಯಾಸ್ ಚೋಟು, ಗೌತಮ್ ಅಲಿಯಾಸ್ ತೂತು ಮತ್ತು ಶ್ರೀನಿವಾಸ್ ಅಲ್ಸೀನಾ ಎಂಬರನ್ನು ಠಾಣೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆಗಳನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ದಾಖಲಾಗುತ್ತೆ. This is the only incriminating material collected by the investigation officer against
No,
me.
that is a fact. He says at the spot CC
Yes, ma'am.
camera.
Yes, my lord.
CCTV
During
camera
the
was
course.
installed. That's all.
Yes, ma'am.
How it will help you?
My lord, during the course of investigation, my lord, the expert who is CW19C, Kiran, my lord, who retrieved the videos in the DVR, my lord, in his statement, my lord, I will,
What he says?
my lord, the video footage recovered time is 4:40 to 4:45 AM, my lord. ನನ್ನ ಪಿಕ್ಚರ್ ಬೆಳಗಿನ ಜಾವ 4:40
ಆಯ್ತು. What is the conclusion he says?
my lord, conclusion that my lord, ಆ ಹುಡುಗ 4-5 ಹೆಜ್ಜೆ ಮುಂದೆ ಬಂದು ಫುಟ್ಪಾತ್ ನಿಂದ ಕೆಳಗೆ ಬಕಡೆ ಬಿದ್ದಿರೋ ವಿಡಿಯೋ ಇರುವುದು ಕಂಡು ಬಂದಿರುತ್ತೆ. ದಿನಾಂಕ 31/12/2023 4:40 4:45 ಗಂಟೆವರೆಗಿನ ಸಿಸಿ ಫುಟೇಜ್ ಗಳನ್ನು ಬೇರೆ ಬೇರೆಯಾಗಿ ಮೈ ಪ್ರೆಸೆನ್ಸ್ ವಾಸ್ ರೆಕಾರ್ಡೆಡ್ at about 4:40 to 4:45 AM. Malad, as per the charge sheet, Malad, the incident is on 12.
Why you have not produced the entire charge sheet? Why are you relying on a single
Malad,
part of it?
Malad, because Malad, I have obtained the charge sheet later.
Maybe.
I am furnishing the certificate.
No, you furnish the entire charge sheet.
Kindly out on Monday. I will furnish today.
Counsel for the petitioner, after addressing the argument for some time, seeks time to produce entire charge sheet.
Number
Yes.
22, Venkatesh Ketty.
22,
Serial number 22, Venkatesh Ketty.
counsel for the petitioner is absent, no representation. Next,
Serial number 23, Arjun. 24, M. Krishna Gowda.
absent, no representation. Next. Hmm? Counsel for the petitioner is absent, no representation. Even on the last date of hearing, there was no representation. No, even better. First. On the last hearing, counsel for the petitioner had sought for time. I do not find any reason to adjourn the matter, however, to offer final opportunity this time. ಅದರಲ್ಲೂ ಸೇಮ್ ನೋಡ್ಕೊಳ್ಳಿ, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಕೊಂಡು. Yes, 25.
Number 25, Tigadi Virana.
Yes,
According to the prosecution, my lord, as on the date of offense, the victim girl was aged about 15 years, 9 months. At the same
no, how
time,
many accused are there?
there are 2 accused, my lord. As far as second accused concerned, it's only 363. He has been granted bail by trial, my lord. As far as POCSO is concerned, only petitioner has been charged.
When he was arrested?
My lord, he was arrested on 22/9/2023.
Charge sheet is already filed.
Charge sheet has already been filed.
You have not produced it.
Of course, sir.
Hmm.
It was only
I have to produce, sir, when the charge sheet is filed.
Yes, then your lordship may kindly have it tomorrow. I will produce it. Today itself, I will produce it.
Place for time. Next.
Serial number 26, Prasanna DP.
May I request my lordship to kindly pass over proxy.
Pass over.
Serial number 27, Aisha Unisa.
The 439 application for the offense punishable under section 302, 201 and 34 of IPC.
Petitioner is?
Petitioner is raised as accused number 2. Totally 3 accused persons are on.
What about A1 and 3?
A1 is arrested, he's also in custody.
Hmm.
And 3 was absconded. And presently, I don't know whereabouts, whether he has been, but split up charge sheet is filed against the accused person, accused number 3. So date of arrest is 21/12/2023, Your Honor.
Who is the deceased?
This is the one of the retired, that is the teacher, Your Honor, high school
Name?
teacher,
Name.
Nagaraj. He belongs to Nanjangud
Who
town.
is the complainant?
Complainant is his son by a name Anup Kumar. Again,
There are eyewitnesses.
no eyewitnesses, Your Honor. Only on the basis of the voluntary statement and when they were in custody, the statement has been recorded. After the date of incident, it is after lapse of 5 months.
What are the circumstances relied on by the prosecution?
Actually, it is a superstitious, Your Honor, wherein
What are the circumstances?
circumstances, I'll just read out the charge sheet, Your Honor.
You do not know what are the circumstances relied on by the prosecution?
Circumstances, actually, they are alleging on the accused number 2, stating that he has helped accused number 1 in doing this
Sir,
incident.
you said there are no eyewitnesses.
No eyewitnesses, Your Honor.
So the charge sheet is already filed.
Already filed.
The prosecution is relying on circumstantial. evidence.
Circumstantial evidence.
What are those circumstantial evidence?
Circumstantial, they have recovered knife along with the mobile phones
Recovered from you
from the place of incident,
at your instance.
in my presence, according to the charge sheet. After the arrest and when you were in
As
custody.
per the charge sheet itself, I am asking you.
No, that is what.
Ah.
ಇಲ್ಲೇನಾಗಿದೆ, ಅವ್ರು ಅರೆಸ್ಟ್ ಮಾಡಿದ ನಂತರ ಇದೆಲ್ಲ 5 ತಿಂಗಳಾದ್ಮೇಲೆ ಎಲ್ಲ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್
ನಿಮ್ಮನ್ನ
ತಗೊಂಡಿದ್ದಾರೆ.
ಅರೆಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ರಿಕವರಿ ಆಗ್ಬೇಕಲ್ಲ?
Yes.
Ah.
I do agree, Your Honor.
So knife, mobile were recovered at your instance.
Yeah, of course.
Then
And that also, it is not my personal mobile.
that is the only.
That is only to
recovery?
the accused number 1.
That is the only circumstance.
That is the only circumstantial evidences. Along with that, there are almost
There is one eyewitness, CW20.
CW.
The last seen witness,
Hmm?
last seen witness.
CW20.
CW20 is the person, my lord, who has seen these accused persons taking the deceased person in the car.
Yes, Your Honor. I sing one eyewitness. It is witness of CW20, Your Honor.
Yes, ಅಂತಂದ್ರೆ you are not giving the judgment against me.
Yes, sir.
It is your duty to
Yes, sir.
find out.
Actually, it's
ನಾನು ಹೇಳಿದ್ಮೇಲೆ yes, you are right ಅಂತ ಅಂದಂಗ ಆಯ್ತು.
ಅಲ್ಲ, ಇದು ನಮ್ ಕೊಲೀಗ್ ಫೈಲ್ ಅವರು ಬರಕಾಗ್ಲಿಲ್ಲ ಅನ್ಬಿಟ್ಟು ನಾನು ಅಪೇರ್ ಆಗಿ. Yes, she has to
Before
confirm.
you stand up before the
Yes,
court,
yes.
you should be thorough with the facts. ಸುಮ್ನೆ ಏನ್ ಹೇಳಿದ್ರು ಇಲ್ಲಿ ಅಲೋ ಆಗುತ್ತೆ ಅಂತ ಡೋಂಟ್ ಬಿ ಅಂಡರ್ ದಟ್
No, no.
ಇಂಪ್ರೆಷನ್. Yes,
Lordship, I want to draw your attention to the charge sheet. That is page number 46 here. Page number 46
Hmm.
of charge sheet. I
yes.
read with the facts of the case. ಈ ದೋಷಾರೋಪಣಾ ಪತ್ರದ ಕಾಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಒಂದೇ ಆರೋಪಿ ಈ ದೋಷಾರೋಪಣಾ ಪತ್ರ ಕಾಲಂ 14ನಲ್ಲಿ ಸಾಕ್ಷಿ 4 ದಟ್ ಇಸ್ ವೈಫ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ರವರು ಮದುವೆಯಾಗಿದ್ದು ಈ ದಂಪತಿಗೆ 10 ವರ್ಷ ಕುಶಾಲ ಎಂಬ ಮಗಳಿರುತ್ತಾಳೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಮೃತಪಟ್ಟಿರುವ ನಾಗರಾಜುರವರು ಸಾಕ್ಷಿ 4ರವರ ತಾಯಿಯ ತಂಗಿ ಗಂಡ ಆಗಿರುತ್ತಾರೆ. ಮೃತ ನಾಗರಾಜು ಎನ್ರವರು ಮಗಳು ಸಾಕ್ಷಿ 2 ಅನುಷರವರಿಗೆ ಸಾಕ್ಷಿ 13 ರಕ್ಷಿತ್ ಎಂಬುವರ ಜೊತೆ ಮದುವೆ ನಿಶ್ಚಯವಾಗಿರುತ್ತದೆ. ಒಂದೇ ಆರೋಪಿಯು ಸಾಕ್ಷಿ 2 ಅನುಷರಗಳನ್ನು ಇಷ್ಟಪಟ್ಟು ಆಕೆಯ ವರಿಸಿಕೊಳ್ಳುವ ಸಲುವಾಗಿ ಆಕೆಯ ಜೊತೆ ಕಳೆದ 2 ವರ್ಷಗಳಿಂದ ತನಗೆ ಸಾವಿರಾರು ಕೋಟಿ ಹಣ ಬರೋದಿದೆ. ನೀನು ತುಂಬಾ ಬುದ್ಧಿವಂತೆ, ರೂಪವಂತೆ. ನಾನು ನನ್ನ ಹೆಂಡತಿ ಡೈವರ್ಸ್ ನೀಡುತ್ತೇನೆ. So the accused number is 1 is telling to the that is CW2, that is the daughter of the Nagaraju, wherein he is in love with the this witness CW2. ನಿನ್ನ ಜೊತೆಗಿರಬೇಕು ಎಂದು ಹಲವಾರು ಬಾರಿ ತಿಳಿಸಿರುತ್ತೇನೆ. ಸಾಕ್ಷಿ 2 ಅನುಷರವರಿಗೆ ಸಾಕ್ಷಿ 13 ರಕ್ಷಿತ್ ಎಂಬುವರ ಜೊತೆ ಮದುವೆ ನಿಶ್ಚಯವಾಗಿದ್ದರೂ ಸಹ ಅನುಷಳನ್ನು ವಶೀಕರಣ ಮಾಡಿಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದ ಪ್ರಕರಣದ ದಾಖಲಾದ 3 ತಿಂಗಳ ಹಿಂದೆ ತುಮಕೂರು ಜಿಲ್ಲೆ ಶಗಡು ಎಂಬ ಗ್ರಾಮದಲ್ಲಿ ಭೂತಸ್ವಾಮಿ ದೇವಸ್ಥಾನಕ್ಕೆ ಒಂದನೇ ಆರೋಪಿಯು ಮೂರನೇ ಆರೋಪಿಯ ಜೊತೆ ಹಲವಾರು ಬಾರಿ ಭೇಟಿ ನೀಡಿ ಸಾಕ್ಷಿ 17ರಿಂದ ಅನುಷಳ ವಶೀಕರಣದ ಪೂಜೆಯನ್ನು ಮಾಡಿಸಿಕೊಳ್ಳುತ್ತಾರೆ. ಈ ಪೂಜೆ ಪರಿಣಾಮಕಾರಿ ಆಗದಿದ್ದಾಗ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳು ಸಾಕ್ಷಿ 17ರವರಿಗೆ ನೀವು ಪೂಜೆ ಫಲಿಸಲಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದ್ದು ಸಾಕ್ಷಿ 17ರವರು ಸೂಚನೆಯಂತೆ 1 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು 2ನೇ ಆರೋಪಿಯಿಂದ ಕುದುರೆ ರಕ್ತವನ್ನು ಪಡೆದುಕೊಂಡು ಮೇಲ್ಕಂಡ ಭೂತಸ್ವಾಮಿ ದೇವಸ್ಥಾನದಲ್ಲಿ ವಶೀಕರಣದ ವಾಮಾಚಾರದ ಪೂಜೆಯನ್ನು ಮಾಡಿಸಿರುತ್ತಾರೆ. ಹಾಗೂ 1ನೇ ಆರೋಪಿ ಸಾಕ್ಷಿ 19ರ ರವಿಪ್ರಸಾದ್ ರವರ ಜೊತೆ ಕರೆದುಕೊಂಡು ಭಾರತದಲ್ಲಿಯೇ ವಶೀಕರಣ ಪೂಜೆಯ ಪ್ರಸಿದ್ಧವಾದ ಅಸ್ಸಾಂ ರಾಜ್ಯದ ಕಾಮುಖ್ಯ ದೇವಿಯ ದೇವಸ್ಥಾನಕ್ಕೆ ದಿನಾಂಕ 8/7/2023 ಹೋಗಿ ಅಘೋರಿಗಳಿಂದ ಅನುಷಳ ವಶೀಕರಣ ಪೂಜೆಯನ್ನು ಹಾಗೂ ಕಾಶಿ ವಾರಣಾಸಿಗಳಲ್ಲಿ ಕಳೆದ 1 ವರ್ಷ ಹಿಂದೆ ಹೋಗಿ ಹಲವಾರು ವಶೀಕರಣದಂತಹ ಪೂಜೆಗಳನ್ನು ಕೂಡ ಮಾಡಿಸಿರುತ್ತಾರೆ. ಪ್ರಕರಣದ ದಾಖಲಾದ 5-6 ತಿಂಗಳ ಹಿಂದಿನಿಂದಲೂ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು ಬಳಿ 1ನೇ ಆರೋಪಿಯು ನಾನು ಹೊಸದಾಗಿ ಕಂಪನಿ ಒಂದು ಸ್ಥಾಪನೆ ಮಾಡುತ್ತೇನೆ, ಹಣ ಹೂಡಿಕೆ ಮಾಡಿ ಕೋಟಿಗಟ್ಟಲೆ ಹಣ ಸಂಪಾದಿಸುವುದನ್ನು ಬಿಟ್ಟು ಲಕ್ಷ ಹಣ ಸಿಗುವ ಕಡೆ ಅನುಷಾ ಯಾಕೆ ಕೆಲಸಕ್ಕೆ ಹೋಗಬೇಕು, ಬದಲಾಗಿ ಅನುಷಾ ನಾನು ಸ್ಥಾಪಿಸುವ ಕಂಪನಿಯನ್ನು ಮತ್ತು ನನ್ನ ಮಗಳನ್ನು ಕುಶಾಳನ್ನು ನೋಡಿಕೊಂಡು ಜೊತೆಯಲ್ಲೇ ಇರುವಂತೆ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರನ್ನು ಒಪ್ಪಿಸಿದ್ದಾಗ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು 1ನೇ ಆರೋಪಿ ಬೇಡಿಕೆಯನ್ನು ನಿರಾಕರಿಸಿ ರಕ್ಷಿತ್ನೊಂದಿಗೆ ಮದುವೆಯಾದ ಫಾರಿನಿಗೆ ಹೋಗಿ ಹೈಯರ್ ಸ್ಟಡೀಸ್ ಅನ್ನು ಮಾಡಿಕೊಂಡು ಅಲ್ಲೇ ಸೆಟಲ್ ಆಗುವುದಾಗಿ ಹೇಳುತ್ತಾರೆ. ಅನುಷಳ ಮೇಲೆ 1ನೇ ಆರೋಪಿಯು ವಿಪರೀತ ವ್ಯಾಮೋಹವನ್ನು ಇಟ್ಟುಕೊಂಡು ಆಕೆಯ ರಕ್ಷಿತ್ ರವರೊಂದಿಗೆ ಮದುವೆಯಾಗಿ ಫಾರಿನಿಗೆ ಹೋಗುವುದನ್ನು ಯಾವ ರೀತಿ ತಪ್ಪಿಸಬಹುದೆಂದು ಯೋಚಿಸಿ ಅನುಷಳನ ತಂದೆ ನಾಗರಾಜರನ್ನು ಮುಗಿಸಿದರೆ ಅನುಷಳ ತಾಯಿ ಒಂಟಿಯಾಗುವುದರಿಂದ ಅನುಷಳ ತಾಯಿಯನ್ನು ಒಂಟಿಯಾಗಿ ಬಿಟ್ಟು ಫಾರಿನಿಗೆ ಹೋಗಿ ನಿರ್ಧಾರವನ್ನು ಕೈ ಬಿಟ್ಟು ಆಕೆಯ ತಾಯಿಯ ಜೊತೆ ಇಲ್ಲಿಯೇ ಉಳಿದುಕೊಳ್ಳುತ್ತಾಳೆ ಎಂಬ ಪ್ಲಾನ್ ಮಾಡಿಕೊಂಡು ನಾಗರಾಜುರವರ ಚಲನವಲನದ ಬಗ್ಗೆ ನಿಗಾ ವಹಿಸಿ ಕಾರಣಕ್ಕೆ ದಿನಾಂಕ 21/7/2023ರಿಂದ 23/7/2023ರವರೆಗೆ ಕರ್ತವ್ಯಕ್ಕೆ ರಜೆಯನ್ನು ಪಡೆದು ನಾಗರಾಜುರವರನ್ನು ಚಲನವಲನ ಬಗ್ಗೆ ನಿಗಾ ವಹಿಸಿ ದಿನಾಂಕ 22/7/2023ರಂದು 6 ಗಂಟೆ ಸಮಯಕ್ಕೆ 1ನೇ ಆರೋಪಿಯು 2 ಮತ್ತು 3ನೇ ಆರೋಪಿತರವರನ್ನು ನಂಜನಗೂಡು ಟೌನ್ ಖಾಸಗಿ ಬಸ್ ನಿಲ್ದಾಣದ ಸಮೀಪ ಅಂಬೇಡ್ಕರ್ ಸರ್ಕಲ್ ಬಳಿಗೆ ಕರೆದುಕೊಂಡು ಅವರುಗಳಿಗೆ ತಾನು ನಾಗರಾಜು ರವರನ್ನು ಮುಗಿಸಬೇಕು ವಿಷಯವನ್ನು ತಿಳಿಸಿ 1ನೇ ಆರೋಪಿಯು 2ನೇ ಆರೋಪಿಗೆ ಹಗ್ಗ ಮತ್ತು ಚಾಕುವನ್ನು ತರಲು ತಿಳಿಸಿದ್ದು ಅದರಂತೆ 2ನೇ ಆರೋಪಿ ಬಜಾರ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಸಾಕ್ಷಿ 21ರವರ ಅಂಗಡಿಯಲ್ಲಿ ಹಗ್ಗವನ್ನು ಖರೀದಿಸಿ ಹಾಗೂ ನೆಹರು ಸರ್ಕಲ್ನಲ್ಲಿ ಸಂಜೆ ಸಮಯದಲ್ಲಿ ನಿಲ್ಲಿಸಿ ಹೋಗುವ ತಳ್ಳುವ ಗಾಡಿನಲ್ಲಿಟ್ಟಿದ್ದ ಒಂದು ಚಾಕುವನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದಿದ್ದು ನಂತರ 3 ಜನ ಆರೋಪಿಗಳು 1ನೇ ಆರೋಪಿಯ ಬಾಪ್ತು KA 04 MP 0845 ಸ್ಕೋಡಾ ರ್ಯಾಪಿಡ್ ಕಾರನ್ನು ನಿಲ್ಲಿಸಿಕೊಂಡು ನಾಗರಾಜುರವರು ಕೊಲೆ ಮಾಡುವ ಸಾಮಾನ್ಯ ಉದ್ದೇಶದಿಂದ ನಾಗರಾಜುರವನ್ನು ಬರುವಿಕೆಯನ್ನು ಕಾಯುತ್ತಿದ್ದಾಗ ಅದೇ ದಿನ 6:30 ಗಂಟೆ ನಾಗರಾಜುರವರು ಉಮ್ಮತ್ತೂರಿನಿಂದ ನಂಜನಗೂಡು ಟೌನಿಗೆ ಬಂದು ಸರ್ಕಾರಿ ಬಸ್ ಇಳಿದು ದಾರಿಯಲ್ಲಿ ಬಂದು ಒಂದು ತಳ್ಳುವ ಗಾಡಿಯಲ್ಲಿ ತರಕಾರಿ ತೆಗೆದುಕೊಂಡು ಮಳೆ ಬರುತ್ತಿದ್ದ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಕಡೆ ಹೋಗುತ್ತಿದ್ದಾಗ 1ನೇ ಆರೋಪಿಯು ನಾಗರಾಜುರವರನ್ನು ಕಾರಿನಲ್ಲಿ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಬಿಡುವುದಾಗಿ ತಿಳಿಸಿ ಮೇಲ್ಕಂಡ ಕಾರಿನ ಹಿಂಭಾಗದ ಸೀಟಿಗೆ ನಾಗರಾಜುರವನ್ನು ಹತ್ತಿಸಿಕೊಂಡು ಅವರ ಬಲ ಮತ್ತು ಎಡ ಕಡೆ 1ನೇ ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ಕುಳಿತುಕೊಂಡಿರುತ್ತಾರೆ. 3ನೇ ಆರೋಪಿಯು ಕಾರನ್ನು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೊರಟು ಹೆಜ್ಜಿಗೆ ಮಾರ್ಗವನ್ನು ಹೋಗುತ್ತಿದ್ದಾಗ ಮಾರ್ಗ ಮಧ್ಯೆ ಈ 1ನೇ ಆರೋಪಿ ಮತ್ತು ನಾಗರಾಜುರವರು ಅನುಷಳನ್ನು ಮದುವೆ ಮಾಡಿಕೊಡುವಂತೆ ಕೇಳಿದ್ದು ನಾಗರಾಜುರವರು ಒಪ್ಪದೆ ಕೂಗಾಟ ಮಾಡಿದಾಗ 1ನೇ ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ನಾಗರಾಜುರವರನ್ನು ಕುತ್ತಿಗೆಯನ್ನು ಹಗ್ಗವನ್ನು ಹಾಕಿ ಜೋರಾಗಿ ಎಳೆದಿದ್ದು ಇದರಿಂದ ನಾಗರಾಜುರವರನ್ನು ಜ್ಞಾನ ತಪ್ಪಿ ಹೋದಾಗ ಅವರ 2 ಕೈಗಳನ್ನು ಟವಾಲ್ನಿಂದ ಕಟ್ಟಿ ಹಾಕಿ ಅಲ್ಲಿ ಇಲ್ಲಿ ಸುತ್ತಾಡಿಕೊಂಡು ರಾತ್ರಿ 9 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ವರುಣಾ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದು ದೇವಲಪುರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 41/1ರ ಜಮೀನ್ ನೇರ ಕೂಡನಹಳ್ಳಿ ರಸ್ತೆಯಲ್ಲಿ ಕಾರನ್ನು ನಿಲ್ಲಿಸಿಕೊಂಡು ನಾಗರಾಜುರವರನ್ನು 1, 2 ಮತ್ತು 3ನೇ ಆರೋಪಿತರನ್ನು ಕಾರಿನಿಂದ ಹೊರಗೆ ಎತ್ತಿಕೊಂಡು ರಸ್ತೆ ಪಕ್ಕದಲ್ಲಿ ಜಮೀನಿನ ಮಲಗಿಸಿ ನಂತರ 1ನೇ ಆರೋಪಿ 2ನೇ ಆರೋಪಿಗೆ ಕಾರಿನಲ್ಲಿದ್ದ ಚಾಕುವನ್ನು ನೀಡಿ ನಾಗರಾಜುರವರನ್ನು ಕುತ್ತಿಗೆಯನ್ನು ಕೊಯ್ಯುವಂತೆ ತಿಳಿಸಿದ್ದು ಅದರಂತೆ 2ನೇ ಆರೋಪಿ ಚಾಕುವಿನಿಂದ ದಿಸ್ ಇಸ್ ದಿ ಅಲಿಗೇಷನ್ ಚಾಕುವಿನಿಂದ ನಾಗರಾಜುರವರ ಕುತ್ತಿಗೆಯನ್ನು ಕೊಯ್ದ ಮೇಲೆ ಮಾಡಿ ಕೃತ್ಯಕ್ಕೆ ಉಪಯೋಗಿಸಿದ ಚಾಕುವನ್ನು ಅಲ್ಲೇ ಪಕ್ಕದ ಬೇಲಿಯಲ್ಲಿ ಬಿಸಾಡುವುದನ್ನು ಹಾಗೂ ಒಂದೇ ಆರೋಪಿ ಮೃತ ಬಾಪ್ತು ಮೊಬೈಲ್ ಮತ್ತು ಇತರೆ ಚೀಟಿಗಳನ್ನು ನಂಜನಗೂಡು ಟೌನಿನಲ್ಲಿ ಹರಿಯುವ ಕಬಿನಿ ನಾಲೆಗೆ ಎಸೆದು ಸಾಕ್ಷ್ಯದಾರಗಳನ್ನು ನಾಶ ಪಡಿಸುವುದನ್ನು ಹಾಗೂ ಮೂರನೇ ಆರೋಪಿ ಕೃತ್ಯ ಸಮಯದಲ್ಲಿ ಕಾರು ಚಾಲನೆ ಮಾಡಿ ನಾಗರಾಜರವರನ್ನು ಕೊಲೆ ಮಾಡುವ ಒಂದೇ ಆರೋಪಿಗೆ ಸಹಕರಿಸುವ ಇಂದುವರೆಗೆ ತನಿಖೆ ದೃಢಪಟ್ಟ ಮೇರೆಗೆ ಆರೋಪಿತ ವಿರುದ್ಧ 302, 201 ದೋಷಾಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿದೆ.
Where is the PM report?
So the medical opinion is that the death is caused due to the strangulation along with the cut injury on the neck, Your Honor.
How many external injuries? Multiple stab injury. Ligature mark is also there.
This is a cut injury.
They try to strangulate my lord.
Even according to the medical report, the deceased was consuming the alcohol, Your Honor. At the time of incident, he has consumed the alcohol. Actually, he is a money lender after his retirement. He is a money lender, Your Honor. So those things are not brought on record. He used to have a collection in the evening time, and he used to go to his native place, that is Ummatur, Chamarajanagar district.
Yes, serious allegations against accused number 2. You played the active role, both in strangulating and also stabbing.
According to the prosecution, everything is matter of evidence, Your Honor.
Yes, that is what I'm saying.
That is what.
Go for trial. Go for trial, wait for some time.
You just, if you go through the distinct statements of each and every complaint witnesses,
Everything is.
ಇರಬಹುದು ಅಂತಾನೆ ಅವರು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. So there is no ill motive or intention behind this
Circumstantial.
murder case, Your Honor. Only on the basis of circumstantial and voluntary statement of the accused person after the arrest,
Recovery of the.
what they have made.
incriminating material. Recovery of the incriminating materials, which correspond with the injuries on the dead body.
You're well aware of the fact that according to
It's the
section
strongest-
26 to 29 of Evidence Act, we cannot appreciate in any circumstance, Your Honor.
This is not the time to appreciate the
No, no,
evidence, sir.
It's my humble submission
Then
because
just
he is
to
the only
appreciate-
breadwinner of the family. ಇಬ್ರು ಮಕ್ಕಳು ಶಾಲೆಗೂ ಸಹ
ಇದೆಲ್ಲ
ಸೇರಿದ್ರು.
ಬರಲ್ಲ.
He is a very poor person.
ಇಬ್ರು ಮಕ್ಳು ಇರ್ಲಿ 10 ಜನ ಇರ್ಲಿ, it is not a matter to be. taken into
Actually,
consideration.
ಅವನು ಅವತ್ತಿನ ದಿನ ಇರ್ಲಿಲ್ಲ ಅಂತಾನು ಅವನು ದೇವಸ್ಥಾನಕ್ಕೆ actually ಅಲ್ಲಿ ಕುದುರೆ ನಿಲ್ಸ್ತಾನಲ್ಲ ಆ ಸಂದರ್ಭದಲ್ಲಿ
It is
ಬೇರೆ
all your defense that cannot be taken into consideration.
he is a poor person, Your Honor.
Petitioner,
Liberty may be given to file before the committal court. ಇವಾಗ ಕಮಿಟಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ JMFC ಕೋರ್ಟ್ ಇಂದ
ಅದೇನು, that will not make any change.
ಕಮಿಟಲ್ ಸಹ ಆಗಿದೆ ಈಗ.
Petitioner is being accused number 2 is seeking grant of bail. He was apprehended on 21/12/2023. Since then, he is in judicial custody. The son of the deceased lodged first information on the death of his father Nagraj. CW20. And after investigation, charge sheet is filed. Even though there are no eyewitnesses to the incident, CW20 is the witness who saw the deceased lastly in the company of the accused. They have taken him in the car. It is stated that accused number 1 was having the vote to marry the daughter of the deceased CW2. And in that regard, the accused have taken the deceased in the car. And accused number 1 demanded to get him married to the daughter. When he refused to do so, it was accused number 1 and 2 who strangulated his neck with a rope, and later the petitioner, accused number 2, stabbed him repeatedly. As per PM report, there were multiple stab injuries found on the dead body, and the ligature marks are also same. As per the final opinion by the medical officer who conducted postmortem examination, the death was due to asphyxia as a result of ligature strangulation with hemorrhage and showed SHODE as a result of chop injury sustained to the neck. The materials collected by the investigating officer. It is stated that the knife used in commission of the offense and the mobile handset were recovered at the instance of the present petition. There are strong prima facie materials against the petitioner for having committed the offense. The offense in question is punishable either with the death or imprisonment for life. In view of the above, I am of the opinion that the petitioner is not entitled. Yes, dismissed.
Serial number 28, yes, Praveen.
Yes. Yes, who is the petitioner?
Notice
You know,
2 weeks time for argument.
you are seeking time.
Yeah.
Praise for time. Next.
Serial number 29, Basuraju TA.
My lord, I'm proxy counsel, it may be passed over.
Pass over. Then
Serial number 30, Arjun, 31, Nanjundagowda MR.
Petitioners. Alleged of, in total, there are 3 accused. All the 3 accused are before my lords.
A 1 to 3.
Please.
Hmm.
438 petition.
Yes.
Alleged offense under section 354B, 504, 506, read with 34 of the Penal Code, and section 67A of Information Technology Act.
Who is the complainant?
Complainant is one Pallavi Mel, who is a stranger to all the 3 petitioners.
What is the allegation?
Allegation against the petitioners are this, my lord, that the complaint has approached.
Come to page number 9.
Please. Column number 10. May I read, please?
Yes.
ದಿನಾಂಕ 15/3/2024 ಸಂಜೆ 5 ಗಂಟೆಗೆ ಫಿರ್ಯಾದಿ ಕೋಣನಬೆಲೆ ಗ್ರಾಮದ ಪಲ್ಲವಿ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನೀಡಿದ ಲಿಖಿತ ದೂರಿನಲ್ಲಿ ನಾನು ನಮ್ಮ ಜಮೀನಿನ ಕಾಗದ ಪತ್ರಗಳನ್ನು ಹುಡುಕಿಸಿಕೊಟ್ಟು ನನಗೆ ನಮ್ಮ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಲು ಜಮೀನಿನ ಹಕ್ಕು ಕೊಡಿಸುವುದಾಗಿ ನಾಗನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿಯಾದ ವೆಂಕಟೇಶ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಪೆಟಿಷನ್ ನಂಬರ್ 1 ಮಿನ್ ಮುನಿಯಪ್ಪ ಮತ್ತು ಮೂರ್ತಿ ಪೆಟಿಷನ್ ನಂಬರ್ 2 ಮಿನ್ ಲೇಟ್ ಬಯ್ಯಣ್ಣ ಎಂಬುವರನ್ನು ನನ್ನನ್ನು ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಓಡಾಡಿಸಿಕೊಂಡು ನನ್ನನ್ನು ಲೈಂಗಿಕವಾಗಿ ಬಳಸಿಕೊಂಡು ನಮ್ಮ ಜಮೀನನ್ನು ಬೇರೆಯವರಿಗೆ 90 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಮಾತನಾಡಿಕೊಂಡು ನನಗೆ ಕೊಡಿಸುತ್ತೇನೆಂದು ಸುಳ್ಳು ಹೇಳಿಕೊಂಡು ನನ್ನನ್ನು ನಾಗನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ವೆಂಕಟೇಶನ ಮನೆಗೆ ಕರೆಸಿಕೊಂಡು ಮೂರ್ತಿ ಹೇಳಿದಂತೆ ನಾನು ಕೇಳದಿದ್ದರೆ ನನ್ನ ನಗ್ನ ಫೋಟೋಗಳನ್ನು ಎಲ್ಲಾ ಕಡೆ ಅಂಟಿಸುವುದಾಗಿ ನನಗೆ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ನಾನು ಒಬ್ಬಳೇ ಓಡಾಡುವಾಗ ನನ್ನ ಮೇಲೆ ಆಸಿಡ್ ಹಾಕುವುದಾಗಿ ಹೆದರಿಸುತ್ತಾರೆ. ಮೂರ್ತಿ ವೆಂಕಟೇಶ್ ಮೂರ್ತಿಯ ಪತ್ನಿಯಾದ ಪದ್ಮಮ್ಮ ಪೆಟಿಷನ್ ನಂಬರ್ 3 ನನಗೆ ಭಾರಿ ಕಿರುಕುಳ ನೀಡಿರುತ್ತಾರೆ. ವೆಂಕಟೇಶನ ಪತ್ನಿಯಾದ ಅಶ್ವಿನಿ ಅವರು ತುಂಬಾ ಕೆಟ್ಟ ಪದಗಳಿಂದ ಬೈದಿರುತ್ತಾರೆ. ಸದರಿಯವರ ಈ ರೀತಿ ಕಿರುಕುಳದಿಂದ ನಾನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿರಲು ಓಡಾಡಲು ಭಯವಾಗುತ್ತಿದ್ದರೆ ಎಂಬುವರಿಂದ ತಾಲೂಕು ರೆಕಾರ್ಡ್ ರೂಮಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು ನನಗೆ ಇಲ್ಲ ಸಲ್ಲದ ಆಮಿಷಗಳನ್ನು ಒಡ್ಡಿ ನನ್ನನ್ನು ಎಲ್ಲಾ ರೀತಿಯಲ್ಲೂ ಬಳಸಿಕೊಂಡು ಈಗ ನನಗೆ ಮೂರ್ತಿ ಮತ್ತು ವೆಂಕಟೇಶ್ ಅವರು ಅವರ ಮನೆಗೆ ಕರೆದು ಕಿರುಕುಳ ಕೊಡುತ್ತಿರುತ್ತಾರೆ. ನಾನು ಮೇಕಪ್ ವಿಷಯಕ್ಕೆ ಮೈಸೂರು ಮತ್ತು ಹುಬ್ಬಳ್ಳಿಗೆ ಹೋದಾಗ ಅಲ್ಲಿ 2 ರೂಮ್ ಮಾಡಿದ್ರು. ಮೇಕಪ್ ಮುಗಿಸಿ ನನ್ನ ಮೇಲೆ ಕಿರುಕುಳ ಕೊಟ್ಟಿರುತ್ತಾನೆ ಮತ್ತು ಅಲ್ಲಿಂದ ಮನೆಗೆ ಬಂದಾಗ ಮತ್ತೆ ಮೂರ್ತಿ ಕರೆ ಮಾಡಿ ಮನೆಗೆ ಬನ್ನಿ ಎಂದು ಫೋನ್ ಸೋನ್ಸೋದಿಂದ ಕರೆ ಮಾಡಿರುತ್ತಾನೆ. ವೆಂಕಟೇಶ್ ಮತ್ತು ಮೂರ್ತಿರವರು ನನ್ನನ್ನು ಹೇಳಿದ ಹಾಗೆ ಕೇಳಲಿಲ್ಲವೆಂದರೆ ನಿನ್ನ ಫೋಟೋಗಳನ್ನು ಕಳಿಸುತ್ತೇನೆಂದು ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಮೂರ್ತಿ, ವೆಂಕಟೇಶ್, ಪದ್ಮಮ್ಮ, ಅಶ್ವಿನಿರವರ ಮೇಲೆ ಕಾನೂನು ರೀತಿ ಕ್ರಮ ಜರುಗಿಸಲು ಕೋರುತ್ತೇನೆ. ನನ್ನ ಫೋಟೋಗಳನ್ನು ಮೂರ್ತಿ ಮತ್ತು ವೆಂಕಟೇಶ್ ಇನ್ಸ್ಟಾಗೆ ಹಾಕುತ್ತೇನೆಂದು ನನ್ನ ಹಾಗೂ ನನ್ನ ಮಕ್ಕಳಿಗೆ ಬೆದರಿಕೆ ಹಾಕಿದ್ದರಿಂದ ಈ ದಿನ ದೂರು ನೀಡಲು ತಡವಾಗಿ ಅಂತ ಇತ್ಯಾದಿಯಾಗಿ ನೀಡಿದ ದೂರಿನ ಮೇರೆಗೆ Last may kindly see the complaint is vague. There is no specific date as to mentioned in the complaint below. But in column number 3 of the FIR, the alleged incident is from 1/6/2023 to 15/2/2024, please.
Yes.
The fact remains this, my lord. My lords may kindly turn to page number 20. Page number 20, my lord, wherein the second petitioner had given a representation to Tahsildar Devnalli for construction of public library and meditation center in his village. A person who are inimically disposed towards the petitioners through this complaint has foisted a false complaint against
Who
this.
complainant is related to this?
She is nowhere connected.
Then
And
how can you relate this?
no, that being the reason, my lord, because she is nowhere known to any of the petitioners.
Why she should make a false allegation, that to such allegations?
Please, my lord. People who are inimically disposed towards the petitioner.
Can you believe that a lady can make such harsh allegations? Huh?
Yes, my lord. The complaint hails from a different
I
village.
can understand if
Please.
she makes some other allegations of assault, something, I can understand, not these type of allegations.
Complaint, my lord.
No, such,
Even to attract the provisions of 354B, my lord.
she is aged 28 years.
Please, my lord.
Then
But petition number 2 is aged on
You should
56, my lord. And petition number 3, my lord, she is a wife of petition number 2, my lord. A person, any man or any wife would not ask his husband to go have sexual intercourse and to threaten her to post up images on social media or elsewhere.
No, sir, sorry. They labor Allah. 438, you are not entitled.
At least to respect to petition number 3, my lord.
No, nothing. She has also actively participated. No.
I
Yes, accused number 1.
make a submission. I may
Yes.
permit to withdraw.
Huh?
I may permit it to withdraw, please.
Withdrawing.
Please.
Counsel for the petitioner, after addressing the argument for some time, seeks permission to withdraw the petition. Submission is placed on record, petition dismissed as withdrawn.
Obliged.
Next.
Number 32, Rajeshwari M.
petition, madam.
Yes.
On behalf of accused number 12, 13, 15, and 16. For the offense punishable under section 312, 314, 315.
They are accused number 1, 2,
12, 13, 15, and 16.
accused number
12, 13, husband and wife, 15, 16.
1 is 12, 13 ಅಂತ ಹಾಕಿದ್ದೀರಿ.
12, 13, 15, and 16, please.
ಅದು 1 ಎಲ್ಲಿದೆ?
Please, ma'am. For the offense punishable under section 3.
In all, how many accused?
There are totally 17 accused. Ma'am.
When these petitioners were arrested?
No, it's a 438 petition, madam.
438.
Yes.
32 ಅಲ್ವಾ? 439 ಆಗಿದೆ. Cause list ಅಲ್ಲಿ 439 ಅಂತ ಇದೆ.
438.
Number 438 also. 438 ಅಲ್ಲ 439. Yes.
Yes, madam. As per the complaint amendments, madam, initially the complaint was lodged on 15/10/2023. Complaint is lodged by the district health officer. Welfare officer. Somoto complaint upon the Somo. The complaint is at page number 13, my lord, please.
Who is the complainant?
Complainant is a officer, district family welfare officer. And this FIR is initially the FIR was lodged at Bangalore in crime number 257/23. And upon the voluntary statements of accused number 192, FIR 65/24 of Udayagiri police has been lodged, my lord. Only on the statement of accused number 192, please. The complaint reads as follows, my lord. At page number 13, ದಿನಾಂಕ 15/10/23 ಮಧ್ಯಾಹ್ನ page number 13, my lord, please.
You come to page number 11, gist of the complaint.
ಫಿರ್ಯಾದಿಯಾದ ಜಿಲ್ಲಾ ಕುಟುಂಬ ಕಲ್ಯಾಣಾಧಿಕಾರಿ, ಜಿಲ್ಲಾ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣಾಧಿಕಾರಿ ಕಚೇರಿ ಮೈಸೂರು ಅವರು ಕೊಟ್ಟ ದೂರಿನ ಸಾರಾಂಶವೇನೆಂದರೆ ಶಿವನಂಜೇಗೌಡ ಮತ್ತು ನಯನ ಕುಮಾರ್ ಸುನಂದರ್ ಅವರುಗಳು ಅಕ್ರಮವಾಗಿ ಹಣ ಸಂಪಾದಿಸುವ ಉದ್ದೇಶದಿಂದ ಅವರು ನಡೆಸುತ್ತಿದ್ದ ಲ್ಯಾಬ್ಗಳಲ್ಲಿ ಪರೀಕ್ಷೆಗೆ ಬರುತ್ತಿದ್ದ ಗರ್ಭಿಣಿಯ ಮಹಿಳೆಯನ್ನು ಮತ್ತು ಮಧ್ಯವರ್ತಿಗಳಾದ ತುಳಸಿರಾಮ್, ಸಿದ್ದೇಶ್, ಪುಟ್ರಾಜು, ಅಭಿಷೇಕ್ ಗೌಡ, ಧನಂಜಯ್ ಗೌಡ ಅವರ ಮೂಲಕ ಬರುತ್ತಿದ್ದ ಗರ್ಭಿಣಿ ಮಹಿಳೆಯರಿಗೆ ನಯನ ಕುಮಾರ್, ನವೀನ್ ಕುಮಾರ್ ಅವರು ಸಂಬಂಧಿಕರು ಸೇರಿ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಆಡಿಯ ಗ್ರಾಮದ ಜಮೀನಿನಲ್ಲಿರುವ ಆಳೆಮನೆ ವೀರೇಶ್ ರವರ ಮುಖಾಂತರ ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಿಸಿ ಗರ್ಭಿಣಿ ಮಹಿಳೆಯ ಹೊಟ್ಟೆಯಲ್ಲಿ ಇರುವ ಹೆಣ್ಣು ಮಗುವೆಂದು ತಿಳಿದು ಬಂದರೆ ಡಾಕ್ಟರ್ ಚಂದನ್ ಬಳ್ಳಾರ್ ಅವರಿಗೆ ಸೇರಿದ ಮೈಸೂರು ಮಾತಾ ಹಾಸ್ಪಿಟಲ್ ಮತ್ತು ಆಯುರ್ವೇದಿಕ್ ಫೈಲ್ಸ್ ಡೇ ಕೇರ್ ಸೆಂಟರ್ಗಳಲ್ಲಿ ಮೀನಾ, ರಿಜ್ವಾನ್ ಖಾನ್, ನಿಸಾರ್ ಅಹಮದ್, ಮಂಜುಳಾ ಅವರ ಮೂಲಕ ಗರ್ಭಿಣಿ ಮಹಿಳೆಯರು ಗರ್ಭಪಾತ ಮಾಡಿದ ಭ್ರೂಣಗಳನ್ನು ನಿಸಾರ್ ಅಹಮದ್ ಅವರ ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡುತ್ತಿದ್ದು, ಗರ್ಭಪಾತ ಮಾಡಿಸಿಕೊಳ್ಳಲು ಒಪ್ಪದ ಮಹಿಳೆಯರನ್ನು ಉಷಾರಾಣಿಯವರ ಮುಖಾಂತರ ಮೈಸೂರು ಚಾಮುಂಡೇಶ್ವರಿ ಆಸ್ಪತ್ರೆ ವೈದ್ಯರಿಗೆ ಮತ್ತು ಮಾಲೀಕರಿಗೆ ಅನುಮಾನ ಬಂದರೆ ರೀತಿ ಗರ್ಭಪಾತ ಮಾಡುತ್ತಿದ್ದು, ನಂತರ ಗರ್ಭಿಣಿ ಮಹಿಳೆಯರಿಂದ ಪಡೆದ ಹಣವನ್ನು ಕಮಿಷನ್ ಹಣವನ್ನು ಮಧ್ಯವರ್ತಿಗಳ ಅಕೌಂಟಿಗಾಗಿ ಹಾಗೂ ನಗದು ರೂಪದಲ್ಲಿ ಕೊಡುತ್ತಿದ್ದು, ದೃಢಪಟ್ಟ ಮೇರೆಗೆ ಮುಂದಿನ ಕಾನೂನು ಕ್ರಮಕ್ಕಾಗಿ ಕೊಟ್ಟ ದೂರು. But in the complaint at last paragraph, please. Page number 14. Page number 14 at last paragraph, please.
Yes.
A1 ಶಿವನಂಜೇಗೌಡ ಮತ್ತು A2 ನಯನ ಕುಮಾರ್ ಹಾಗೂ ಇತರ ಆರೋಪಿಗಳು ನೀಡಿದ ಹೇಳಿಕೆ ಮೇಲೆಗೆ ATM ಕಾಯ್ದೆ ಉಲ್ಲಂಘನೆಯಾಗಿರುವ IPC ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಮೇರೆಗೆ ಈ ದಿನ ಸದರಿ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ದೂರನ್ನು ದಾಖಲಿಸಿ ಬೇಕೆಂದು ರಾಜ್ಯ ಸರ್ಕಾರ so and so. So the originally the complaint refers of the date 15/10/23, which took place in Bangalore, my lord. And this said the present FIR is filed on 24/4/24. That is almost of 6 months.
Yes.
So there is a delay of 6 months, and
Yes.
the petitioners, any conditions may be imposed, please. There is no any direct nexus, not direct allegations as against the petitioners.
No, not entered. Not entered. Name of the petitioners are specifically mentioned in the FIR.
Madam, only as per the complaint amendments, madam, they say that only upon the statement taken by A1 and A2.
Maybe it is still at the initial stage of investigation. Very brutal act. No. Nobody.
Lord, there are.
No, 438, no, nothing.
Madam,
Petitioners.
it may be passed over, madam, please, I'll file necessary memo. I'll take the instructions, I'll file necessary memo, please.
No,
At
no
2:30,
question of
please.
passover. I am dictating it. Within 2 minutes, it will be closed. No passover, nothing. Petitioners being accused number 12, 13, 15, and 16 are seeking grant of anticipatory bail.
Liberty will be given to me
preferential
to withdraw the petition.
You are withdrawing. Counsel to the petitioner after addressing the argument seeks permission to withdraw the petition. Submission is placed under the petition. Memo will appear and memo will follow. Dismissed is withdrawn. Yes.
Serial number 33, Akshay Swami.
Kindly be passed over.
ಇನ್ನೊಂದು ಯಾವುದು? 510. There is a second
Fine.
petition
Yeah, once. I'm a proxy
Same
counsel.
petitioner has filed
I'm
another
the proxy
petition.
counsel. Kindly be passed for his coming.
Asureke, that the second petition is to be tagged with this present petition.
Brother Swami, he's stuck as that. Kindly pass it.
First time. It is noticed that criminal petition number 5102 of 2024 is filed by the same petitioner. Court officer, same petition, the same petitioner. Hence, office is directed to list both these cases together. Yes. Next.
Serial number 34. Abhishek Ramyamar.
Petitioner in this case, my lord.
Yes.
438 petition, my lord. Accused number 1 is the present petitioner, my lord.
Petitioner is accused number 1.
Yes, my lord.
How many accused?
7 accused persons, my lord. Accused number 2 to 7 have been granted bail by Sessions Court, my lord.
What are the offense?
My lord, 498A, 504, 506, 114.
You are the husband.
Yes, my lord. My lord, the reason given by the learned Sessions Court judge for the rejection of the anticipatory bail is at page 21, my lord.
Adirli, what is the allegation against you?
My lord, demand for dowry and harassment. Page 21, para 9, 7th line, my lord. The petitioner in this case has earlier filed criminal miscellaneous number 559 of, sorry, my lord.
What is that you are reading?
My lord, the reason given by Sessions.
Sir, I should understand the allegations made against you.
Please.
How I am concerned about the reasons given by the learned Sessions judge. Without knowing the allegations, without knowing the facts of the case.
Please, my lord.
First, you should explain the facts of the case.
Yes, my lord. Page 15, my lord.
Come to page 13. Gist of the complaint.
Yes, my lord.
Yes.
ದಿನಾಂಕ 25/11/2023 ಬೆಳಗ್ಗೆ 11:30 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರು ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನೀಡಿದ ದೂರಿನ ಸಾರಾಂಶ ಏನೆಂದರೆ, ನನ್ನ ವಿವಾಹವು ದಿನಾಂಕ 16/5/2022 ಚಾಮರಾಜನಗರದ ಮೌಲಾನಾ ಆಜಾದ್ ಕಮ್ಯುನಿಟಿ ಹಾಲ್ನಲ್ಲಿ ನಮ್ಮ ಇಸ್ಲಾಂ ಮತ ಸಂಪ್ರದಾಯದಂತೆ ಗುರು ಹಿರಿಯರ ಸಮ್ಮುಖದಲ್ಲಿ ಮೈಸೂರು ಜಿಲ್ಲೆಯ KR ನಗರ ತಾಲೂಕಿನ KR ನಗರ ಪಟ್ಟಣದ ಮುನಾವರ್ ಶರೀಫ್ ಹಾಗೂ ಶಾಮಿ ಮಮ್ತಾಜ್ ದಂಪತಿಗಳ ಕೊನೆಯ ಪುತ್ರ ಇಸ್ಮಾಯಿಲ್ ಶರೀಫ್ ರವರೊಂದಿಗೆ ನೆರವೇರಿರುತ್ತದೆ. ಮದುವೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡನ ಬೇಡಿಕೆಯಂತೆ ನನ್ನ ಗಂಡನಿಗೆ 50,000 ರು ಹಣ, 10 ಗ್ರಾಂ ಚಿನ್ನದ ಸರ, 7 ಗ್ರಾಂನ ಒಂದು ಚಿನ್ನದ ಉಂಗುರ, 65,000 ರು ಬೆಲೆ ಬಾಳುವ ಒಂದು ರಾಡೋ ವಾಚ್ ಅನ್ನು ನನ್ನ ತಂದೆ ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಿರುತ್ತಾರೆ. ಮದುವೆಯಾದ ನಂತರ ನಾನು, ನನ್ನ ಗಂಡ, ಅತ್ತೆ, ಮಾವ ಎಲ್ಲರೂ KR ನಗರದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು, ಮದುವೆಯಾದ ನಂತರ ಸುಮಾರು 1-2 ತಿಂಗಳ ಕಾಲ ನನ್ನ ಪತಿ ನನ್ನನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಆನಂತರ ನನ್ನ ಅತ್ತೆ ಶಮೀಮ್ತಾಜ್, ನನ್ನ ಮಾವನಾದ ಮುನಾವರ್ ಶರೀಫ್ ಹಾಗೂ ನನ್ನ ಪತಿಯ ಸಹೋದರಿಯರಾದ ಅನಿಸಾ ಫಾತಿಮಾ, ನಾಜಿಯಾ ಫಾತಿಮಾ, ಆಯಿಷಾ ಅಮ್ರೀನ್, ನನ್ನ ಹಿರಿಯ ಅಣ್ಣನಾದ ಯೂಸಫ್ ಶರೀಫ್ ರವರುಗಳು ನನ್ನ ಗಂಡನಿಗೆ ಇವಳ ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ಚಿನ್ನಾಭರಣ ತರುವಂತೆ ಕೇಳು, ಮೈಸೂರಿನಲ್ಲಿ ಸೈಟು ತೆಗೆದುಕೊಂಡು ಕೊಡುವಂತೆ ಒತ್ತಾಯ ಮಾಡು ಎಂದು ವರದಕ್ಷಿಣೆ ತರುವಂತೆ ಕುಮ್ಮಕ್ಕು ನೀಡಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ನನ್ನ ಮಾವ ಮುನಾವರ್ ಶರೀಫ್ ರವರು ನಮ್ಮ ಕಡೆ ಮದುವೆಯಾಗಿದ್ದರೆ ಸರಿಯಾಗುತ್ತಿತ್ತು, ಇವಳು ಮನೆ ಕೆಲಸ ಮಾಡಲು ಸರಿಯಾಗಿದ್ದಾಳೆ ಎಂದು ತುಚ್ಛವಾಗಿ ನಿಂದಿಸಿರುತ್ತಾರೆ. ಇದರಿಂದ ನನ್ನ ಗಂಡ ನನಗೆ ಸರಿಯಾಗಿ ಊಟ ತಿಂಡಿ ನೀಡದೆ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ BSc ಪದವೀಧರೆಯಾದ ನನ್ನನ್ನು ಹೆಚ್ಚಿನ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಲು ಬಿಡುತ್ತಿರಲಿಲ್ಲ. ಈ ವಿಚಾರವಾಗಿ ನಮ್ಮ ತಂದೆ ಹಾಗೂ ಕುಟುಂಬದ ಹಿರಿಯರು 2-3 ಸಲ ನ್ಯಾಯ ಪಂಚಾಯಿತಿ ಮಾಡಿ ನನ್ನ ಪತಿ ಹಾಗೂ ಪತಿಯ ಮನೆಯವರಿಗೆ ಬುದ್ಧಿ ಹೇಳಿ ನನ್ನೊಂದಿಗೆ ಬಾಳ್ವೆ ಮಾಡಲು ಹೇಳಿ ನನ್ನನ್ನು ಕಳುಹಿಸಿದ್ದರು. ಆದರೂ 1-2 ತಿಂಗಳು ನನ್ನನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳದೆ ನನ್ನ ಗಂಡ ಪುನಃ ಹಳೆಯ ಪ್ರವೃತ್ತಿ ಮುಂದುವರೆಸಿ ನನ್ನನ್ನು ನಮ್ಮ ತಂದೆಯ ಮನೆಗೆ ವಾಪಸ್ಸು ಕಳುಹಿಸಿದ್ದರು. ಇಷ್ಟಾಗಿಯೂ ದಿನಾಂಕ 22/8/2023 ಬೆಳಿಗ್ಗೆ 11:30 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡ ಇಸ್ಮಾಯಿಲ್ ಶರೀಫ್ ನನ್ನ ತಂದೆಯ ಮನೆಯ ಬಳಿ ಬಂದು ನನ್ನನ್ನು ಚಿಕ್ಕ ಹೊಳೆಯ ಜಲಾಶಯದ ಕಡೆ ಹೋಗಿ ಸುತ್ತಾಡಿಕೊಂಡು ಬರೋಣ ಬಾ ಎಂದು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿ, ನೀನು ನನಗೆ ವಿಚ್ಛೇದನ ನೀಡಬೇಕು, ನಾನು ಇಷ್ಟಪಟ್ಟಿರುವ ನಮ್ಮೂರಿನ ಉಸ್ಮಾ ರವರ ಜೊತೆ ವಿವಾಹವಾಗಬೇಕು ಎಂದು ಹೇಳಿದರು. ಇಲ್ಲದಿದ್ದರೆ ನಿನ್ನನ್ನು ಇಲ್ಲೇ ಹೊಳೆಗೆ ತಳ್ಳಿ ಸಾಯಿಸುತ್ತೇನೆ ಎಂದು ಬೆದರಿಸಿ ಬಲವಂತವಾಗಿ ಖಾಲಿ ಪತ್ರಕ್ಕೆ ನನ್ನ ಸಹಿ ಹಾಕಿಸಿಕೊಂಡರು. ನಂತರ ನನ್ನನ್ನು ಚಾಮರಾಜನಗರ ಪಟ್ಟಣಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ರೈಲ್ವೆ ನಿಲ್ದಾಣಕ್ಕೆ ಹೋಗುವ ಶಾಲೆಯ ಬಳಿ ನನ್ನ ಮೊಬೈಲನ್ನು ಹೊಡೆದು ಹಾಕಿ, ನೀವೇನಾದರೂ ಕೋರ್ಟ್ ಕೇಸ್ ಎಂದು ಮುಂದುವರೆದರೆ ನಿನ್ನನ್ನು ಹಾಗೂ ನಿಮ್ಮ ಮನೆಯವರನ್ನು ಕೊಲೆ ಮಾಡುತ್ತೇನೆಂದು ಹೆದರಿಸಿ ಹೊರಟು ಹೋಗಿರುತ್ತಾರೆ. ನಂತರ ನಮ್ಮ ತಂದೆಗೆ ವಿಚಾರಗಳನ್ನು ತಿಳಿಸಿ ನ್ಯಾಯ ಪಂಚಾಯಿತಿ ಮಾಡಲು ನಮ್ಮ ಬಡಾವಣೆಯ ಹಿರಿಯರು ತಿಳಿಸಿದ್ದರಿಂದ ಸುಮ್ಮನಾಗಿದ್ದೆ. ಆದುದರಿಂದ ಈ ದೂರಿನೊಂದಿಗೆ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುವುದು ಏನೆಂದರೆ, ನನ್ನ ಗಂಡ ಹಾಗೂ ಮನೆಯವರು ವರದಕ್ಷಿಣೆ, ಕಿರುಕುಳ, ದೈಹಿಕ ಹಾಗೂ ಮಾನಸಿಕ ಹಿಂಸೆ ನೀಡಿ ಹಲ್ಲೆ ಮಾಡಿ ಕೊಲೆ ಬೆದರಿಕೆ ಹಾಕಿರುವ ನನ್ನ ಅತ್ತೆ ಶಮೀಮ್ ತಾಜ್, ನನ್ನ ಮಾವನಾದ ಮುನಾವರ್ ಶರೀಫ್ ಹಾಗೂ ನನ್ನ ಪತಿಯ ಸಹೋದರಿಯರಾದ ಅನಿಸಾ ಫಾತಿಮಾ, ನಾಜಿಯಾ ಫಾತಿಮಾ, ಆಯಿಷಾ ಅಮ್ರೀನ್, ನನ್ನ ಪತಿಯ ಅಣ್ಣನಾದ ಯೂಸುಫ್ ಶರೀಫ್ ರವರುಗಳ ವಿರುದ್ಧ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಂಡು ನನಗೆ ನ್ಯಾಯ ದೊರಕಿಸಿಕೊಡಬೇಕೆಂದು ಈ ದೂರಿನ ಮೂಲಕ ವಿನಮ್ರವಾಗಿ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುತ್ತೇನೆಂದು ನೀಡಿದ ದೂರಿನ ಮೇರೆಗೆ ಈ My lord, the reason for rejection of the anticipatory bail is at page 20.
My lord, charge sheet has been filed, my lord. He was shown as absconding, my lord. Whether he is required for, he is not required for anything. Conditional order. So, petitioner being accused number 1 is seeking grant of anticipatory bail on the apprehension of being arrested. The wife of the petitioner lodged the first information on 25/11/2023, alleging that the petitioner being her husband and other accused being his family members were ill-treating her by demanding additional dowry. And accused number 1 had taken her signatures forcibly in blank paper, pressurizing her to give divorce and criminally intimidated to cause her death. It is stated that the incident of taking her signature on the blank paper and criminally intimidating to cause her death was on 22/8/2023. However, the first information was came to be filed on 25/11/2023. It is stated that the case number 2 to 7 are already apprehended and granted and released on bail. Admittedly, the investigation is completed and charge sheet is filed, showing the present petitioner as absconding. It is not the contention of the prosecution that the petitioner is required for further investigation. Hence, I am not taking it. Allowed subject to condition.
Grateful.
Serial number 35, Basuraju TA. Serial number 35, TA Basuraj.
Absent, no representation. Next.
Serial number 36, Murali M.
Pray for the petitioner, please. There are 7 accused, Your Honor. Petition number 1 is the case number 1.
A1.
A1.
When he was arrested?
He was arrested on 26/12/23.
What are the offense alleged?
Offense under section 302 of IPC, Your Honor, and the allegation is that, my lord,
Is filed.
charge sheet is filed. Your Honor, may get it, charge sheet at page number 26 here. Relevant portion at page number 38. Initially, my lord, the daughter of petitioner is missing, Your Honor. Thereby, he filed a complaint before the police at page number 63.
Who is the deceased?
This is the daughter, Your Honor. Daughter of petition number 1, petitioner.
What was her age?
Sorry?
Age.
Age was 18 years. When his daughter is missing, Your Honor, he filed a complaint before the police, my lord, at page number 66.
Who filed the complaint?
Petitioner only. Petitioner filed complaint on 17/10/23, which is registered as FIR number 410 of 23. Sorry, 210 of 23. Under section 363. After 17/10/23, my lord, the police have registered sumo motu case against this petitioner at page number 13. At page number 13, one head constable has registered a complaint against this petitioner
Yes.
for the offence under section 302 of IPC.
Yes.
Thereafter, after the investigation, my lord, the police have filed a charge sheet against this petitioner for the offence under section 302 and 9 and 10 of Prohibition of Child Marriage Act.
Yes.
The gist of the allegation is
The
that, my lord,
Provisions of Prevention of Child Marriage Act is invoked.
invoked, my lord.
She must be a child.
No, on the allegation that when she was minor under 17 years, he performed the marriage of his daughter with another one, Subramani, that is accused number 2. The allegation is that, my lord, petitioner's daughter is in love with, in his native place, the same village, with someone, Kalyan Kumar, and that he doesn't like that. So that is the reason why he performed the marriage with one Subramani of one Krishnapura village.
Yes.
After that, they are leading their happy marital life. When she is not leading happy marital life with her husband, he called, petitioner was called to that village, and he advised her in a manner. When she is not listened, he had taken her to the land, and there he committed murder of her, his daughter, and set on fire to the dead body. After that, Your Honor, that alleged incident in the month of May 2023. May 2023, 25/5/2023. The alleged incident took place, Your Honor. And he lodged a complaint, missing complaint before the respondent police, my lord, at page number 66. Even after lodging missing complaint, after lodging the missing complaint 2 months later, my lord, this present complaint came to be filed by the police official. Present complaint at page number 13.
Recovery at your instance.
No recovery is made, my lord.
No recovery.
No recovery is made at my instance.
Yes, what is saying?
The instance of this accused, my lord, the blood-stained clothes of the accused were recovered.
Blood stain, his blood stained clothes.
Yes,
Blood stain?
Then
so the club who used for the commission of the.
club also recovered. Then
The vehicle will use for the commission of the.
all recovery at his instance. Then Hmm. There were no traces. The body was burned.
Yes, my lord, body was burned.
The remaining accused were granted bail, Your Honor, by the session.
No, allegation against others is not so
They are not
serious.
involved
Not
in
so
the-
serious. Please.
It is you who committed you assaulted her. Thereafter caused her death,
Please give
burnt
that
the dead
daughter.
body, burnt the blood stained clothes,
That is the allegation.
and thereafter filed the missing complaint. See the cruelty.
Now the charge sheet is filed, Your Honor.
No, sir, serious, no, look at the seriousness of the offense.
Yes.
The father has caused the death of the girl. No, sufficient prima facie materials are there.
There is no motive, my lord, and there is no eyewitnesses also.
Not circumstantial evidence.
Circumstantial evidence also not supporting.
Any other circumstantial evidence?
Except this,
apart from
my lord,
the
there is
story?
no circumstantial.
The other witnesses say that, my lord, the accused was not happy with that, with the
Yes,
victim,
Adela,
that he was
that
in
is the
love with
motive
her.
for. No, not it. Petitioner, being accused number 1, is seeking grant of bail. He was arrested on 26/12/2023. Then he is in judicial custody. Initially, the petitioner filed the complaint alleging that his daughter is missing. Later, it came to know that the daughter was done to death by the petitioner with the help of other accused. Thereafter, the first information was came to be filed for the offense punishable under section 302 of IPC. After investigation, charge sheet is came to be filed. As many as the 36 witnesses are cited by the prosecution, even though there are no eyewitnesses to the incident, the prosecution is relying on circumstantial evidence. They stated that the blood-stained clothes of the petitioner, club and the vehicle used in commission of the offense were recovered at the instance of the present petition. They stated that the petitioner was having strong motive to cause the death of his own daughter. It is also alleged that the petitioner was not happy with the relationship of his daughter with another person in the village, got her married. She was married to whom? Accused number 2. Her married to accused number 2 during her minority, and thereby he has committed the offense. There are strong prima facie materials against the petitioner for having committed the offense. Considering the nature and seriousness of the offense, I am of opinion that the petitioner is not entitled. Dismissed.
Serial number 37, Rajanna C. Serial number 37, Rajanna C.
Absent, no representation. Next.
Serial number 38, Devraj AG.
Please, your lord. Petitioner is accused number 1 in crime number 145 of 2024.
Now, how
Registered.
many accused are there?
2 accused.
What about 2?
The second accused is my ex-wife. I have divorced from her, but I don't know how. The entire complaint, we would like to highlight to this court seems to be a got-up type of thing.
What are the offense alleged?
Offences alleged are 506, 34, 406, 420, 468, and 471. Complaint, it goes to say that I met the accused, the petitioner. He's complainant is a resident of Dubai, Muscat. Met the accused person in Dubai and a friendship developed. The contention of the complainant is that on 18/7/23, he had come to Bangalore, and at that time he had spent time with the petitioner in a hotel called Savory Restaurant on Mosque Road, Bangalore.
Yes.
And at that time, there was a discussion with respect to the complainant seeking to buy a land for which financial assistance was being sought. That financial assistance is purported to have been suggested by the accused number one to be from a company known as Blackjack Investments Private Limited. Now, your lordship, the entire allegation is that he has parted with substantial amounts of money, which from the very narration of the complaint would go to show has been to the account of that private limited company, which has not been arraigned as an accused in these proceedings. If the entire case of the grant or non-grant of loan and processing fees and advance installments have been taken, it would be against that private limited company against whom, unless it's made as an accused, no vicarious liability of anything could be liable.
No. the
Even
allegation-
otherwise.
Allegation against you is that
My accusation is that I am the owner of it.
you took the money of 2 lakh rupees.
No, I have not taken the money. Must transfer, bank transfers. Bank transfers are all to that financial institution.
ಎರಡು ಲಕ್ಷ ನಗದು ಹಣವನ್ನು ಜಮೀನಿನ ದಾಖಲಾತಿಗಳನ್ನು ನೀಡಿರುತ್ತೇನೆ.
Yes, only to that limited extent.
Was
The substantial
received by-
amount
No.
has all gone about nearly, according to the complaint, nearly about 65 lakhs has gone to the private limited company.
But let it go on. But he has no grievance about that.
The grievance is that he didn't get the loan. And I am not the person who can grant him loan. That financial institution's requirement has to be met. There is nothing against him. And how 468 is available, how 471 is made available to me is not less available from the complaint. 406 is not available. There is no entrustment to me. And on that day of importance is on that day I was not in Bangalore at all. Admittedly, I was in Bombay on that day. So he couldn't have met me at all.
1 minute, sir.
Please.
I'm reading the gist of the complaint. This 96,82,000 was transferred to which account?
To the account of that investment company.
No, there is reference to Atana company Katege.
He treats that company as mine.
Hmm.
But it's admittedly a private limited company.
Who admitted that?
Is that by law, it's a private Blackjack Investments and Finance Limited.
You introduced yourself as the owner of that private limited company.
How can there be anything called an ownership of a private limited? I fail to understand.
Where is it? How can you say that
Your
admittedly?
lordship,
Allegation
in
is
law,
that.
your lordship, in law.
Allegation is that. you
Allegation, fair
introduced
enough.
yourself.
Fair enough, your lordship, the allegation.
Cannot
But by
say
law,
admittedly there is a company, it is a private limited company, it is not made a party. How can such contentions be raised?
but then the fact is that on that day I was not here in Bangalore.
Maybe.
That means how can the complaint be? How did he meet with me? How did he spend a time of over
That is
7
the
hours in the
defense-
restaurant?
That is the defense taken by.
Not defense,
that
it's
can
an
be taken
admitted
by.
position. Records are there. I am not setting up an alibi. It is an admitted person.
What do you say?
the information that my lord, it shows that my lord, he is the owner of the company. He is also one of the director of the company, my lord. And total amount of 96,82,000 has been paid to the account, my lord.
96,82,000 was transferred to which account?
To the account of the company, my lord.
Why it was deposited? He wanted a loan.
Yes, ma'am.
Then why he should deposit 96 lakh? 97 lakh?
To purchase the land, my lord, he wanted to take the loan, my lord.
No, to take the loan, why he should deposit 97 lakhs? He was in need of money.
Yes.
He approached the petitioner.
Yes.
Petitioner promised to arrange for loan. Then why he should deposit 97 lakhs? I can understand 2 lakh rupees payment in cash, I can understand.
Is the complaint, my lord, he says that he has given the money. That is the complaint in complaint, my lord. he says that-
I could not understand this.
Because he would get 30 crores loan, my lord. The land, my lord, he would get 30 crores loan.
There is allegation that there are such 8 such fake financial companies.
Yes.
Any other information? No.
It's still under investigation, my lord.
As per his complaint, the petitioner threatened him that the information will be provided to income tax AD. And immediately he lodged the complaint. What about A2?
A2 is my wife, my lord, whom I have divorced. I have got nothing to say with her. Long number of years ago, I have divorced her. And I have thereafter got married again, and she has got nothing to do with this. And what it has been shows falsity in the nature of the complaint is all that we wanted to hide.
Petitioner being accused number 1, seeking grant of anticipatory bail on the apprehension of being arrested. The informant lodged the first information stating that the resident of Muscat, and he came in contact with the petitioner and accusing too. Then he came to Bengaluru and wanted to invest in land. Petitioner assured him of providing him the financial assistance and took rupees 2 lakh in cash. He was asked to transfer 96,82,000 to the account of a private limited company, stating that he is the owner of the said company. Later, no loan was arranged by the petitioner. But the informant came to know that the petitioner is running several fake financial institutions and extracting the amount from various persons under the guise of providing them the loan. Okay. Even though the allegations made against the petitioner is of serious nature, it stated that an major portion of the amount, that is 96,82,000, was transferred to the account of a private limited company. Under such circumstances, I am of opinion that the petitioner may be granted anticipatory bail subject to conditions which will take care of the interest of the informant and also the prosecution. Hence, it is made clear that even though the petitioner is granted anticipatory bail, if the investigating officer is of the opinion that the petitioner is required for custodial interrogation, he may take him to the custody with the permission of the jurisdiction of magistrate upon the additional conditions of the marriage, allowed subject to conditions.
Careful.
Serial number 39, approach Pasha.
Petition. 439.
Yes.
The two accused, my lord. Accused number 2 is already granted bail by Sessions Court. This is a case of counter case, my lord. Case and counter case. Connected matter, this honorable court already granted bail to accused number 1 and 2 in a counter case, my lord. Counter case will bail already.
Counter case complaint by
Lord, complainant, my lord.
counter case registered by whom?
The complainant in this case, my lord. Accused number 2 in this case, my lord.
That is crime number
107, my lord. 107 of 24, Pargudi police station.
for what offense?
Same offense, 307 and 504 and 34 of IPC, my lord.
How many are injured in this case?
My lord, they're 2 injured, my lord.
Huh?
2 injured. All outpatient treatment, my lord. They taken treatment on the same time. They both the parties came to the station and filed the FIR, my lord.
When you are arrested?
Arrested on 15th May 2024 on
24.
24 months.
Where is the wound certificate?
We not received, my lord.
Hmm?
We not received.
Yes. Simple. So, petitioner, being accused number 1, is seeking grant of bail. He was apprehended on 15/5/2024. Since then, he is in judicial custody. He stated that accused number 2 is already enlarged on bail. The informant lodged the first information making specific allegations against accused number 1 and 2 for having committed the offense under section so and so. It is noticed that accused number 2 herein lodged the first information against the complainant and others is registered in crime number 107 of 2024. Therefore, it is a case and counter case registered against one another. Admittedly, the injured has sustained only simple injuries. The accused in the counter case are already granted bail. Considering all these facts and circumstances, I am of the opinion that it is not the contention of the prosecution that the petitioner is required for further investigation. Under such circumstances, his detention in custody would amount to so then allowed subject to conditions.
Serial number 40, Harish Prabhu, yes. 40, Harish Prabhu, yes.
Absent, no representation. Yes.
Petition number 41, Nikhil Krishnamurthy.
Sir, 438.
Yes.
Its alleged offences 409, 418, 420, 465, 468, read with 120B, my lords.
Yes.
My lords, in all, there are 9 accused. Petitioner is accused number 5. He's a gold valuator, my lords, a jewel appraisal. And he's been doing this from 1994, my lords, appraisal of jewelry. My lords, he's aged about 72 years now, my lords. And he's been doing this gold valuation for the Urban Cooperative Credit Society, Kanakpura, since 1994, my lords. So when his services were engaged, my lords, they had taken an indemnity bond from him. In case of any losses because of the inaction done by him, he would be bound by the indemnity bond, my lords. Now, my lords, in the year 2022, my lords, they would find that certain kind of valuation done by the present petitioner was not right. He had not valued it correctly. Some fake gold which was given as a security towards the loans that have been given, he should have appraised it properly, which he hadn't done. So then, my lords, they would choose to invoke the indemnity bond, my lords, and a sum of 21.50 lakhs was paid from the indemnity bond. Petitioner pays it to the society, my lords. They would also notice, my lords, so far as 9 accounts are concerned, there is still an outstanding of 14.05 lakhs. And they would ask us to pay that amount also, 14.05, my lords. Now that amount also was paid, my lords. So totally about 35 lakhs that has been paid on the ground that my valuation was wrong. Either I had overvalued the gold or certain ornaments which were not gold were taken as gold. Mainly, my lords, probably that acid test which he is supposed to do, my lords, to ascertain how the gold is, that he hadn't done. Anyway, my lords, all this happened in 2023, my lords. So insofar as the role of the petitioner ended with that, my lords, paying back the entire amount which is due from him.
When you paid it?
My lords, in 2023, there is they have acknowledged it, my lords. Could I just pass this on, my lords, where they have acknowledged the entire amount in their audit report? They have acknowledged, as well as they've given a letter acknowledging the whole amount.
What is the amount that was cheated according to the complaint?
No, now what has happened here is, my lords, now the present complaint, when an audit report was done, my lords, they found there's various violations done by different persons in different transactions. So present complaint is a combination of 9 transactions, out of which 8 transactions, my lords, pertains to directors, the secretary, the CEO of the society, different, in which I have no role to play.
But you are the evaluator.
Only in one transaction. If the complaint is seen, my lords, if my lords would kindly notice the complaint, very distinct, 9 different kind of transaction, different offenses, different accused.
Who is the complainant?
My lords, the complainant, CEO, my lords, of the Credit Cooperative Society. This complaint is dated 12/4/2024, my lords. Much after the indemnity bond was invoked, repayment done by the gold valuator, my lords, much after that, my lords would get it at page 19, my lords, in which, my lords, the relevant portion, how they split up this entire complaint is into different crimes that have been committed. My lords, first crime, Kritya number 1, my lords would get it page 21. That pertains to, I'm sorry, page 21. In Kritya number 1, that pertains to the director and the secretary, my lords. Certain interests which was collected from the members, they are misappropriated.
Yes.
My lord, second crime, which we get at page 22, Kritya number 2, that again pertains to, my lords, a person, Ravindra, who's fabricated someone else's signature and had received money from the members. And they would assess what is the loss that is caused by him, my lords.
Yes.
Now, the third crime which they say, page 24, that pertains to the gold valuation, my lords. My lords would get that portion, it's
Yes.
gold valuation. And there they say how it was valuated, when it was valuated. But probably, my lords, there they have not mentioned the fact that the entire amount had been paid by the gold valuator, which they themselves have acknowledged and which is part of the audit report. And thereafter, my lords,
Total amount cheated 41 lakh.
41 lakhs. Now, according to them, my lords, what the gold valuer's mistake was to the tune of 35 lakhs, which has been repaid, my lords. 21 lakhs through the indemnity bond, 14 lakhs from 9 accounts where the valuation was wrong. And that audit report, my lords, could I just point out in the audit report itself?
Merely because you repaid some amount under indemnity bond, whether the criminal offense will.
My lord, this was much prior to the FIR itself, my lord. They
Maybe.
said your valuation was wrong. And they invoked the indemnity bond, my lords.
No,
The whole
allegation-
amount has been recovered by them.
Allegation made against you is that you evaluated the
Fake. Yes, my lords.
fake jewelry.
That's the
as that
allegation
of
made.
gold jewelry and caused loss.
My lords,
Cheated.
may notice in that allegation, my lords, it is not a case, my lords, that the petitioner was paid anything or shared anything from them. No, that was not the allegation, my lords. The amount,
Obvious.
but the amount they say, my lords, is the directors. They are the
Why
ones.
why
who
you
are-
should evaluate a fake jewelry as a gold jewelry
My lords,
for no reason?
Allah, process of, I'm sorry, my lord, subject to instruction, the process of evaluation, the acid test that had to be done for the gold had not been done. The
Yes.
physical verification of the gold, he assessed it, my lords. Probably that is what was done. But anyway, my lords, the fact remains, my lords, the allegation is not that for 420, 409, my lords, breach of trust and cheating, consequential gain, zero, my lords, nothing.
No, I am asking you,
I
why you
understand.
have done that?
I understand, my lords, there's a fault on the part of the valuer about what he did, my lords. There's a fault. And they've invoked the indemnity bond, made sure no one loses that money. They've collected back that
It is
entire
not of 1,000 or 2,000, more than. Even
41,
according to you,
41, according to them, 41 lakhs is the total loss, my lords, and they attribute 35 lakhs because probably, my lords, when they even assess that 41 lakhs, it's on the weightage of the gold, which should have been done. That's how they would have assessed it, my lords. But according to them, my lords, in their own audit report, what was demanded has been repaid, my lords, according to them. So, my lords, while considering the fact, my lords, because this FIR comes much later, if probably, my lords, at the time of FIR, they were to assess that the repayments had been done and there was no loss out of those 9 accounts, probably that Kritya number 3 might not have been part of this. My lords may kindly notice the repayment. My lords, the report of the auditor.
even it is accepted,
Yes, ma'am.
it will not inure to your.
I know, my lords, I wouldn't say, my lords,
Then
we are absolutely
you
no.
cannot justify it.
No, my lords, I'm not saying we may be absolutely innocent of the crime, my lords. It may not be a case of that, my lords. Investigation is going on. I'm on the aspect, my lords, of the consideration of bail for a person who is about 74 years, my lords. I'm willing to subject myself to any kind of conditions, my lords, at this age.
Yes,
That is the
what is
reason.
it?
The petitioner, my lord, being the gold valuer, my lord, he has actively participated in the crime.
Yes.
He has conspired with the other accused person, my lord, and caused the loss to the society, my lord. My lord, this custodial interrogation is required,
Yes.
my lord, to unearth the other appropriations.
Is necessary.
My lords, necessary, they can in a condition itself, my lords, at
No,
this age.
with the protection of an umbrella, no.
No, my lords, protection of umbrella barrella, my lords.
Be effective.
My lords, custodial interrogation, my lords.
Yes.
Even if there's an anticipatory bail and there's a condition for custodial interrogation is custodial interrogation, my lords. And my lords, custodial interrogation, ಹೇಳುವಾಗ, my lords, ultimately Article 20, my lords, if a person says right of silence, please leave me.
That is
That-
all there,
that
sir.
is there, my
That
lord.
is
So-
all there.
And for this aged person, my
You can
lords,
take it to anywhere. Yes.
but for a
that is all
person, my
there.
lords, of this age who's repaid the entire amount much prior to the FIR being registered, we didn't even have an inkling.
That shows your guiltiness.
No, my lords, they asked.
Otherwise, no evaluator will pay 35 lakhs. Simply, no
ಅಲ್ಲ,
one will
bond
pay
ಇತ್ತು.
that.
Indemnity bond ಇತ್ತು. They invoked the indemnity bond, my lords. Because of invoking, we paid that amount.
That means to say you admit that you have committed this misappropriation,
My lords.
cheating,
Otherwise,
everything.
otherwise it would have ended up with a suit, my lords, against the indemnity bond, my
Counts to
lords.
criminal breach of trust. Repaying the indemnity bond is one thing. But what about the criminal offense?
My lords, consequential
That
gain,
will
my
not
lords.
dilute that.
Gain, my lords, any gain made by the valuer
You can take advantage of that, that's all. But no,
for the purpose of anticipatory bail with a condition that I
no.
go in
no,
for
no,
an interrogation, my lords.
ಇಲ್ಲ. Petitioner.
My lords, in that case, my lords, I withdraw it, my lords.
Yes.
That's the case.
Counsel for the senior counsel for petitioner, after addressing the argument, but sometimes it's permission to withdraw.
My lords, could I at least reserve liberty post the charge sheet, my lords, or the change of
Sir, why
circumstance?
liberty, sir?
Please.
438.
I understand.
The moment you are apprehended, you are at liberty.
Now, in case they don't apprehend and they file a charge sheet, my lords, it'll be a change.
ಅದು I will
I'll
not-
pay,
I will not do.
Please, my lords. Oblige, my lords.
Yes.
Hearing on IA, serial number 42, MJ Alva.
ಏನಿಲ್ಲ. ಏನೋ ಅಯ್ಯೇ ಹಾಕಿದೆ. ಇಲ್ಲ, RP-ನೇ ಇದೆ.
Not for review of the judgment.
What are the grounds?
My lord, a will is raised subsequently, subsequent to the judgment.
Hmm.
A registered will came to the knowledge of this petitioners, whereupon the property in question is a suit for partition.
Your RSA was, ಏನಾಯ್ತು?
RSA was
Allowed in.
allowed with the.
You are the respondent.
I am the petitioner, my lord. I am the appellant before this honorable court, my lord.
Hmm.
The RSA, the shares were modified. I'm sorry, my lord, I got some throat problem, therefore, I am permitted to make my submission on the next date. There are few authorities also on this. On the next week, I'll convince your lordship.
No, is it not beyond the scope of the review?
My lord, it is within the power of this honorable court, my lord. The view taken by the apex court in year 2005 Supreme Court.
So you can produce additional document, lead additional evidence.
My lord,
You
it
can
was
invoke
not- my lord,
41
I
rule
have to-
27.
My lord, I have to fulfill the conditions stipulated under order 47 rule 1, my lord. That is a mandate.
There is a condition is there.
My lord, this document was not within our knowledge. At the time when this.
Registered document according to. you.
Registered document.
It is
It's a
the
registered document.
registration of a document. It
My lord,
is a notice
registered
to-
will, my lord, registered will. It was with the, one of the attesters. It was not within our knowledge. It came to our knowledge only at this fact.
No.
Lordship may kindly grant me 1 week time. I'll convince your lordship. There are.
So for the petitioner praise for time. List on. Next.
Serial number 43, Srinivasa KN.
Yes, my lord, I am for the petitioner. I am for the petitioner.
Hmm.
My lord, I have undergone bypass surgery
Hmm.
last week. I am seeking extension for disposal of the suit, my lord.
What is to be extended?
Time has to be extended, direction has to be given to the trial court for disposal of the suit, my lord. Because the lordship granted time till 13th July. It will expire on 13th July.
Let
By
the
the
court,
time-
let the court request for extension of time. Why you are requesting?
Because time, my lord, expires on 13/7, next month, 13th.
Yes.
It is not possible because I have to,
No, it is to be stated by the trial
Present-
court, not by the advocate.
but my lord, the trial court is not granting time. It is taking every day. I am not
See,
able
there
to
is no-
attend.
There is no direction against you. The direction is to the trial court.
Correct, my lord, I am a party to it.
No,
I have to appear and address argument.
let the trial court go ahead.
Lord, at least 1 month time may be extended, my lord, 13/7 to
Sir, there is
13/8.
there is no direction against you.
My lord, it is diagnostic, I do agree, my lord. But the thing is, I am not able
I
to
have not
appear
received
before
any
the court.
requisition from the court. No,
but I am unable to appear, my lord. That's why, my lord.
you make the submission before the trial court. Aste.
No, I insist, I have also filed application
Hmm.
and my side is also already closed.
You are the petitioner in the writ
I am
petition.
the plaintiff. Yes, my lord, I am the plaintiff.
That is at your instance that direction was issued.
Yes, I do
Then
agree, my lord.
now you cannot
But now I have
have any
suffered a heart
grievance.
attack. I suffered a heart attack. I undergone
Sir,
bypass surgery.
that submission you have to make before the trial court, not before this court.
No, my lord, I only, since your lordship is
Heard IA3 of 2024.
at least 1 month or 20 days
Direction was
time
given
next
to
to
the
me.
trial court for disposal of the suit. No requisition is received from the trial court for extension of period. I do not.
Let
find
there
any
be an
reason.
observation to that effect, my lord. My application.
Application. Hence IA3 of 2024 is dismissed. Yes, next. No, your application is dismissed.
Lord, since I'm making submission regarding my lord, my condition, let there be a record, my lord, and the trial court can consider for extension of time.
That is to be considered by the trial court, sir. I
Correct, my
cannot
lord.
give a direction to the trial court, consider this request. No,
Oh, my lord,
you
the
make
lordship
such
God.
request, representation before the trial
Well,
court. Next.
Serial number 44.
I may be permitted to represent, my lord.
Where is the restriction, sir? There is no bar.
No
I'm
bar,
only
but
saying that you are not seek any extension here by this court. No, next. Yes, 44.
Yes. No, just on two very limited points.
Yes, why this?
Just 2 points, my lord.
Hmm.
We are not dislodging or raising grounds which are appropriate on appeal, but it appears there is an apparent error, my lord. My lord will
That
appreciate that. Kindly come to page
writ
23.
petition was disposed of.
Disposed
You are the
of.
petitioner or respondent?
I am the respondent, my lord. My lord had upset the order of the trial court.
Writ petition was allowed.
Allowed upsetting the order of the trial court.
Yes,
In an Article 227 petition.
yes.
My lord will see the operative portion of my lord's order at page 23.
Hmm.
Page 30, ink page 36.
Yes.
Lord is observed in Roman 3.
Hmm.
The trial court is directed to impound the agreements dated 29th April 1984 and 25th February 1992 as provided under Article 5E of the Karnataka Stamp Act 1957 in the light of the observations made above. My lord, the observations made above are in paragraph 12.
Hmm.
I'm sorry, not 12. In paragraph 16. The last, on page 26, the last 3 lines. Therefore, the relevant act.
Paragraph number?
Para 16, I'm reading at manuscript page number 26.
Yes.
The last few lines of para 16. Therefore, the relevant act to attract the stamp duty is the Karnataka Stamp Amendment Act 1981, which was in force when the agreements were executed. And my lord will see this third line on top of the same page. It's ₹3.
Hmm?
Third line on the top of that page.
Yes.
It is 3. Now, coming back to the operative portion, Roman 3, my lord, these agreements of 84 and 92 bear a stamp duty of ₹3.
Hmm?
They bear a stamp duty,
Hmm.
the appropriate stamp duty.
Article 5 of stamp that deals with, you read the entire paragraph, I don't
Please.
remember this.
I'll read. Para 16, my lord.
Hmm.
Article 5 of the Stamp Act deals with the agreement or memorandum of agreement.
Hmm.
This Article 5 was substituted to Section 3 by Act number 6 of 1910. That is the Karnataka Stamp Amendment Act 66,
Yes.
which came into effect from 15 November 66. As per the amended Article 5D, if the agreement or memorandum of agreement is not provided otherwise for, the proper stamp duty payable is ₹3.
Hmm.
Similarly,
That is 66 Act.
yes.
Yes.
The 81 Act doesn't change it. Similarly, the Karnataka Stamp Amendment Act 1981 came into effect from 7th April 1981, according to which Article 5, Item D was renumbered as Item E. So there was no change in the rate. It is thereafter Karnataka Stamp Amendment Act 1995 came into effect from 31st March 95. But the agreements referred to in the present petition are dated 29th April 84 and 25th February 92, which are admittedly prior to coming into force of Act number 8 of 95. Therefore, the relevant act to attract the stamp duty is the Karnataka Stamp Act 1981, which was in force when the agreements were executed.
Yes.
And therefore, as per that, ₹3 had to be paid.
Hmm.
And therefore, my lord, these two agreements
Hmm.
have ₹3. It was not brought to the notice of the
That
court.
was written on the value of stamp duty. What is the value of the stamp duty? Paid under those,
₹3.
already paid.
Yes,
according to
yes.
you. ಮತ್ತೆ ಯಾಕದ್ ಬಂತು ಆ ರೀತಿ? ಯಾರು who is for the other side? Yes, that is the only ground.
And my lord, on that ground,
Hmm.
and one other ground, my lord, may I just point out, if my lord is issuing notice, I'll raise the other grounds later on.
No, which is the other ground?
My lord, it's just to 24, kindly come to para 24. I'll just point this out. I mean, due respect, my lord, maybe it's just by oversight.
Page 20,
In
24.
para 24 at manuscript page number 31.
Yes.
My lord, this is on another legal issue. In the present case, admittedly, my lord is looking at the suit prayers. The suit filed by the respondent as plaintiff before the trial court is one for permanent injunction in respect of the very same property against the petitioner and the other defendants from interfering with the peaceful possession and enjoyment of the suit scheduled property and from committing acts of trespass into the suit scheduled property. Therefore, the possession of the property is to be proved by the plaintiff, and for the said purpose, the plaintiff wants to rely on the agreements and the declaration cum ratification deed. Under such circumstances, it cannot be said that the plaintiff is placing reliance on those documents only for collateral purposes.
Hmm.
So, my lord, in interpreting collateral purposes under Section 49 of the Registration Act, my lord has looked at collateral in the context of the prayers in the plaint. But my lord, the law is settled by the Supreme Court. When the word collateral is used in Section 49, it is not with reference to the pleading in the proceeding, it is with reference to the document itself. If the main purpose of the document, for example, is to convey title, but possession is handed over in that document and you're only proving possession, then you can rely upon the document for the collateral purpose of proving the nature of possession. So the collateral is a reference to the nature, the main purpose of the document, not with reference to the suit prayer. And my lord, we have a judgment clarifying that.
Let me consider issue notice to Hurdle and senior advocate for the petitioner.
I have one very reasonable prayer to make, my lord.
Issue emergent notice to respondent.
Very reasonable prayer. This will be heard very quickly to review petition. My trial is stuck. Subject to the outcome of the review petition, my stamp duty is paid. I may be permitted to mark the documents, subject to the outcome of the writ petition.
To serve the copy on the other side immediately, I will take up the matter. Tomorrow, day after.
Right. Just another prayer, another matter. They are relying on this as a precedent in other cases which is affecting us. Let a clarification be made, my lord, that it cannot be relied until this matter is resolved.
I'll consider. Yes, when will you serve the notice on the other side?
Tomorrow.
Issue
On
emergent
council, I serve it tomorrow.
ಯಾರಿಗಾದ್ರು issue notice to respond, issue emergent notice to respond. Counsel for the petitioner seeks permission to serve the notice on the learned counsel representing the respondent. Is permitted to do so in addition to issuance of notice.
Until some observation that it need not be relied upon until in other proceedings.
Immediately, I will take up the matter.
I'm grateful, my lord, very grateful for the accommodation. A date can be fixed, I'll serve them.
But in the meantime, you have to serve, they have to appear
That's the difficulty, my lord.
next week.
They are relying on this judgment in every other case. And I've been, in some cases, there are time-bound matters as well. It's putting me in a difficulty.
That is why immediately you serve the.
I'll move the
notice on
court
the
after
rest.
service. I'm grateful.
After service of notice, you move.
On
it.
council, I'll come. I'm sure he'll appear.
List after service. The second list.
List 2, non-compliance of office objection for first time, serial number 1 to 15.
My lord, serial number.
Please comply with the office objections. First time.
My lord, serial number 10. My lord, it is asking for clarification. We have written correctly, my lord.
How many objections are there?
Only the offences and court name mentioned in the cost title is not tallying with the same in the bail rejected order and the charge sheet copy to be clarified. Whatever is there in the charge sheet only we have written, my lord.
The third learned counsel for the petitioner, he submits that the offense, the provisions of the penal, the penal provisions invoked in the charge sheet are correctly mentioned in the petition. The submission is accepted, office objection is ignored. Issue, CGP takes notice for respondent number so private idre issue notice. Yes.
Much obliged.
Other matters, comply with
number
the office
13.
objections. Huh?
Serial number 13.
Yes,
One objection ಇದೆ ಸ್ವಾಮಿ ಅದು
comply with that.
2 days.
Yes,
Serial number 12, my lordship.
yes,
1 week may be granted.
yes. In all other matters, the time will be granted. Please comply with the office objection.
Serial number
Lordship,
14.
serial number 14.
Hmm.
Lordship, it is a 438 petition, Lordship. The observation made by the learned sessions judge, Lordship, it clearly reveals that anticipatory bail cancel ಆದಂಗೆ ಲೆಕ್ಕ ಆಗುತ್ತೆ. ಮತ್ತೆ ಹೋಗಿ ಆಫೀಸಲ್ಲಿ ಕೇಳ್ಕೊಂಬಂದೆ. ನೀವು ಅಲ್ಲೇ ಓವರ್ ರೂಲ್ಡ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಅಂತ ಹೇಳಿ. Kindly peruse the page number 23 minutes. I filed application for relaxation.
Your petition was, your application was allowed.
First bail application is allowed.
Huh.
Thereafter, I filed application to modification of one condition, Lordship. He not appeared before the investigation officer within
Violation
10
of the
days.
condition.
Within 10 days. Therefore, that application is dismissed. Kindly peruse the observation, Lordship. ನಾನು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟರ್ ಮುಂದೆ ಅಪಿಯರ್ ಆಗಿ ಅಂದ್ರೆ ನಥಿಂಗ್ ಬಟ್ ಅದನ್ನ ಆನ್ಸ್ಪೆಕ್ಟರ್ ಬೇಲ್ ಓದಂಗೆ ಲೆಕ್ಕ.
Sir, when you have not complied with the directions issued while granting anticipatory bail, naturally you have to surrender.
ಅಲ್ಲ 307 ಮ್ಯಾಜಿಸ್ಟ್ರೇಟರ್ ಮುಂದೆ ಇದಾಗಕ್ ಬರಲ್ಲ. ಸರೆಂಡರ್ ಆದ್ರೆ ಅಲ್ಲಿ ಇದ್ ಮಾಡ್ಕೊಳಕ್ ಬರಲ್ಲ. Therefore, I request to.
You surrender before the jurisdictional court.
I sought a fresh anticipatory bail.
No, when you have not complied with the conditions imposed while granting the anticipatory bail, you are not entitled for that. Once it is granted, you are required to surrender before the jurisdictional court immediately. You have not complied with that.
It is a FIR stage, Lordship. ನನಗೆ ಐವ ಮುಂದೆ
Whatever it may be.
10 days ಕೊಟ್ಟಿದ್ರು.
I am not.
Due to health
concerned
condition, he has not appeared before the IO, Lordship.
No, nothing.
ಅದು maintainability ಬರುತ್ತೆ. It may be heard on main. It may be overruled and it may be heard on main.
Heard counsel for the petitioner on maintainability. The office objection regarding maintainability is ignored for the present. To hear on merits. Yes. Issue notice.
Issue notice to.
CGP takes notice. Yes.
Much of this.
Non-compliance of office objection for second time, serial number 16 and 17.
Counsel for the petitioner, absent error roll.
Non-compliance of office objection for third time, serial number 18, Abhinay Vaiti.
Counsel for the petitioner is absent, no representation. List finally as the last chance, in 10 days.
Non-compliance of office objection for fifth time, Niranjan Murthy LC.
Good. Counsel for the petitioner is absent, no representation. The petition is filed. This is seeking grant of bail on 7/2/2024. Office raised as many as 13 objections. The same are not complied with till date. I do not find any reason to adjourn the matter. This petition dismissed. Next.
Orders first time matter, serial number 20 to 30.
Ali, the same are not.
For
complied
serial number
with
20, my lord.
Same are not viewed in spite of listing the matter for the fifth time. Yes, first time. order.
Serial number one.
CGP takes notice for respondent, private respondent ಇದ್ದಲ್ಲಿ issue notice. Special PP ಇದ್ರೆ ಅವರಿಗೆ, yes. All these matter issue notice.
Serial number 30. Short
22.
date given, my lord.
Yes, yes. Short ಇರೋದು matters ಕಡಿಮೆ ಇದೆ, shortest date. Even without asking, it will be listed.
ಈ Saturday, short date.
ಕೊಡ್ತಾರೆ. ಹ? Before asking, the date is given as 22/6.
Great.
ಮಧ್ಯಾಹ್ನ. ಒಂದು ಕರಿಬೇಕಷ್ಟೇ ಇರೋದು. ಅದು ಮಧ್ಯಾಹ್ನ 2:30. ಆಯ್ತು. 2:30, Paso matters. Yes. ಎಷ್ಟಿದಾವೆ?
Serial number 26.
ಕೊಟ್ಟಿದ್ದಾರಾ? Next.
ಬರ್ಲಿಲ್ಲ ಬರ್ಲಿಲ್ಲ. ಫಸ್ಟ್ ಗೊತ್ತು.
After our matter, list one, serial number one, Gautam M, Tumbigi Prabhugod.
Yes.
Order. 439 petition, my lords.
Yes.
The accused is the sole accused under the POCSO. Really, with
When he
all,
was arrested?
he was arrested on 36/2023, my lords. So the charge sheet has been filed, all the witnesses has been examined. The deposition, I have to give the compilation before this honorable court.
Why should I consider that?
Because the statements of,
The duty of the trial court, not this court.
yes, ma'am.
I am not supposed to write the acquittal judgment.
Yes.
It is for
Allah.
the trial court.
So I have to rely on
Why
the,
I should assume the jurisdiction of the trial court?
because yakandre all the witnesses has been
Not
examined.
before the trial court, say the same thing.
All the witness,
For the trial court to appreciate the
yes, my lord,
evidence.
yes, please.
And if there are no materials, acquit the accused. I cannot write that judgment here. If all the witnesses are examined, what remains? Only 313 already recorded.
313 no agide.
Then
313,
just address the argument and do away with that. I will not entertain the case.
since because the bail order has been rejected on
Maybe, sir.
27/10.
In a week, you can address the argument and get the judgment of either acquittal or conviction.
Yes, liberty may be granted to file a,
ಗೊತ್ತಿಲ್ಲ ಏನು.
or else I'll argue on the merits. ma'am.
See, when you are confident of getting a judgment of acquittal, why you are seeking bail?
Because the bail application before the trial court has been rejected,
Maybe, sir.
I have,
About a year back, he was apprehended.
yes, my
Now
lord.
charge sheet is filed.
Yes,
All the witnesses are examined.
yes, my lord.
313 is recorded.
Yes,
What remains? Only addressing the argument.
yes.
Hmm?
313, I'm not sure that, 313.
Even if it is not
Yes,
done.
313, yeah,
Within
313,
a
I'm
day,
not,
it should be recorded.
yes, 313, I'm not sure.
No. ಇಲ್ಲ. ಏನು on merits ಆದ್ರೆ dismiss ಮಾಡ್ತೀನಿ.
My liberty may be given to the,
Liberty ಯಾಕೆ ಮಾಡ್ಬೇಕು?
so I'll approach the trial court first.
ಅದೇನಾದ್ರೂ ಮಾಡಿ.
ಆಯ್ತು.
Approach the trial court and address the argument.
Yes,
Don't file one more application. Don't burden the court.
ಆಯ್ತು.
Dismissed,
No,
Not
no,
pressed.
withdrawal, ಮಾಡಿ.
withdrawn.
Yes,
Yes.
for court.
Yes.
Serial number seven, Nanjunda Gowda MR. No, sir.
Counsel for the petitioner filed a memo reporting that the entire file is taken over by the petition, taken back by the petitioner with NOC on the wakalat. Memo is accepted. Counsel for the petitioner is permitted to retire. Petitioner, no one represents the petitioner. Petition is dismissed. Yes. ಬಂದಿದ್ರೆ ಕರೆದು ಬಿಡಿ ಅಷ್ಟೇ. 1 minute, 2:30 matter only.
This one for pronouncement of order, serial number 45, Ahan Mohan, Jaisimha Rao.
Petition is allowed. Impugned order passed in criminal miscellaneous number 961 of 2024 is set aside. Anticipatory bail granted to respondent number 2 and 3. That is accused number 1 and 2 is cancelled, acting under section 439(2) of CRPC. They are directed to surrender before the trial court within 7 days from today, that is on or before 26/6/2024 without fail. Registry is directed to communicate this order to the jurisdictional magistrate for information and for necessary action. Yes.
Last over matter, serial number 10, Sharath S. Gogi.
Matter is connected with 5378. It's not listed today. Accused number 3 also approached before this cause of court under
ಯಾವ್ದು? Serial number 10.
serial number 10. Accused
Yes.
number 3 also approached this court under 5378 of 2014.
There is-
May be taken on Your Lordship asking for warning passed on regarding antecedent He has having 2 more cases. I have sought for get the data FIR.
This petitioner is accused number 13.
13. He is having in another 2 cases he is accused He is same similar offences Therefore I sought for records to get along with the.
Is only one case he is accused, my lord. I also verified in 113, also is not
No,
accused in
but
140.
according to him, so there are some more cases.
Yes, there are
Let
cases.
him get the report.
I will get the the entire FIR and that details.
Requested.
Third learned counsel for the petitioner. Petitioner, learned HCGP pays for time to get the report from the IO regarding criminal antecedents and to make his submissions. When?
And connected matter along with.
No, my lord, it may be had on one day.
Next, it
Monday.
is also stated that
5378
criminal petition number
5378 of 2014.
is filed by
Accused number 3.
number 3.
33.
Is both these cases together.
My lord.
Yes.
Serial number 16, Mohammed Pasha.
The 439 minutes.
Yes. Petitioner is,
He is a sole accused minutes.
when he was arrested,
He arrested on 31/7/2023 minutes.
31.
7/2023 minutes.
Hmm.
The offense is 302.
302.
Complaint in a page number 18 minutes.
Who is the complainant?
Complainant who is one of the relative of the deceased, CW1, is by name Sandeep Kumar.
Hmm.
May I read the complaint? Page number 18.
Now charge sheet is filed.
Charge sheet is filed.
Where is the charge sheet?
Yes, ma'am. In the page number 28 onwards, my lordship.
Come to page number 37.
Yes, my lordship. May I read, my lordship?
Hmm.
Yes. ಈ ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯ ಕಾಲಂ ನಂಬರ್ 6 ಕಂಡ ಸಾಕ್ಷಿ 17ರವರ ಮೃತನ ಸಂದೀಪ್ ಕುಮಾರನ ಹೆಂಡತಿಯಾಗಿದ್ದು ಸಾಕ್ಷಿ 18ರವರು ತಂದೆಯಾಗಿರ್ತಾರೆ. ಕಾಲಂ ನಂಬರ್ 2 ಕಂಡ ಆರೋಪಿ ಮೃತ ಸಂದೀಪ್ ಕುಮಾರನ ಚಿಕ್ಕಮ್ಮನ ಮಗನಾಗಿರುತ್ತಾರೆ. ಮೃತ ಸಂದೀಪ್ ಕುಮಾರನು ಚಿಕ್ಕಜಾಳ ಪೊಲೀಸ್ ಠಾಣಾ ಸರದಿನ A2B ಹೋಟೆಲ್ ಹಿಂಭಾಗದ ಶಕ್ತಿ ನಗರದಲ್ಲಿ ಇರುವ RDC ಕಾಂಕ್ರೀಟ್ ಇಂಡಿಯಾ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಯಲ್ಲಿ ಪ್ಲಾಂಟ್ ಹೆಲ್ಪರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದು ಬಿಲ್ಲಮಾರನಹಳ್ಳಿ ಗ್ರಾಮದ KEB ಲೇಔಟ್ ಸಾಕ್ಷಿ 19ರ ಶೆಡ್ನಲ್ಲಿ ಸಾಕ್ಷಿ 2ರವರೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತಾನೆ. ಕಾಲಂ ನಂಬರ್ 2 ಕಂಡ ಆರೋಪಿ ಬಿಹಾರ ರಾಜ್ಯದ ಗುಲಿರೆ ಯಾತ್ರಿ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಸಾಕ್ಷಿ 17, 18ರವರು ಬಿಹಾರ ರಾಜ್ಯ ಬೇನಿ ಬಿಂಕ್ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. ಆರೋಪಿ ಸಂದೀಪ್ ಕುಮಾರನ ಹೆಂಡತಿಯಾದ ದಟ್ ಇಸ್ ಡಿಸೀಸ್ ಸಾಕ್ಷಿ 17ರವರ ಮೇಲೆ ಮನಸ್ಸಾಗಿದ್ದು ಆರೋಪಿ ಸಾಕ್ಷಿ 17ರವರಿಗೆ ಫೋನ್ ನಲ್ಲಿ ಮಾತನಾಡುತ್ತಿದ್ದ ವಿಚಾರ
Who is the deceased?
ಡಿಸೀಸ್ ಹೂ ಇಸ್ ಸಂದೀಪ್ ಕುಮಾರ್.
ಆರೋಪಿ ಸಂದೀಪ್ ಅಂತಾರೆ.
ಆರೋಪಿ ಈಸ್ ಸುಬೋಧ್ ಕುಮಾರ್ ಮಿಲಾಡ್ಶಿಪ್.
Deceased is Sandeep Kumar.
ಸಂದೀಪ್ ಫೋನ್ ನಲ್ಲಿ ಮಾತನಾಡಿದ ವಿಚಾರ
CW17 is his wife.
Yes, my lordship. She is wife of the deceased. ಸಾಕ್ಷಿ 17ರ ಮನೆಯಲ್ಲಿ ಒಬ್ಬರೇ ಆರೋಪಿಗೆ ಸಂದೀಪ್ ಕುಮಾರನ ಹೆಂಡತಿಯಾದ ಸಾಕ್ಷಿ 17ರವರ ಮೇಲೆ ಮನಸ್ಸಾಗಿದ್ದು ಆರೋಪಿ ಸಾಕ್ಷಿ 17ರವರಿಗೆ ಫೋನ್ ನಲ್ಲಿ ಮಾತನಾಡುತ್ತಿದ್ದ ವಿಚಾರ ಮತ್ತು ಸಾಕ್ಷಿ 17ರವರು ಮನೆಯಲ್ಲಿ ಒಬ್ಬರೇ ಇದ್ದ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಮನೆಗೆ ಹೋಗಿ ಬರುತ್ತಿದ್ದ ವಿಚಾರ ಸಾಕ್ಷಿ 18 ಮತ್ತೆ ಸಂದೀಪ್ ಕುಮಾರನಿಗೆ ಗೊತ್ತಾಗಿ ಸಾಕ್ಷಿ 18 ಮತ್ತು ಸಂದೀಪ್ ಕುಮಾರ್ ಆರೋಪಿಗೆ ಸಾಕ್ಷಿ 17ರವರಿಂದ ದೂರವಿರು ಎಂದು ಎಚ್ಚರಿಕೆ ನೀಡಿದ್ದು ಈ ವಿಚಾರವಾಗಿ ಆರೋಪಿ ಆಕ್ರೋಶ ಭರಿತನಾಗಿ ಸಂದೀಪ್ ಕುಮಾರನಿಗೆ ಏನಾದರೂ ಮಾಡಿ ಕೆಡುಕು ಮಾಡಬೇಕೆಂದು ಸಾಕ್ಷಿ 17ರವರನ್ನು ಹೋಲಿಸಿಕೊಳ್ಳಬೇಕೆಂದು ಅದಕ್ಕೆ ಅಡ್ಡಲಾಗಿ ಸಂದೀಪ್ ಕುಮಾರನನ್ನು ಜೀವಂತವಾಗಿ ಇಲ್ಲದಂತೆ ಮಾಡಬೇಕೆಂದು ತೀರ್ಮಾನಿಸಿ ಆರೋಪಿ ದಿನಾಂಕ 28/7/2023ರಂದು ಸಾಕ್ಷಿ 2 ಮತ್ತು ಸಂದೀಪ್ ಕುಮಾರನ ವಾಸವಿದ್ದ ಶೆಡ್ಡಿಗೆ ಬಂದು ಆ ದಿನ ಅಲ್ಲೇ ಇದ್ದು ಸಾಕ್ಷಿ 29/7/2023ರಂದು ಬೆಳಿಗ್ಗೆ ಸಾಕ್ಷಿ 20ರವರ ಬಾರಿನಲ್ಲಿ ಆರೋಪಿ ಸಂದೀಪ್ ಕುಮಾರನಿಗೆ ಮದ್ಯಪಾನ ಮಾಡಿ 11 ಗಂಟೆಗೆ ಸುಮಾರಿಗೆ ಶೆಡ್ಡಿಗೆ ಬಂದಾಗ ಸಂದೀಪ್ ಕುಮಾರನು ಆರೋಪಿಗೆ ನೀನು ಯಾಕೆ ನಮ್ಮ ಮನೆಗೆ ಹೋಗುತ್ತೀಯಾ ಎಂದು ಬೈದು ಗಲಾಟೆ ಮಾಡಿ ಮಲಗಿದ್ದು ಆರೋಪಿ ಮಲಗಿದ್ದ ಸಂದೀಪ್ ಕುಮಾರನ ಮುಖ ಮತ್ತು ಹೆಣೆಯ ಭಾಗಕ್ಕೆ ಸಿಮೆಂಟ್ ಇಟ್ಟಿಗೆಯಿಂದ ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹಲ್ಲೆ ಮಾಡಿ ರಕ್ತ ಗಾಯಪಡಿಸಿ ಕೊಲೆ ಮಾಡಿದ್ದು ತನಿಖೆಯಿಂದ ದೃಢಪಡಿಸಿದೆ. My Lordship, in this matter, there is no eyewitness to the incident. The entire case rests on the circumstantial evidence. Can you see the complaint that is find the page number 18, my Lordship?
What are the circumstantial evidence?
Yes, circumstantial.
What are the circumstances?
Circumstantial is, my Lordship, on fateful day, the petitioner accompanied the deceased at about morning 11 o'clock.
Who have seen that?
It is that some photos have taken by the investigation officer in this regard.
Somebody must have seen him going to the house of the deceased.
My Lordship, in this regard, the complaint itself reflects that in the morning, that about 9 o'clock, accused number, the petitioner and the deceased left the shed in the morning to attend their daily routine work.
Yes.
That is only the last scene theory. Subsequently, when the deceased came to the shed and whether the petitioner accompanied the deceased, there is no.
No, I am asking you, what are the circumstances
That-
relied on by the prosecution?
That is only when the deceased and the petitioner went to the bar in the morning 11
There
o'clock.
are no other circumstances.
Nothing, no other strong
There
circumstances.
is no recovery.
Nothing. My Lordship, kindly see 29/7/2023, CW1 come across about the incident through CW2.
CW,
2. One Gagan,
who came to know?
who is who also working in the same company along with the deceased, Dharminder.
ಏನ್ರಿ? ಏನಿದೆ?
Lord, there is a recovery, my lord, blood stained brick, cement brick, my lord, it is used for the commission of offense. And moreover, wife of the deceased herself is the, my lord, she has state, my lord, this petitioner, my lord, used to come to and is trouble, giving trouble to this, my lord, the wife of the, my lord, the deceased. My lord. I have interest in her, therefore, that is the, my lord, statement. And my lord, bar, last seen witness, my lord, bar owner, my lord, bar cashier.
CW?
Please.
CW?
CW 20, my lord.
20.
20. He has seen, my lord,
Is the bar owner,
bar cashier, my lord.
cashier?
Cashier. Last seen, my lord, with the, my lord, deceased petitioner. And moreover, my lord, PM report also support the case of the prosecution. There are 13 injuries, my lord, to the, my lord, the body of the, my lord, the deceased, my lord. And, my lord, death also, on PM report also, my lord, is he died due to, my lord, head injury. Therefore, my lord, there is a prima facie case, my lord.
May make a submission. 29/7/2023, CW1 come across about the mishap through CW2, who is an inmate of the deceased.
Yes.
My Lordship, immediately the complaint was not registered. Next day, that is on 30/7/2023, case was registered.
Yes.
As per the prosecution, 31st, next day, the accused was arrested.
Mm.
In fact, the same day, he was taken to the custody. When their suspicious arised, he was taken to the custody.
Yes.
They interrogated. Lordship, straight away when the complaint lodged, the police visited the spot and the body also shifted to the hospital mortuary. After after arresting the petitioner, that is on, after lapse of 2 days, Caesar Mazar was conducted after lapse of 3 days, my Lordship. Really appreciate here. Police visited the spot, body was shifted to the hospital, and they thoroughly searched the place, inside and outside the place. They have nothing was found.
Any spot measure was held?
Yes, my Lordship. Kindly see the spot measure. I have placed in
Where the brick was recovered?
after arrest of the
From which place?
The same place. And that body was laying. Kindly see in the page number 50, my lordship. It is created. Page number 50, my lordship.
Hmm.
I would like to read third para, my lordship. ನಂತರ ಪಂಚರಾದ ನಾವುಗಳು ಪೊಲೀಸರ ವಶದಲ್ಲಿದ್ದ ಸುಬೋಧ್ ಕುಮಾರ್ ಪೆಟಿಷನರ್ ಎಂಬುವರನ್ನು ವಿಚಾರ ಮಾಡಿದ್ದು ಆತನು ತಾನು ಸಂದೀಪ್ ಕುಮಾರನ್ನು ಸಿಮೆಂಟ್ ಇಟ್ಟಿಗೆಯಿಂದ ಮುಖ ಮತ್ತು ತಲೆಯ ಭಾಗಕ್ಕೆ ಹೊಡೆದು ಕೊಲೆ ಮಾಡಿರೋದು ಹಾಗೂ ಸಿಮೆಂಟ್ ಇಟ್ಟಿಗೆಯನ್ನು ಮತ್ತು ಸಂದೀಪ್ ಕುಮಾರನ ಮೊಬೈಲ್ ಅನ್ನು ಸೈಟ್ ನಲ್ಲಿ ಹಾಕಿರುವುದು ತಿಳಿಸಿದನು.
Yes.
So next page, in the page 51, my lords.
The offense was committed in the house, is it?
In the house itself.
Site
Can-
andre?
Can you see page number?
Site andre?
ಆ ಸೈಟ್ ಅಲ್ಲಿ ಶೆಡ್ ಒಂದು ಶೆಡ್ ಇತ್ತು, ಆ ಶೆಡ್ ಅಲ್ಲಿ ಆಗಿದೆ ಅಂತ ಹೇಳೋದು.
Site, shed alla.
No, as per the prosecution case, when the deceased was sleeping, that point of time on account of personal differences, the petition
Sir, I understood that, sir. The offense was committed inside the house,
inside the house,
not in the open site.
not in the open side.
Here, the accused stated that he has left the cement brick
Brick.
and the mobile
Mobile.
in the site.
Kindly see in the page number 51 in this regard, my lord. In this regard, the clarification will forthcoming.
And he was taken to a site,
Yes, my lord.
ಸೈಟಿನ ಮುಂಭಾಗಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋದಾಗ
ಹೌದು.
ಖಾಲಿ ಸೈಟು,
ಖಾಲಿ site.
ರಸ್ತೆ ಇರುವುದು, ಅಲ್ಲಲ್ಲಿ ಮನೆ ಇರುವುದು ಕಂಡು ಬಂದಿದೆ.
Yes, ma'am. Kindly see page number 51, my lords. Next page. Very next page. In second para. ನಂತರ ಆರೋಪಿ ನಮ್ಮನ್ನು ಶೆಡ್ಡನ ಹೊರಭಾಗಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ಶೆಡ್ಡನ ಮುಂಭಾಗದಲ್ಲಿ ಇದ್ದ ಒಂದು ಸಿಮೆಂಟ್ ಇಟ್ಟಿಗೆಯನ್ನು ತೋರಿಸಿ ಇದೇ ಇಟ್ಟಿಗೆಯಿಂದ ಸಂದೀಪ್ ಕುಮಾರನ್ನು ಕೊಲೆ ಮಾಡಿದ್ದನ್ನು ತಿಳಿಸಿ ಹಾಜರುಪಡಿಸಿದ ಮೇರೆಗೆ ಸದರಿ ಇಟ್ಟಿಗೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸುಮಾರು 6x9 ಸುತ್ತಳತೆಯ ಚೌಕಾರಾದ ಸಿಮೆಂಟಿನ ಇಟ್ಟಿಗೆಯಾಗಿರುತ್ತದೆ. ಸದರಿ ಇಟ್ಟಿಗೆಯಲ್ಲಿ ಅಲ್ಲಲ್ಲಿ ರಕ್ತ ಕೊಲೆ ಆಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನಂತರ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆರೋಪಿ ಸಂದೀಪ್ ಕುಮಾರ್ ಉಪಯೋಗಿಸುತ್ತಿದ್ದ ಮೊಬೈಲ್ಗೆ ವಿಚಾರಿಸಿದ್ದು ಆರೋಪಿದ ಸುಬೋಧ್ ಕುಮಾರ್ ಇದೇ ಸೈಟ್ ನಲ್ಲಿ ಉತ್ತರದ ಕಾಂಪೌಂಡ್ ಗೋಡೆಯ ಕಡೆ ನಮ್ಮನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಬೆಳೆದಿದ್ದ ಹುಲ್ಲು ಮತ್ತು ಗಿಡಗಳ ಮಧ್ಯದಿಂದ ಒಂದು ಮೊಬೈಲ್ ಅನ್ನು ತೆಗೆದು ಹಾಜರುಪಡಿಸಿದ್ದು ಪರಿಶೀಲಿಸಲಾಗಿ ಮೊಬೈಲ್ ಸ್ಕ್ರೀನ್ ಒಡೆದು ಹೋಗಿರುವುದು ಕಂಡು ಬಂದಿದೆ. What I am making to make submission here, very immediately the police visited the spot while lodging the complaint. And thoroughly they searched. Nothing has been found at that point of time.
Recovery was not from inside the shed. It was outside.
Out just in front of the shed. When the brick was lying in front of the shed, what prevented the officer to take that particular object?
No, that
That
cannot
is
be.
one aspect. Another important aspect, my lordship, as per the prosecution, the mobile phone also seized from the said spot. Here, no fingerprints were found with respect to the petitioner is concerned. Can you see the statement of deceased wife? There was no such terms between the petitioner and the deceased wife. In page number 66, my lordship. Last para, my lordship.
ಇರಿ.
Below, last para. ಆಗ ಸುಬೋಧನು ನಾನು ಮದುವೆ ಆಗಲು ದಟ್ ಪೆಟಿಷನರ್ ಸುಬೋಧನು ನಾನು ಮದುವೆ ಆಗಲು ಹೆಣ್ಣು ನೋಡುತ್ತಾ ಇದ್ದೀನಿ. ನಮ್ಮ ಮನೆ ಸರಿ ಇಲ್ಲದೆ ಇರುವ ಕಾರಣ ನನಗೆ ಯಾರು ಹೆಣ್ಣು ಕೊಡ್ತಾ ಇಲ್ಲ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ಮನೆಯನ್ನು ತೋರಿಸಿ ಇದೇ ನಮ್ಮ ವಾಸದ ಮನೆ ಅಂತ ಹೆಣ್ಣು ಕೊಡುವವರಿಗೆ ಹೇಳಿ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳೋಣ ಅಂತ ನಿಮ್ಮ ಊರಿಗೆ ಬಂದಿದೆ. ಅದನ್ನು ಬಿಟ್ಟರೆ ಬೇರೆ ಏನು ವಿಷಯ ಇಲ್ಲ ತಿಳಿಸಿದ. ಈಗ 15 ದಿನಗಳ ಹಿಂದೆ ಈ ವಿಚಾರ ನನ್ನ ಗಂಡನಿಗೆ ಗೊತ್ತಾಗಿ ನನ್ನ ಗಂಡ ಸುಬೋಧನಿಗೆ ಫೋನ್ ಮಾಡಿ ಸುಬೋಧನ ಮೇಲೆ ಕೂಗಾಡಿ ಜಗಳ ಮಾಡಿ ಪೂಜಾ ದೇವಿಯಿಂದ ದೂರ ಇರು ಎಂದು ಎಚ್ಚರಿಕೆ ನೀಡಿದೆ. That's it.
What is the motive?
Yeah. Here the motive is not tenable because, my lordship, can you see, if the deceased has come across about the conduct of the petitioner towards his wife, definitely he never allowed to stay in his shed.
Yes.
But as per the prosecution case, he invited the petitioner who went to the shed and stayed together for one day, and they had drinks and all other things. That is also quite unnatural. And moreover, my lordship, in this regard, there is no lost sin theory. There is no lost sin theory. And after securing the accused, the complaint was manipulated.
CW 20.
Yes, my lordship. The reason is very simple, my lordship, the prosecution has suppressed many aspects in this case. As far as
That
the,
is all your defense, sir.
Yes, my
We
lord.
have to see the prima facie materials placed before the court by the prosecution.
Absolutely, my lordship.
They are relying on
Yes,
statement of CW 17
kindly
to
see.
support their contention that you had the motive.
Yes, my lord.
They rely on the statement of CW 20 to say that the cashier in the bar has last seen the deceased in the in your company.
At about
And
11 o'clock.
further, there is recovery of blood-stained brick,
At about 11 o'clock,
Hmm.
incident happened in the night.
whatever it may be.
Kindly see another aspect, my lordship. Here, the inquest also prepared. Incident occurred on 29/7/2023. After lapse of 4 days, the 3 days, the inquest is prepared. Because in order to gather all the information, because that point of time, the petitioner was in the custody of the police. Voluntary statement recorded. Based on their voluntary statement, other statement have been recorded in the inquest report. That is the only reason to record the inquest report in order to suit their case. What was the difficulty to
What will be there in the inquest report?
the voluntary statement of the accused?
Why voluntary statement of the accused is necessary for drawing inquest measure?
Because in order to give all the information to the prosecution.
What information, sir?
No, no,
Inquest measure basically will be drawn to show the position of the
dead body.
dead body.
Absolutely.
What are the injuries found on the
Absolutely.
dead body?
And
That's
also,
all. Why voluntary statement of the accused?
no, 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 the other witnesses' statements recorded at
Why?
point, in order to
was the
suit their
necessity?
case, in order to suit their case, to crack the case, my lordship, that is, kindly see, in while lodging the complaint, neither a CW 1 and 2 and the other witnesses have provided all those precious information which is forthcoming in the subsequent
Initially, no
events.
such information will be available. It is only during investigation, it will be unearthed.
Lordship,
That
kindly,
is why the investigation will be held.
absolutely, kindly appreciate here, if accused was not arrested, that point of time, whatever the proceedings took place in this regard, certainly it could be upheld. That is a natural way, because they gather all the information and the same is correspondence to the other
If
witnesses.
the accused was not apprehended, there is no question of recovery. There will not be any question of recovery.
My lordship, kindly appreciate 27.
There will not be
evidence.
any question of CW 20 saying that I had seen the accused in the company of the deceased.
My lordship, what I'm making to convince this honorable court, recovery is concerned.
Hmm.
3 days gap is there. In this duration, the investigation officer oftenly visited the spot. Though the brick is lying in front of the shed where the incident occurred, where they have not seen. That is one aspect. Another aspect is that
It was not inside the shed.
just also outside the shed, in front of the open field, it is not an isolated place. To draw inference that at the instance of the petitioner, it has been recovered. It is appear to every public that to just in front of the shed, my lordship. It is nothing but it created. And the PM report also conducted after lapse of 3 days. And more so, here the prosecution case is
When
that
the incident had occurred,
29/7, my lordship,
29/7.
2023.
At what time?
And the time is not mentioned, but it appears in the night hours. 9 o'clock, CW2 visited the shed. He saw that the body is lying in the pool. And one more aspect to be appreciated.
9 o'clock in the night, is it? 9 o'clock in the night.
9 o'clock. In complaint
The
itself,
dead body was found.
he saw the dead body was lying in the shed.
When the complaint was filed.
On the 30, my lordship, next day.
Time.
Timing is 6:30, my lordship, evening.
Hmm.
And moreover, my lordship,
When the inquest was conducted.
inquest 31 minutes. In the page number 39, my lordship,
30?
39, page number 39,
Date of inquest is 31st.
31/7/2023.
Yes. At what time?
In the more. ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಯಿಂದ 12 ಗಂಟೆ ಸರ್.
Immediately thereafter, PM.
PM, yes.
On
That
the
is on
same
next
day.
day. That is on next day. In the page number 48, my lordship.
That is on 1st August.
That is on 3/8, my lordship, after lapse of 60 days.
No, how it will inure to your benefit, I don't know.
No, actually, I'm not, I don't want to highlight the PM report is concerned. As far as the inquest report and the complaint and the material placed by the prosecution is itself indicates that the petitioner has been roped in the false case. In order to crack the case, that's it. My lordship kindly appreciate here, the deceased who is working in a Chikjala police station limit as a security guard. This petitioner working in the
every,
Banshankari, my
each and
lordship.
every case, the defense of the accused will be false implication.
No, based on the material placed by the prosecution.
That is what prima facie, there is recovery, there is a CW20 who is not concerned to the deceased, or CW17 says that I had seen him in the company of the accused. Why he is to be disbelieved?
My lordship, he accompanied and they had a drinks in the morning hours. Thereafter, what happened, the petitioner is not aware. He is working in a Banshankari, my lordship. If suppose he visited the spot of the deceased at night hours, certainly at least the IO could have been collected the details from his company, whether he has been absent or present in that particular company. He has not collected. Can you see the photo of the deceased? The allegation in the prosecution case is that in a brick, he has smashed the face and head of the deceased. But the photo indicates that there is no such injuries found on his head and face, my lordship. There are so many rivalries against the deceased. He is a drunkard and he used to playing gambling and taking hand loans from the various people of his native place. So many persons of his native place are working in the Bangalore. So many inimicals are there. Who committed the murder? Nobody's known. In order to crack the case, the petitioner has been roped in this matter, my lordship.
All this argument will hold good before the trial court while seeking acquittal.
As far as liberty is concerned, there is no material.
That can be considered by the trial court on the basis of the evidence of the witnesses.
He has no antecedent. He is just an earning member to his entire family members. Can the statement of the deceased wife
Who are
itself,
depending upon him? He is not married. He is not with his parents. Who are there?
just two brothers?
Nobody.
Two brothers.
Brothers, they will eke out their livelihood.
As far as the
He is
prosecution,
the only person, he came here.
no, since from 3
And
years,
he had an eye on this CW17.
it's not like that.
Ah.
Since 3 years, he is working in the Banshankari, my lordship.
No.
That is not,
Yes,
He-
what
he
do you
has-
say? Why there is delay?
Lord, he is arrested on, my lord, 1/8 itself. Accused is arrested on, same day, my lord, Mahajara has been conducted, my lord. And the bricks, my lord, the bloodstains, bricks are recovered on the same day itself. On his, my lord, he has shown the, my lord, place of incident, my lord. And not only bricks, my lord, the mobile phone also seized from the, my lord, on the spot.
Mobile phone
Of the petitioner.
petition.
Oh, yes,
petitioner
my lord.
deceased though.
Deceased.
Deceased
Deceased, my
also.
lord, assaulting, my lord, the mobile phone was broken, my lord. That is Mahajara ಬಂದಿದೆ.
ಅದು ಯಾವ್ದು ಫಿಂಗರ್ ಪ್ರಿಂಟ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ತಗೊಂಡು ಬಿಸಾಕಿದ್ದ ಅಂತ ತೋರ್ಸೋದಿಕ್ಕೆ. ಆಮೇಲೆ ಸುಮಾರು ಜನ ನೇಬರ್ಸ್ ಇದಾರೆ ಸ್ವಾಮಿ. ಈವ್ನಿಂಗ್ ಅವ್ನು ಬಂದಿದ್ದ ಅವನ ಜೊತೆಲಿ ಅಂತ ಯಾರ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೂಡ ಇಲ್ಲ ಸ್ವಾಮಿ. ಸಾಕಷ್ಟು ಶೆಡ್ಸ್ ಇದೆ ಪಕ್ಕದಲ್ಲೇ ಸ್ವಾಮಿ. Only in order to crack the case, the petitioner is shown as a culprit in this matter. There is no incriminating evidence.
These are all incriminating, sir. That cannot be ignored now. No. Nobody.
May permit to withdraw the petition.
Withdrawing.
Yes, please.
Counsel for the petitioner after addressing the argument at length seeks permission to withdraw. The motion
Yes, sir.
taken upon you in this- That's it.
Number 20, Naveen HM.
Yes, DNI, TAP.
In this case, my lord, Arun Kumar, my lord, who is a victim, my lord, again, my lord, he has also, my lord, participated in the TI period, my lord, he has,
Where is it?
it is here.
He is injured.
Yes, injured himself has identified.
Injured identified there.
The,
Accused number 3.
please, yes, identified.
Where is it? What about two eyewitnesses, whether they have identified,
They also, my lord, they also conducted TA period, my lord, they have also
identified this petitioner?
Yes, my lord, yes.
ಐ ವಿಟ್ನೆಸ್ ಯಾರು ಕೂಡ ಅಕ್ಯೂಸ್ಗಳನ್ನ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ನೋಡೋಣ.
ಮತ್ತೆ ವಿಕ್ಟಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಇರಿ,
ಕೊಟ್ಟಿದ್ದಾರೆ
ಇರಿ.
ಸ್ವಾಮಿ.
ಅರುಣ್ ಕುಮಾರ್ my lord.
ಅರುಣ್ ಕುಮಾರ್ ಅಂತ ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ?
ಅಲ್ಲಿ ಗುರುತಿಸಲ್ಪಟ್ಟವರು ಕಾಲಂ ಮಾಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್
ಭಾಗವಹಿಸಿದ ಆರೋಪಿಗಳು ಅರುಣ್ ಕುಮಾರ್.
ಅರುಣ್ ಕುಮಾರ್, ಆಮೇಲೆ ಗುರುತಿಸಲ್ಪಟ್ಟವರು ಗಿರೀಶ, ಆಮೇಲೆ
ಇವು ಪೆಟಿಷನರ್ ಯಾರ ಹೆಸರು?
ಗಿರೀಶ್.
ಪಿಟಿಷನರ್ ಗಿರೀಶ್
ಗಿರೀಶ್.
ಗಿರೀಶ್.
ಟೆನ್.
ಹೌದು. ಹೆಸರು ಸಮೇತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
Yes, Girish is identified by
Yes,
CW1
Please.
complainant.
Yes.
Where is the other?
Raghavendra and Sridhar also identified. PW, CW 11 and 12.
ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ಎಲ್ಲಿದೆ ಅದು? ಕೊಡಿ.
ಇದರಲ್ಲಿ ವಿಕ್ಟಿಮ್ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ 16/1/2024 ಮೋಟರ್ ಸೈಕಲ್ ನಲ್ಲಿ ಬಂದು ಜಗ್ನಲ್ಲಿ ಆಸಿಡ್ ಅನ್ನು ಎರಚಿದವರನ್ನು ನೋಡಿ ಗುರುತಿಸಿದ್ದು. ಅವರ ಪೈಕಿ ಒಬ್ಬ ನನಗೆ ಆಸಿಡ್ ಎರಚಿದವನು, ಆತನ ಹೆಸರು ನಿತಿನ್ ಕುಮಾರ್. A2 ಆರೋಪಿ ಸರ್. ಆಲ್ರೆಡಿ ಬೇಲ್ ಆಗಿದೆ ಸರ್ ಆಲ್ರೆಡಿ. ಮತ್ತೊಬ್ಬ ಮೋಟರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದವನು, ಆತನ ಹೆಸರು ಗಿರೀಶ್.
Considering the test identification period.
ಹೌದು.
The
Girish
victim,
petitioner,
the
Swami.
injured has identified you in the test identification period.
ಎಸ್ ಸ್ವಾಮಿ.
It is one of the strongest circumstances against you.
ಎಸ್ ಮೇಡಮ್.
Now he is saying even the witnesses have identified.
ಎಸ್ ಮೇಡಮ್.
Let us see.
ನಮ್ಮ ಪಿಟಿಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 80 ಮೇಲೆ ನಮ್ಮ ಪೇಜ್ ಅಲ್ಲಿ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. ವಿಟ್ನೆಸ್ ಲಿಸ್ಟ್.
Page number?
80 ಮೇಲೆ 80. ಲಾಸ್ಟ್ 11.
ಅದಾಯ್ತು, ಅದು ಬೆಳಿಗ್ಗೆ ನೀವು ತೋರಿಸಿ.
ನಾನು ಮೇಲ್ಕಂಡ 14 ಜನ ಆರೋಪಿಗಳ ಪೈಕಿ ಯಾವುದೇ ಆರೋಪಿಗಳನ್ನು ಗುರುತು ಹಚ್ಚಿರುವುದಿಲ್ಲ.
ಬಟ್ ಇದ್ರಲ್ಲಿ ನೋಡಿ, ಕಾಲಮ್ ನಂಬರ್ 10 ಅಲ್ಲಿ.
ಗುರುತಿಸಲ್ಪಟ್ಟ ಅಪರಾಧಿ ಹೆಸರು ಅವ್ರು ಪಡಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ, ಬಟ್ ಟೈಪಿಂಗ್ ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಇವರು ಆರೋಪಿಗಳು ಗುರುತಿಸಿ ಮಾಡಿರೋ ಸ್ವಾಮಿ
ಅಲ್ಲೂ
82
ಕೂಡ ಬಂದಿದೆ. accused number
82
3.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಇದೆ ಸರ್ ಮೇಲೆನೆ. ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. 82 ಸ್ವಾಮಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ 1ನೇ ಸುತ್ತಲ್ಲಿ.
ಶ್ರೀಧರ್ means CW?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಯಾರು ಇಲ್ಲ. ಶ್ರೀಧರ್.
ಹಾ?
ಶ್ರೀಧರ್ TW
Sridhar is
12
CW
12 ಮೇಲೆ 12.
He identified accused number 3.
ಇಲ್ಲ ಮೇಡ, ಒಂದು ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ 82 ಪೇಜ್ ನಂಬರ್ ಮೇಲೆ 82 ಅಲ್ಲಿ ಮುತ್ತುರಾಜ್
80,
ಮತ್ತೆ
page 80.
ತಿಮ್ಮೇಶ್ ಅನ್ನೋನ್ನ ಫಸ್ಟ್ ರೌಂಡ್ ಮುತ್ತುರಾಜ್
That's
ಮತ್ತೆ
page number 80,
ಹಾ ಮೇಡಮ್.
ಕಾಲಮ್ ನಂಬರ್ 10.
ಹಾ ಮೇಡಮ್.
ಗುರುತಿಸಲ್ಪಟ್ಟ ಅಪರಾಧಿಯ ಹೆಸರು.
ಹೌದು ಸ್ವಾಮಿ. ಫಸ್ಟ್ ರೌಂಡ್, ಸೆಕೆಂಡ್ ರೌಂಡ್, ಒಟ್ಟು 3 ರೌಂಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 3 ರೌಂಡ್ ಅಲ್ಲಿ ಕೂಡ
ಕ್ರಮ ಸಂಖ್ಯೆ 5 ನಿತಿನ್ ಕುಮಾರ್ and 10 ಗಿರೀಶ್. They were identified.
ಅಲ್ಲ 3 ರೌಂಡ್ ಅಲ್ಲೂ ಕೂಡ ಆರೋಪಿಗಳು ಯಾರು ಪತ್ತೆ ಹಚ್ಚಿಲ್ಲ ಸ್ವಾಮಿ ಇವರು. 3 ರೌಂಡ್ ಆಗಿ ಅಲ್ಲಿ ಟೈಪಿಂಗ್ ವ್ಯತ್ಯಾಸ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ
ಟೈಪಿಂಗ್
ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿದೆ, ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಆಗಿದೆ ಸ್ವಾಮಿ. ಯಾಕೆಂದ್ರೆ ಇಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ ಅದನ್ನು
ವೆರಿ ಸ್ಪೆಸಿಫಿಕಲಿ ಸ್ಟೇಟೆಡ್. ಗುರುತಿನ ಕವಾಯತಿಯಲ್ಲಿ ಗುರುತಿಸಲ್ಪಟ್ಟ ಅಪರಾಧಿಯ ಹೆಸರು. Accused number 3 is mentioned there. Even the CW1, CW12, and what about CW11?
ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಮುತ್ತುರಾಜ್ ಮತ್ತೆ ತಿಮ್ಮೇಶ್ ಅನ್ನೋರ್ನ ಶ್ರೀಧರ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡ್ತಾನೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 82 ಅಲ್ಲಿ. ಸೆಕೆಂಡ್ ರೌಂಡ್ ಅಲ್ಲಿ ಯಾರನ್ನೂ ಕೂಡ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ.
ಯಾರು ಇಲ್ಲ ಸರ್. ಪೇಜ್ ನಂಬರ್ ಕಾಲಮ್ ನಂಬರ್ 10 ನೋಡಿ.
ಹೌದು.
What does it mean?
ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೂಡ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ ವಿಕ್ಟಿಮ್ ಇವನು ಆಸಿಡ್ ಎರಚಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ಸ್ವಾಮಿ ವಿಕ್ಟಿಮ್ ಕೂಡ ಸ್ಟೇಟ್ಮೆಂಟ್ ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್ 37 ಮೈಲ 37 ಪೇಜ್ ನಂಬರ್.
ಅದೆಲ್ಲ ಇರ್ಲಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಇರ್ಲಿ, ಬಟ್ ಸ್ಟ್ರಾಂಗೆಸ್ಟ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಇಸ್ ದ victim has identified you in the test identification period. So what?
ಫ್ಯಾಮಿಲಿ ಇದಾರೆ ಸ್ವಾಮಿ ಎನಿ ಕಂಡೀಷನ್ಸ್
ಸರ್, ಎಲ್ಲರಿಗೂ ಫ್ಯಾಮಿಲಿ
ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ.
If that is the yardstick, no one can be sent to jail. ಎಲ್ಲರಿಗೂ ಫ್ಯಾಮಿಲಿ ಇರ್ತಾರೆ, ಎಲ್ಲರಿಗೂ ಮಕ್ಕಳು ಇರ್ತಾರೆ. That is not the yardstick. ಅದೆಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಹೇಳೋದು, ಸಣ್ಣ ಪುಟ್ಟ ಪೆಟ್ಟಿ ಅಫೆನ್ಸ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಆಗ ಹೇಳೋದು.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಏನು ರೋಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಗಂಡ ಇದ್ದಾರೆ,
ಅಕ್ಯೂಸ್
family ಇದ್ದಾರೆ.
ನಂಬರ್ 3 ಜಸ್ಟ್ ಬೈಕ್ ಅಲ್ಲಿ ಕೂತಿದ್ನ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಇವನು ಆಸಿಡ್ ಹಚ್ಚಿಲ್ಲ ಸ್ವಾಮಿ. ಇವನು ಆಸಿಡ್ ಹಚ್ಚೋದಕ್ಕೆ ಆಲ್ರೆಡಿ ಸೆಷನ್ ಕೋರ್ಟ್ ಆಲ್ರೆಡಿ ಬೇಲ್ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ ಆಲ್ರೆಡಿ.
No. Petitioner being accused number 3 is before this court seeking grant of bail. He was apprehended on 24/1/20. Since then he is in judicial custody. Any antecedents?
No antecedent.
No.
No. Investigation already completed.
Completed. 326 A.
ಎಲ್ಲಿ resident of?
He is a resident of
ಹಿರಿಯೂರು ಆರ್ಟಿಕೋಟೆ.
Condition?
326 A, my lord.
A ಇದೆ.
Lord.
ಏನು, what is the nature of injury?
Serious injuries, my lord.
ಎಲ್ಲಿದೆ?
There are grievous.
Certificate ಎಲ್ಲಿ?
Yes, ma'am.
What is the condition of the injured?
Still, my lord, he is taking treatment. My lord.
Wound certificate ಇದೆ. Yes, have you produced a wound certificate? Injury certificate?
And photographs also is there, my lord. Entire body, my lord, has been.
ಇದರಲ್ಲಿ ಏನು ಅರ್ಥನೇ ಆಗೋದಿಲ್ಲ ಇದು.
Last ಅಲ್ಲಿ.
Superficial to deep burn over right upper limb,
Photographs.
right arm, right side of chest. Superficial to deep burn on the right side of face. ಎಲ್ಲಿದೆ ಫೋಟೋಸ್?
Xerox.
ಫೇಸು, ಚೆಸ್ಟ್, ದೆನ್
Voluminous ಇದೆ.
ಇಲ್ಲ ತಗೊಳ್ಳಿ. Petitioner being accused number 3 is seeking grant of bail. He was apprehended on 24/1/2024. Since then he is in judicial custody. The injured lodged the first information. FIR is against unknown persons.
ಅನ್ನೋನ್ ಪರ್ಸನ್.
Unknown persons alleging that he was attacked with an acid by the unknown persons and he sustained burn injuries. During investigation, the petitioner was apprehended and the test identification period was conducted. The documents produced before the court discloses that CW1, the injured eyewitness, and CW12, the eyewitness, have identified this petitioner during test identification period. The wound certificate discloses that the injured sustained 3 grievous injuries, that is superficial to deep burns over right upper limb and right arm ಅದೆಲ್ಲ ಇದೆ ನೋಡಿ ಅದನ್ನ ಕೇಳ್ಕೊಂಡು ಮಾಡಿ more injury ಇದೆ so and so on which are grievous in nature. The investigation is completed and charge sheet is filed. It is stated that the injured is taking treatment for the burn injuries. On consideration of these materials that are placed by the prosecution, the contention of the counsel for the petitioner that the petitioner is falsely implicated in the matter cannot be accepted. Even though it is stated that accused number 2 is already enlarged on bail, the allegation against accused number 2 is entirely different, as he is not alleged that it was accused number 2 who poured acid on the injury. Therefore, I am of the opinion that the petitioner is not entitled for grant of bail. Accordingly, dismissed.
Serial number 26, Prasanna DP.
And for the petitioners. Four 38 petition, my lord.
Yes.
Petitioner is the sole accused. For the offense on section 354B, 363, 417, 313, 113, 506, 504 of IPC, my lord. The case of the respondent number 2 and 3, who are the complaints before the trial court, my lord.
Private complaint.
Private complaint, my lord. They have filed the private complaint in PCR number 73/2023, my lord, on 11/8/2023. Alleging that, my lord, on 4/3/2023, 2023, there was a national level kabaddi tournament in Somarpet town, my lord, where the third respondent being the PT teacher who participated as the umpire in the tournament. And
Who was the umpire?
my lord,
Who was the umpire?
the third respondent hearing, Mohan,
That is complainant number 2.
complaint number 2, was the umpire. And the accused petitioner tried to assault him on that
Police constable.
police constable, my lord. Police constable. He tried to assault him. And it is further alleged that on the very same day, in the night hours, the police constable entered to his house and he has assaulted his wife, the second respondent, complaint number 1, and kicked on the abdomen. In respect to that, she lodged the complaint on 7/3/2023.
Yes, incident on
4/3. She allegedly lodged the complaint on 7/3/2023.
Yes.
And the third respondent, second complaint, has lodged the complaint on 8/3/2020, sorry, 7/3/2023, my lord. Thereafter, since no complaint is entertained by the police,
So no FIR was registered.
no FIR was registered.
They have lodged the complaint with which police?
Somarpet police. Thereafter, they have approached the superintendent of police and matter is referred to CDPO. before the CDPO, there was some talks between the both parties.
He is also working in Somarpet police station.
No, my lord, he is in a reserve police department. There was some proceedings on 8/3/2023 before the CDPO, my lord. And matter was closed. Before that, I will try to bring to your lordship notice that, my lord, on 4/3/2023. Before that, I will try to bring to your lordship notice that the wife of the petitioner is also co-teacher in the very same school where the third respondent and second respondent are working. And there was allegation that there was extramarital relationship between the third respondent, the second complainant, and the wife of the petitioner.
Who alleges that?
That's the allegation of the complaint, and there was the complaint and everything. And
Whether it is stated in the complaint.
yes, they have stated that's the allegation. They have stated.
ಎಲ್ಲಿದೆ?
ಅದು ಬರುತ್ತೆ ಅದಕ್ಕಿಂತ ಮೊದಲು I will submitting one FIR on 4/3.
Whether the complainants have made such allegations.
Yes, yes, my lord. That's the allegation. In page number 15. The complaint submits that the complaint number 2 and wife of the accused are working in OLV Convent, Somarpet. The accused have a doubt about the chastity of his wife and also illegal cohabit with the complaint number 2. The accused has suspicious towards his wife and complaint number 2. He has built up his mind aggressively against innocent complaint number 2. And on 8/3/2021, that's 2 years prior, at about 12:15 noon, the accused along with his 2 friends attacked on the complaint number 2.
ಆಯ್ತು.
That's the allegation. But on 4/3/2000,
ಅಂದ್ರೆ that was the, you are having the doubt against your wife
Wife.
and the complainant number.
yes, in respect to that, my lord, on the date of incident, that's on 4/3/2023, after completion of this tournament, there was a dinner in the one hall, my lord, where the accused and complainant met, and the second complaint has assaulted on this petitioner, and petitioner has lodged the complaint on the very same day. May pass on the FIR, my lord. It is registered in crime number 32/2023, my lord.
Of which police station?
Very same Somarpet police station. Yes, lodged complaint on the very same day. That's on incident has taken place at around 11 PM in the night on 4/3/2023. He has lodged the complaint on 5/3/2023, wherein he has clearly stated that, my lord, ದಿನಾಂಕ 5/3/2023 ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನೀಡಿದ ಪುಕಾರಿನ ಸಾರಾಂಶವೇನೆಂದರೆ, ನಾನು 27 ವರ್ಷಗಳಿಂದ ಪೊಲೀಸ್ ಇಲಾಖೆಯಲ್ಲಿದ್ದು ARSI ಆಗಿ ಕರ್ತವ್ಯ ಮಾಡಿಕೊಂಡಿದ್ದು, 2 ವರ್ಷಗಳಿಂದ ERSS ವಾಹನದಲ್ಲಿ ಚಾಲಕನಾಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದು, ಈ ದಿನ 4/3/2023 ನನಗೆ ಕರ್ತವ್ಯಕ್ಕೆ ಬಿಡುವಿದ್ದುದರಿಂದ ಸೋಮಾರ್ಪೇಟೆ ಜೂನಿಯರ್ ಕಾಲೇಜು ನಲ್ಲಿ ಕಬಡ್ಡಿ ಪಂದ್ಯಾಟವನ್ನು ನೋಡಲು ನಾನು ಮತ್ತು ನಮ್ಮ ಗ್ರಾಮದ ವಾಸಿಯಾದ ನರಸಿಂಹನವರಿಗೆ ಪಂದ್ಯವನ್ನು ವೀಕ್ಷಿಸಿ 11 PM ಸೋಮವಾರಪೇಟೆ ಜಾನಕಿ ಕನ್ವೆನ್ಷನ್ ಹಾಲ್ನಲ್ಲಿ ಊಟಕ್ಕೆ ಹೋದ ಸಮಯದಲ್ಲಿ ಈ ಹಿಂದೆ ನನ್ನ ಹೆಂಡತಿ ತೀರ್ಥರವರೊಂದಿಗೆ OLV ಶಾಲೆಯ ದೈಹಿಕ ಶಿಕ್ಷಕ ಮೋಹನ್ ಸಲುಗೆ ಸಂಬಂಧವನ್ನು ಇಟ್ಟುಕೊಂಡಿದ್ದ ವಿಚಾರವನ್ನು ತಿಳಿದು ತೀರ್ಥರವರನ್ನು ಕೆಲಸದಿಂದ ಬಿಡಿಸಿ ಈಗ ಮನೆಯಲ್ಲಿರುವುದಾಗಿದೆ. ನಾನು ಜಾನಕಿ ಕನ್ವೆನ್ಷನ್ ಹಾಲ್ನಲ್ಲಿ ಊಟ ಮಾಡುತ್ತಿದ್ದ ಸಮಯದಲ್ಲಿ ಎದುರಿಗೆ ಸಿಕ್ಕ ಮೋಹನ್ ರವರಿಗೆ ನನ್ನ ಹೆಂಡತಿ ತೀರ್ಥರ ಸಲುಗೆ ಸಂಬಂಧವನ್ನು ಬೆಳೆಸಿ ನನ್ನ ಸಾಂಸಾರಿಕ ಜೀವನವನ್ನು ಹಾಳು ಮಾಡಿದೆಯಾ ಎಂದು ಹೇಳ್ತಿರುವಾಗೆ ಏಕಾಏಕಿ ಅಲ್ಲಿಯೇ ಇದ್ದ ಪ್ಲಾಸ್ಟಿಕ್ ಚೇರ್ನಿಂದ ನನ್ನ ಮುಖದ ಮೂಗಿನ ಭಾಗಕ್ಕೆ ಹೊಡೆದು ಗಾಯ ನೋವು ಪಡಿಸಿ ಆ ಸಮಯದಲ್ಲಿ ನನ್ನೊಂದಿಗಿದ್ದ ನರಸಿಂಹ ಮತ್ತು ನಮ್ಮ ಊರಿನ ಕೆಲವರು ತಡೆದು ಸಮಾಧಾನ ಮಾಡಿರುತ್ತಾರೆ. ನನಗೆ ಹಲ್ಲೆ ಮಾಡಿದ ಮೋಹನ್ ರವರ ಮೇಲೆ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ನೀಡಿದ ಲಿಖಿತ ಪುಕಾರಿನ ಮೇರೆಗೆ ಪ್ರಥಮ ವರ್ತಮಾನ ವರದಿ. On the very same day, the petitioner has lodged the complaint. To counter blast, they have lodged complaint alleging that 2 years prior, that's on 8/3/2021, there was some attack on the second complainant, and 4/3/2021 attack on the wife. By making such allegation, they have filed the private complaint before the trial court, my lord. And the respondent number 2 and 3 have
given their sworn statement, after recording the sworn statement, my lord, the trial court has taken the cognizance for the offence under section 354 D, B and other offences, my lord. In the sworn statement, my lord, the first complaint has stated that on the date of incident, there was a galata in the Somerpet Junior College ಮೈದಾನದಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ.
One
But-
minute. Yes, what do you say?
My lord, one statement, my lord, the PW2, my lord, that is the complainant, of the complainant, my lord. She has narrated the incident, my lord.
No, why there is such a delay lodging the complaint?
Lord, they say that, my lord, they went to Mahila Ayoga, ಅದನ್ನು ಕರ್ಸಿದ್ರು, ಅಲ್ಲಿಗೆಲ್ಲ ಹೋಗಿ there was some settlement.
Maybe first attempt to file the complaint was on 7/3/2023.
Yes, ma'am.
Date of incident is 4/3/2023. The petitioner has
My
lodged the
lord, the
complaint
last
on the same
incident
day.
is 4/3/2023, my lord. After that, my lord, on 7/3/2023, my lord, they were filed by the Women Commission, my lord. And there, my lord, he accepted that, my lord, he has done all these things, my lord, and
No, if he has illegally trespassed into the house and committed all these offense,
yes,
immediately he could have lodged the complaint. Why he used to wait for so many days? Instead of going to the police station, why they have gone to the women, commission?
the complaint, my lord, they say that, my lord, they went to the police station, but the police, as the petitioner is also a policeman, my lord, they did not entertain those complaints.
No, even the complaint to the police, superintendent of police was on
Eight,
8/3.
eight,
Why 4 days delay? That too when the complaint, the petitioner has already registered a complaint.
that is not been explained in the.
Is it not fatal? Conditional order. Petitioner, being the sole accused, is seeking grant of anticipatory bail on the apprehension of being arrested. Petitioner is said to be working as police constable in a reserve police. Respondent number 2 and 3 have filed the private complaint in PCR 73 of 2023. Cognizance was taken in the respondent number 1 was directed to register the FIR. Accordingly, the FIR was registered for the opposite offences and investigation was undertaken. It is stated that the incident explained by the complainant was occurred on 4/3/2023 when a kabaddi tournament was organized in Somarpet. It is pertinent to note that on 4/3/2023 itself, the petitioner as informant got the first information against respondent number 2, alleging commission of the offence punishable under section 324 of IPC. The FIR in crime number 32 of 2023 was came to be registered on the same day at 1 p.m. But strangely, even according to the complainants, they have not filed any complaint on that day or in 1 or 2 days. But they went to the police station only on 7/3/2020 to lodge the complaint. The same was not received when the same was not received by the police. They complained to the superintendent of police on 8/3/2020. I do not find any reasonable explanation for this inordinate delay in lodging the complaint. Since the petitioner is said to be the police constable, he is working as a police constable. His abscondence, his chance of abscondence is not It cannot be said that he will abscond. Therefore, I am of the opinion that reasonable conditions may be imposed while granting anticipatory bail, which will take care of subvention. Allowed subject to conditions.
Serial number 29, Basuraju TA.
Here for petitioner, my lord. Lord 439 petition. There are two accused. This petitioner is accused number 1. Accused number 2 is died at the jail. The case against him is abated. Proceedings are going on against this petitioners only.
Now, what is the stage?
My lordship, one witness CW1 is examined. Lordship, she was arrested on 29/9/2022. My lordship, earlier during 2022, my lordship approached this honorable court, rejected the bail application. This is the second application, my
1
lordship.
minute. Deceased is the husband, your husband.
Not husband, my having illicit relationship is the allegation.
Deceased.
Deceased also, and also with accused number 2.
Already on merits, it was dismissed.
Merits
Earlier
were
petition.
dismissed. Some misinformation, please, your honorship. In para page number 4 ali, this middle portion, please, the blood stained saree and petticoat were also recovered at the instance of this petitioner. And the FSL report confirms such blood stains. Lordship, FSL report, my lordship, I placed page number 63 in the petition. 65 is the opinion. My lordship, petticoat and the saree. Item number 11 and 12. 65, my lord. 11 and 12. Saree and petticoat. 65. Result examination number 2. Presence of blood stains were not detected in item number 11. 11, it is in the second. Lordship, 12, sixth opinion. Blood stains in item number 12 were insufficient for serological analysis.
But there was blood stain.
Blood stain, but blood stain was belongs to the B group of the deceased is not found. And one important. This is one. My lordship, second one. Lordship, last scene CW2. My lordship, it's very important to be noticed. Some unnatural conduct, my lordship, is has placed. Page number 45. Nagabhushana. Nagabhushana.
You know,
my lordship, after the death, he went to the spot. He had last seen the witness. He last seen the accused accompanying the deceased. At the time of he is visiting to the place of incident, seen the dead body, police were all conducting the smart measure all verification. He never whispered about the incident. He has seen that those accused is also accompanying along with him. Police ಅವರಿಗೆ ಆ ದಿನ ಏಕೆ ಹೇಳಲಿಲ್ಲ ಎಂದು ಕೇಳಿದರು. ಪೇಜ್ ನಂಬರ್ 45 ಮಿಡ್ಲ್ ಪೋರ್ಷನ್. ಅದಕ್ಕೆ ನಾನು ಭಯವಾಯಿತು ಎಂದು ಹೇಳಿದೆ.
ಏನದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ CW3 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು, ನಾಟ್ ಓನ್ಲಿ CW3, CW2,
All
4, 10, 11.
ಆಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇಸ್ ಲೈಕ್ ದಟ್ ಓನ್ಲಿ. ಪೇಜ್ ನಂಬರ್ 46 ಅಲ್ಲಿ ಅವತ್ತು ಆ ದಿವಸ ಪೊಲೀಸರು ನಮ್ಮೂರು ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ವಿಚಾರ ಮಾಡುತ್ತಿದ್ದರು. ಆಗ ಪೊಲೀಸ್ ಅವರಿಗೆ ಸತ್ತು ಹೋಗಿರುವ ದಿನ ಮುದುಕ ಬಸ್ಸಿನಲ್ಲಿ ಒಂದು ಹೆಂಗಸಿನ ಜೊತೆ ಇಳಿದು Lordship, he had not informed the same to the at the time of visiting and at this spot. This is the last scene. And Your Honor, and also, and another important thing, please, Your Honor, the delay in recording these witnesses' statement, Your Honorship, and also very importantly, these last scene witnesses are unknown to the accused and another accused, two accused. Investigation officer, no step has taken. Very importantly, tested identification period must and should be conducted.
Why tested identification period?
Tested identification period is very important because Lordship, last scene witnesses are not aware to the accused.
Sir, tested, the
known.
purpose of test identification is entirely different.
Test the identification of the accused persons who are involved in the offences. That is not
No
done, please.
eyewitnesses?
No eyewitnesses.
No eyewitness to the
Direct
incident? What are the circumstances?
That is, my lord, that is the last scene, my lord.
Hmm.
My lord, the CW3.
FIR was against unknown person.
Yes, my lord.
Yes,
ಎಲ್ಲಿದೆ FIR?
page number 9, my lord.
Unknown person. No. Then no TAP.
No TIP is done, my lord, but they were identified, my lord. CW3.
Unknown ಇದ್ದಾಗ?
TIP ಮಾಡಲಿಲ್ಲ.
Then
After the arrest, my lord, they were identified by CW3, my lord. And the recovery, my lord, the recovery of the mobile cap and battery of the deceased, my lord, where the IMEI number is shown, my lord. That shows that that battery is of the deceased mobile only, my lord. And my lord, that were recovered at the of accused number 1 and 2, my lord. They have shown the place, my lord, where that was recovered.
It is giant recovery.
And
then this blood-stained petticoat was also recovered.
yes, my lord.
Now virtually the circumstance is only recovery of the mobile and blood-stained petticoat. How many witnesses are there?
40 witnesses total. Nearly 2 years he is in jail.
Conditional order. Petitioner being accused number 1 is seeking grant of bail. He was apprehended on 29/9/2022. Since then, he is in judicial custody. Initially, the petitioner had approached this court by filing criminal petition number 11209 of 2022, seeking grant of bail. The same was came to be dismissed. Now the investigation is completed, charge sheet is filed. It is stated that CW1 is already examined before the trial court. Prosecution is relying on the evidence of 40 witnesses. Next, FIR was came to be registered against unknown persons. Admittedly, no test identification period was conducted by the investigating officer for the reasons best known to me. It is stated that CW 2 to 4, 10 and 11 are said to be the witnesses who have last seen the deceased in the company of the petitioner just before the incident. But no test identification period was conducted as although. It is stated that these witnesses have identified the accused in the police station. The other circumstances on which the prosecution is relying on is recovery of the mobile handset of the deceased and the blood-stained petticoat at the instance of accused number 1 and 2. the conclusion of the trial in the matter may take sufficiently long period of time. Since there are no eyewitnesses to the incident and the prosecution is relying on only the strong circumstance of recovering the mobile handset and the bloodstained petticoat at the instance of this petition, along with the accused. I am of the opinion that the petitioner may be enlarged on bail subject to conditions, which will take care of such, as otherwise his detention in custody would amount to pre-trial punishment. Accordingly, I answer the above point. Is allowed subject to conditions. Like that.